there's probable cause.
La Corte encuentra motivo fundado.
Your Honor, just for a brief housekeeping matter, can we establish that the public defender is appointed on every case?
Yeah,
unless-
I thought we did, yeah. So the public defender will be appointed on every case unless there's any private counsel.
Understood.
Como
No, no.
cuestión preliminar, en todos los casos se nombra el abogado de oficio, a menos que se indique que tengan un abogado contratado privadamente.
Your Honor, the defendant has no priors. The state's request is $1,000 in stay away order.
Señoría, la demandada no tiene antecedentes. Solicitamos $1,000 de fianza y una orden de alejamiento.
Your Honor, specifically for that reason, since there is no priors, the defense is going to be asking for a release on their own recognizance.
Precisamente por esa razón, su señoría, porque ella no tiene antecedentes, solicitamos que le den libertad bajo palabra.
No, this is a serious accusation, and this is also alleged. This also was in front of a minor child. I'm not gonna RR her. I find probable cause, and I will grant her the standard bond of 1,000 with a stay away order.
Your Honor, would you?
Ya
My apologies, Ms. Interpreter. You can go.
Thank you. Ya que este es un delito serio y además ocurrió frente a un menor de edad, voy a imponer la fianza estándar de $1,000 y una orden de alejamiento.
Your Honor, at this time, then we were also asking for pretrial services then in exchange for, not granting the RWR. She does have another reference and another address that she can remain at.
Su señoría, entonces solicitamos que en lugar le imponga servicios antes de juicio, que es un programa que se llama PTS, por las siglas en inglés, o alternativamente $1,000 de fianza, ya que ella tiene a personas donde ella puede quedarse temporalmente.
I'm gonna keep it at $1,000 bond and stay away order.
Lo voy a mantener en $1,000 de fianza y orden de alejamiento.
I can't hear you, Joe. You said 1,000?
Yes, 1,000. And ma'am, do you reside with Francisco, the alleged victim in this case?
Señora, ¿usted vive con Francisco, la presunta víctima del caso? Responda.
Sí.
Yes.
Okay, so you're not to engage in any criminal activity, do not use or possess any illegal drugs. If you have any firearms, you're immediately required to turn them over to the police department. You're to have no, interpreter.
Bien, señora, por favor, usted no puede tiene que mantenerse alejado de la víctima en todo momento. No puede participar en ninguna actividad criminal. Si tiene algún arma, debe entregarla inmediatamente a la estación de policía.
You are to have no contact with Francisco Marcos, indirectly, directly through a third person, in writing, by telephone. You are to stay 500 feet away from the victim's house, place of appointment, and her school at all times. Do you understand?
And what is his last name, Your Honor?
It says here Marcos.
Ok. Bien, señora, usted no puede tener ningún tipo de contacto con Francisco Marcos, sea directa o indirectamente, por escrito, por teléfono, a través de terceras personas, a través de medios sociales, ningún medio electrónico, y permanecer alejada de él en todo momento. De donde viva, donde trabaje, donde vaya a la escuela, en todo sitio. ¿Entiende?
Ma'am, you are permitted to go back to the resident one time with a police officer within 48 hours to obtain your personal belongings, any medicine or anything you have, but you must go back with a police officer within 48 hours.
Your Honor,
Se le permitirá ir a la residencia donde vive la víctima una vez solamente, acompañada de la policía. Será hecho en 48 horas tras haber sido liberada, más tiene que ir con la policía para recoger sus pertenencias personales, medicamentos o cosas que tenga.
Your Honor, at this time, the defense is going to ask if we can just remove the $1,000 bond and put Ms. Pineda on house arrest level 3 roaming. That way she can go and attend to everything that she needs to do, get her belongings. Ms. Pineda is 21, and she, she does have things to attend to. She has ties to the community. She's not a flight risk. She has no priors whatsoever. This is her only interaction with the criminal justice system. So for that reason, we feel that the $1,000 bond is tantamount to no bond. So we're just asking that Ms. Pineda get house arrest level 3 to at least to continue on with her affairs, her job, and everything else she needs to do, and also to go get the belongings. And as we've already established, she does have her mother. She has another address that she can return to, and that's why we're going to ask in exchange for removing the $1,000 bond, just house arrest level 3.
Su señoría, debo insistir en que no le impongan una fianza de $1,000. Solicitamos que le den arresto domiciliario nivel 3, ya que ella tiene 21 años, como habían dicho, no tiene antecedentes y además ella tiene que atender sus cosas diarias, tiene lazos con la comunidad, no es un riesgo de que se escape. Además, ella tiene que encargarse de sus cosas, de su trabajo, tiene a su mamá y donde hay otra dirección donde ella puede quedarse y no es una amenaza a la comunidad.
Steve, do you want to briefly respond to Defender's request?
Si el Estado quiere responder a esa solicitud.
The standard bond in this case is $1,000 in a stay away order. That is not an extremely high bond that would be tantamount to no bond. That is the standard bond in domestic violence battery cases.
Los $1,000 de fianza son la cantidad estándar y la orden de alejamiento, por lo tanto, no es como si fuera no fianza o equivalente a no fianza.
Are we done with Ms. Pineda, Judge?
Okay, so at this time, we're going to leave it at the standard $1,000 bond and a stay away order. Thank you.
En este momento lo dejamos en $1,000 de fianza y orden de alejamiento. Gracias.
One second. Oh, recognize. Asking. So I just click host. Sorry, hold on one second. I'm trying to let some attorneys in. IT, are you there?
I am there.
So there's some people on the webinar chat that are here for certain cases and they're asking to be promoted. They're asking if they could be promoted. I'm not sure exactly how to do that.
No one has indicated that they're.
Someone says they're here on behalf of, they're hired for Miss Marta Reyes, which is a DV charge. Do you handle this to let them in?
Here from there. Okay.
So you'll let them in? Okay, thank you so much. Okay. So the next case I have is Stephanie Nicole.
There you
Okay.
go.
You've been charged with one count of battery. I'm going to go ahead and read your arrest affidavit to determine if there's probable cause. And public defender, please let me know if you have any PC arguments at this time.
Yes, Your Honor.
However, they are immediately do the police request.
Okay. Okay, thank you. Do you have any arguments at this time?
Yes, Your Honor. The defense is going to argue that there's no probable cause for the battery, specifically no reasonable person could believe that it's more likely than not that Mrs. Corsino had committed the alleged battery due to the fact that it's explained heavily throughout the A form that Mrs. Corsino's girlfriend was trying to help her, and she was intoxicated, so she was falling, slipping, and that's how the scratches would have occurred on the alleged victim in this case. And for that reason, nobody or no reasonable person could find that it's more likely not that those scratches and those bruises were specifically done due to a battery, but rather through the assistance and helping Mrs. Corsino throughout the night.
Eight.
The victim's statements to officers that the defendant became physically aggressive towards her and started grabbing, along with the injuries observed by officers themselves, is enough to establish probable cause for battery in this case. The defendant has priors. The state's request is $1,000 and a stay away order.
Your Honor, at this time, my apologies.
No, you can go ahead.
Your Honor, at this time, the defense is going to be asking that Mrs. Corsino be released on her own recognizance. Once again, she has absolutely no priors. She has no interactions with the criminal justice system. There's no reason to believe that she's a flight risk. There's no reason to believe that she wouldn't appear for court. There's no reason to believe that anything else or danger to the community. So for that reason, we're asking that Ms. Corsino be released on her own recognizance at this point in time.
So the court finds probable cause. And I'm going to issue a stay away order. So you and the victim reside together? No, ma'am. Okay. So the stay away, you're not to engage in any criminal activities, do not use or possess any illegal drugs. You're immediately to surrender any firearms if you have to the local police station. You are prohibited from any contact directly or indirectly with Monica Deblee, including contact in writing, by telephone, through social media, through a third person. You must stay at least 500 feet away from the victim's home, place of employment, or school at all times. Do you understand?
Yes, ma'am.
And you do not need to return to the, so you guys don't reside together, so you don't need to get anything. And
Is Your Honor rejecting the releasing Ms. Corsino on her own recognizance at this time?
yeah, I'm not gonna R her no at this time.
Bond 1,000.
On 1,000.
Next offender, Ms. Reyes.
Ms. Reyes,
Here you are.
Yes, ma'am.
you've
Your
been,
Honor, I'm sorry.
you've been charged with one count of battery. I'm gonna read your arrest affidavit to determine if there's probable cause. And public defender, please let me know if you have any PCR arguments at this time.
Yes, Your Honor.
You have any arguments?
Yes, Your Honor. At this time, the defense is going to argue that there's no probable cause due to the multiple statements throughout the A form that witnesses saw both of them having a sudden tussle from both parties. And also they stated that the offender stated that she was not sure who struck first. So there's just a lack of probable cause to establish whether or not Mrs. Reyes was acting in self-defense in this case. So for that reason, there is no probable cause. A reasonable person couldn't find that it's more likely than not with the A form writing that multiple people said that they did not know who started the altercation, that Mrs. Pineda is the one who even initiated this alleged crime. And for that reason, there's no probable cause, and we're asking that Ms. Pineda be released outright.
There is enough probable cause due to the victim's statements to officers that the defendant struck her about the left side of the face with an open right hand. The fact that the defendant said she wasn't sure who struck who first does not get rid of the probable cause to believe the battery occurred.
Your Honor, throughout the A form, there is multiple statements made that there was other witnesses. Obviously, the alleged victim is referring that she was struck. That's why Ms. Pineda was arrested. I mean, Mrs. Reyes, I'm sorry, was arrested. But for other purposes, throughout this A form, there's witnesses saying that, they do not know who started it first. They were not able to determine who started it first. And Mrs. Reyes is even saying that, the alleged victim in this case could have started it first. So for that reason, there is no probable cause to establish that Mrs. Reyes was the one who committed this alleged crime. So for that reason, we're asking that Ms. Reyes be released outright.
Your Honor, there's no witnesses listed on the arrest form, and the only statements are from the victim and the defendant.
And I don't believe there's, me to change anything. I don't believe there's any victims here present to say otherwise.
I'm sorry, what, Your Honor?
I said, there's no victim here to, testify otherwise that, so I'm not, there's nobody here to testify that, she's not scared of her or to that nature. So I'm gonna go ahead and give her the standard bond of 1,000. The stay away order. Probable cause was found. Ma'am, you're not to engage in any criminal activity. You're not to use or possess any illegal drugs. If you have any firearms, you must immediately surrender them to the local police department. You're not to have any contact with Jocelyn Figueroa indirectly, directly, by telephone, through third party, telephone, any electronic means. You're to stay 500 feet away from the victim's home, place of employment, and school at all times. Do you understand, ma'am?
Yes, Your Honor.
All right, thank you.
Thank you.
Hello, Your Honor.
Hello, Angelica. I'm gonna ask, IT, are you there? If there's a witness that wants to testify, you'll let them in when the case gets called, or I need to be looking, because I know in one of the cases there is, it hasn't been called yet, but they want to be heard. They're writing on it. Will you let them in at that time?
Figure out who's here, yeah, of course.
Okay,
The thing is, there's an iPhone. I never let an iPhone. They're very risky. There's 3 people currently logged in his iPhone. I don't know which iPhone this is.
okay. In one of the cases, Hayes, that's gonna be coming up soon. I think she wants to be heard on this case, but I haven't read her comments. I'll let you know when it gets called. Okay. Are you Lisette and Angelica?
Yes, Your Honor.
Okay. Okay, you've been charged with 1 count of battery. I'm gonna read the A form to determine if there's probable cause. You have any? Please see arguments.
Yes, Your Honor. Based off the four corners of the A form, no reasonable person would believe that's more likely than not that Mrs. Carmona did not act in self-defense, as is stated at the beginning of the A form. It is saying that it says that obviously the other individual who was involved in this case, the alleged victim, mentioned that she was belittled and explicit, I guess, insults were made toward Mrs. Carmona, and then Mrs. Carmona reacted. A reasonable person would not believe that it's more likely not that Mrs. Carmona did not act in self-defense in this case. And for that reason, we believe that there's no probable cause to establish that this was not Ms. Carmona acting in self-defense.
I just want to make sure I understand the public defender's argument here, that because the defendant was insulted, she was allowed to hit him. If that is the case, if that is the argument, my response is that just because someone says something to you, that does not give you permission to batter them. The victim herself stated that the defendant herself stated that she swung at the victim with her right hand, balled in a fist, connected with the back right side of the victim's head. That is a battery. Additionally, the defendant has no priors and state requests $1,000 in a stay away order.
Your Honor, at this time, the defense obviously is going to be asking for Ms. Carmona to be released on her recognizance due to the fact that she has no priors and no interactions with the criminal justice system at this point in time.
Court does find probable cause. I'm gonna go ahead and issue the standard $1,000 bond with a stay away order.
1,000?
1,000. Ma'am, you're not to engage in any criminal activity. Do not use or possess any illegal drugs. If you have any firearms, you must surrender them immediately to the nearest police department. You are to have no contact directly, indirectly with Victor, sorry if I pronounce this incorrectly, Almanzar, including by telephone, social media, third parties. You are to stay at least 500 feet away from the victim's home, place of employment, school at all times. Did you and the victim reside together?
No, ma'am.
The next case I have is Brittany Strokes.
Yes, Your Honor.
You've been charged with 1 count of battery. I'm gonna go ahead and read your A form.
Your Honor, at this time, the defense is going to argue that there's no probable cause to establish an alleged battery in this case, specifically on the four corners of the A form. It doesn't mention that anywhere, actually, that the alleged victim in this case was attempting to be drowned, as it's stated, as far as the alleged victim claimed that he was trying to be drowned, but it makes no mention there was touching, striking. It doesn't even mention on the A form whether or not that the alleged victim had any evidence that he was even wet for purposes of the alleged battery in this case. So for that reason, no reasonable person can find that's more likely or not based on what was written in the A form that in a battery in the manner in which it's stated in the A form was conducted.
There is probable cause for battery. The defendant herself stated that she poured juice on the victim while he was asleep. That along with the victim's statements that the defendant, he was asleep and awoke when the defendant tried to drown him, shows that he did not want her to do that. That is an unwanted touch or cause the juice to touch him, which is a battery. She has no priors and the state's request is $1,000 in a stay away order.
Okay.
Straight bond 1,000.
No, I'm gonna reduce the bond here. I'm gonna reduce the bond to 500. If I'm probable cause, I'm gonna reduce the bond to 500 in this case. And I'm gonna issue a stay away order. Do not engage in any criminal activity. Do not use illegal drugs. If you have any firearms, you must surrender them to the nearest police department. You are to stay away from Macklin Jackson at all times. No contact through social media, writing directly, indirectly. You're stay 500 feet from the victim's home, victim's place of employment, and her school at all times. Do you understand?
Yes.
And you and the victim do not reside together. Is that correct?
She's asking if you guys reside together.
Yes, we do.
You do?
Mhm.
Okay, so I'm gonna let you go, one time, within 48 hours with a police officer to get your personal clothing, medication, anything that you have at the house, within 40 hours with a police officer.
It's at the hotel.
Understood, Your Honor.
Okay, and I did reduce the bond to 500.
Thank you, Your Honor.
Thank you. The next case I have is Elena Hayes. Are you Miss Hayes?
Yes.
Hold on, I believe you have someone here on your behalf. On your behalf, can you let in, I believe your sister is on.
Shakia Hayes.
You've been, charged with one kind of battery touch strike. I'm gonna go ahead and read your A form to see if there's probable cause while we figure out, because I believe your sister's on the Zoom.
Okay.
No priors.
She's unmuted on Zoom, but
Am I on mute?
there.
Okay, can I see, are you just talking, can I see you, or is it just you called in?
No, I'm on the Zoom. I'm not sure how to allow video access. It says it's on auto. So how do I show you? Because I see meeting settings and rendering method listed as auto. Let me see. You're being video is not an option. Can you hear me? Hello? Hmm.
Do you guys want to pass to her? I don't see her.
Ms. Shaki Hayes, were you able to go to your settings and access the video?
She wrote a whole, wrote in the whole panel. That's her sister, and she's asking, like, we have to see her. Yeah, she's asking, I can,
Motion, stay away order.
do you, are you still there? What is your sister's name again?
It's Shakia.
Shakia, are you still there?
Yes, Your Honor. We could just briefly pass it so Ms. Shaki can just get her camera working.
Yeah, okay, I'll just pass it because okay, I'll go ahead and pass it.
Thank you so much.
Okay, so we'll pass her and so she's able to come back. So the next case that I have is Kendra Jimson.
Yes, Your Honor. He hasn't been brought in yet.
Sorry?
I don't think he's been brought in yet.
Okay. Do you want me to, go to the next one?
No, no, no.
Okay.
I believe the correction's bringing him in right now.
Oh. Oh, I got muted. I don't have a video camera, just so you know, Judge. Is that going to prohibit me being able to express myself? Because I've called in as well on the Zoom link and it's just automatically muting me. I'm
Yeah,
totally satisfied with you hearing my voice and me expressing that I don't.
I understand, but unfortunately, like, I need to have at least your ID to know that it's really who you say you are.
She's out here. She's a single.
Right, but I need to see your face or have a form of identification to know that you are who you're saying you are.
Oh, the lady who called me this morning to
Ms. Hayes, you're kind of coming in and out, but if you can get on some sort of computer or something with a camera, that would enable us to just see your ID, and that way we can hear what you
Yeah,
have to
if
say.
you have your ID, I'm sufficient with that. I just need your ID or something to, if you're able to use a computer, we're gonna pass the case right now until you're able to figure that out, so I can give you that chance. If you can maybe use someone's phone or somehow so you can use a camera so I can get your ID. We're figuring that, let me go on to the next case. Kendra, Jimson, is that you, sir?
Yes, ma'am.
You have been, charged with 1 count of battery. I'm gonna review the affidavit to determine if there's probable cause. Okay, the court finds probable cause at this time. Do you have a PC argument?
No, Your Honor, at this time, we're just arguing they don't reside together, so he has a separate address and a reference. We're just asking that Mr. Jimson be put on pretrial services and allowed to, be released on pretrial services.
On the first sentence of the A form, it says that they're boyfriend and girlfriend who reside together as a family. The first,
I understand. I confirmed with client that they do not reside together. That was a misstatement by the police officer.
but if she's not here to testify, I mean, I can't, that's what the arrest affidavit form says, that they reside together as a family. State?
The defendant has priors, but no domestic violence priors. He has a felony from 2011, stolen property, grand theft, and, two felonies from 2011, 1 stolen property, which was consolidated with the other case, then grand theft, 2 counts, convicted, then felony from 2009, driving with suspended license, convicted, and probation violation. Misdemeanor from 2007, resisting officer without violence, adjudication was withheld. Felony from 2007, burglary of an unoccupied structure, possession of burglary tools, grand theft, no action. Felony 2018, burglary of unoccupied conveyance and grand theft, convicted. And felony of 2009, driving with license suspended, resisting officer without violence, convicted. Probation violation where probation was revoked. Felony 2009, grand theft of a vehicle, and another probation violation. He was convicted of the grand theft. For that reason, the state requests $1,000 and a stay away order from the victim, Brianna Clark. And it can be for him. The stay away order just prevents him from going near the victim or where she lives. If he can go to a place where she doesn't live, that's a non-issue. So regardless, the stay away order just protects her and where she lives.
Correct. Yes, I'm gonna grant the standard bond, and he also has several priors, so it's gonna be $1,000 bond. I find probable cause with a stay away orders. Sir, you're not to engage in any criminal activity. Do not use any illegal drugs. If you have any firearms, you must surrender them to the nearest police department. You're to have no contact, directly, with Brianna Clark, including in writing, telephone, through a social media. You are to stay 500 feet at all times away from the victim's home, employment, or school. Do you understand?
Yes, ma'am.
Okay, and you said that you reside at different locations, so there's no need for you to go back to the property to retrieve any personal belongings?
That's my property. Well, the address that's there. I live there. She don't.
Are you referring to the address, Northwest 103rd Street and Northwest 25th Avenue?
No, that's not that.
Oh, sorry, is it 16440 Northwest 19th Avenue?
Yeah, correct.
Well, looking at the form, it says that your boyfriend and girlfriend reside together as a family.
You're on a straight bond, $1,000?
I'm sorry?
It was $1,000 bond?
Yes, it is $1,000 probable cause, but in terms of his getting his belongings, based on the A form, it says you guys reside together. You guys can at a later time figure this out, but I'm gonna let you go to that property one time within 48 hours to get your personal belongings. If she's not there, you have to stay 500 feet away from the victim. So if she doesn't reside with you, then it's a irrelevant point.
Yes, Your Honor. We're just asking that this not stay away from the actual location as that's his residence and just from the alleged victim in this case, so that way he's able to return back to that property as it's his, as long as she's just not there.
Okay. If she lives there, I'm gonna make this clear for the record. If she lives there with you and you claim it's your property, you cannot go there. If she's there, so wanting to see you, you cannot go to the property. You claim she doesn't live there. So if she's there, you'll be in violation of this. Do you understand, sir?
Yes, Your Honor.
Okay, so you can go back if that's your property, you live there, as long as you're 500 feet at all times from Brianna Clark.
Yes, ma'am.
Okay. And standard bond 1,000.
That's it. Thank you.
You're welcome. Are you Mr. Tillman?
Yes.
You've been charged with 1 count of battery touch strike. I'm gonna go ahead and read your affidavit to determine if there's probable cause. Public defender, let me know if you have any probable cause arguments. I'm gonna go ahead and read it.
Yes, Your Honor.
Okay, the court finds probable cause.
Understood, Your Honor. At this time, we're just going to ask that since Mr. Tillman has no interactions with the criminal justice system previously, as the only prior was I believe no action here, as I can see. Yeah, no action. We're just asking that he be released on his own recognizance, and that way he can return back to work and just engage in normal faculties. There's no reason to believe that he's a flight risk or a threat to the community whatsoever. We're just asking that he be released on his own recognizance.
Your Honor, the defendant's prior misdemeanor from 2024 was for domestic violence battery, and the victim in that case was the same victim as the victim in this case. Additionally, the state would request PC to be found for aggravated battery on a pregnant person. The victim and the defendant share 5 children with another on the way. The victim is currently 16 weeks pregnant. So the state would be requesting the standard bond for second-degree felony aggravated battery on a pregnant person, which is $7,500, and a stay away order.
Yes, these are serious allegations. It says, it's important to note, the victim is 16 weeks pregnant. That's a very serious being pregnant, to hit a pregnant woman. I'm going to raise the bond in this case.
And Your Honor, because of the prior battery with the same victim, state would also be requesting GPS level 3.
I'm going to raise this to standard aggravated battery on a pregnant woman is very serious. So I'm raising it to 7,500 for aggravated battery with a stay away order. And I'm going to read it to you. You're not to engage in any criminal activities. Do not use any illegal drugs. If you have any firearms, you must surrender them to the nearest police station. The defendant is prohibited from having any direct or indirect contact with the following person, DR, and I use the initials because it's a minor. You're having no contact even through social media, directly in writing. Do you understand, sir?
Oh, Your Honor, just for the record, the victim's not a minor, she just elected Mercy's Law. That's why
okay.
there's initials. Her name
I
is
see.
Denise Reagan.
Oh, I saw the date. Sorry, I read the wrong letters. Okay. You are to stay 500 feet at all times away from the victim. Do you understand, sir?
Yeah.
And do you and the victim reside together?
Yeah.
Okay, I'm gonna let you can go one time with a police officer within 48 hours to retrieve any personal belongings, items, medication, anything that you have. Do you understand?
Yeah.
Okay. And hold on 1 second. So you have your stay away order, and since it is on a pregnant woman, I'm gonna raise it to 7,500. Thank you. The next case I have is Roca Maya. Is that you, sir?
Yes, Your Honor.
Okay, you've been charged with 1 count of battery, domestic violence. I'm gonna go ahead and read your affidavit to determine if there's probable cause. Sorry about that. Okay, give me 1 second to review it, sorry. Is that the right one? Okay. Do you have an argument?
Your Honor, at this time, we're just asking, since Mr. Maya has no interaction with the criminal justice system other than this one instance, and obviously these are just allegations that are made on an A form, and Mr. Maya still preserves the right to be presumed innocent. We're just asking that he be released on his own recognizance, or at the very least be allowed to enter into pretrial services, due to the fact that this is his one and only interaction with the criminal justice system.
Dee?
Your Honor, standard bond in this case is $1,000. The state requests $1,000 and a stay away order. The defendant has no priors, but that is not a reason to release him on his own recognizance, especially not for a domestic violence crime where the legislature has set a standard bond.
Your Honor, specifically, there's a presumption that to not be held actually in pretrial, or to not be held pretrial. So for that reason, that is why we were asking for the release on your own recognizance. The things that the court takes into account when granting pretrial release is whether he's a flight risk, not just the legislator creating rules. There's certain factors that are supposed to be taken into account when pretrial release is being taken into account. And for that reason, he's not a flight risk. He lives in Miami-Dade County. He's never failed to appear. He's never had any interaction with the criminal justice system, period. So for that reason, there should be a presumption that Mr. Maya should be released on his own recognizance as he awaits trial. Just because that the legislator established that a standard bond is a standard bond, it doesn't mean that there's still not the presumption that you should be entitled to release while you await trial. Or there's a presumption of non-monetary release.
I'm gonna go ahead and reduce the bond in this case. I do find probable cause. I will reduce it to 500 with a stay away order. Do you and the victim reside together?
No,
Okay. So you're not engaged in any criminal activity, do not use any illegal drugs, do not purchase any firearms. You must immediately surrender any firearms to the nearest police department. You're to have no contact with the defendant, Vivian Morales. Do you understand, sir?
yes,
And I mean contact directly, indirectly, through a third person, social media. You're to stay 500 feet at all times away from the victim's home, place of appointment, and school. Do you understand?
Excuse me, is there a way I can get a restraining order? Because she's already tried to make contact with my parents to try to contact me when I release. And I really would like to get a restraining order on her because I don't believe that I know I can keep my.
Okay, sir, I cannot give you any legal advice, but I'm sure your public defender will explain what you need to do on your end. So I can't give you legal advice, but talk to your public defender and he will explain that process.
Yes, Your Honor. Thank you so much. Go ahead.
Okay, and I reduced the bond to 500. Thank you. So the next case I have is Stephen Welch.
I need my dog.
Are you Stephen, sir?
Yes.
I'm gonna put you up in charge with domestic violence, violation of an injunction. I'm gonna go ahead and read your affidavit for probable cause. Okay, the court finds probable cause and you also were in violation of an injunction order. Public defender, do you have any arguments at this time? Are you, if you're talking to me, you're muted.
Sorry about that, Your Honor.
No problem. I didn't hear anything.
Okay, no, understood. At this time, once again, we're just asking that Mr. Welch be released on his own recognizance. As there's an instance here where also Mr. Welch is a victim, and since it's just an injunction violation, we are asking that he just be released on his own recognizance so he's allowed to go back and work. Again, he is poked in the presumption of innocence, and there is a presumption to non-monetary release, which would allow Mr. Welch to return back to work. So we're asking that at the very least he be ROR'd or be allowed to be enrolled in pretrial services so that he can return back to work.
State?
Your Honor, the defendant has an open misdemeanor from 2026 for domestic violence battery. The victim in this case is the same victim as the prior domestic violence battery. For that reason, you're requesting $1,000 and a stay away order. Also GPS level 1, since he has already shown an inability to follow court orders, and a misdemeanor hold to address bond in the open misdemeanor, which he has violated his pretrial release conditions.
So the court has found probable cause. I'm going to do standard bond of 1,000. There's going to be a misdemeanor hold. And you did violate the injunction. So I'm going to add GPS because you're in violation of your injunction. So you're going to have GPS monitored. And want to make you and the victim do not reside together. I just want to make sure.
She's asking.
Yeah, we won't. We won't.
You are to stay 500 feet at all times away from Madeline, Drumna.
Drums.
Do you understand?
Yes.
You're to have no contact directly, indirectly through social media, third party.
Yes.
You're to stay 500 feet from her place of her home, employment, school at all times.
Yes.
You are to possess no firearms. If you have any, you must surrender them immediately.
Yes.
You're to engage in no criminal activities, possess any illegal drugs, do you understand?
Yes.
Okay. And since you're in violation of your injunction, I'm gonna order GPS monitoring.
Place a hold on the case?
Yes, and there will be a hold on the misdemeanor case.
What's the case number?
What's
M265421.
M2654
5421.
5421. And the GPS, the level 1 is the,
That would be total lockdown. Level 2.
it's the work.
Yeah. Lately they've been doing level 1 with work exception. I don't know, work only. Level 2 would be also work exception, and then level 3 is roaming.
Okay, I'm gonna give you GPS monitoring level 1, but you're allowed to work. If you work, so you'll be able to work.
Thank you.
I'm gonna note that in there. So he'll be able to, so it won't be like, it will be limited like by his working hours. I'll note that.
Your Honor, we are going to be asking for level 3 so that he can continue. The court will have complete control and understanding of where Mr. Welch is throughout the course of the day, even if he is on level 3. We see no reason for house arrest level 1 lockdown, as for it is his residence, and on top of that, he has no interactions with the criminal justice system prior to this event. So we are asking for house arrest level 3. The court would have control and know where he is at all times. With level 3, especially if the court is inclined to grant working hours, level 3 would provide pretty much the same freedom as the court, allowing for that caveat. So we're just asking for level 3 so that he can continue to.
Yeah, hold on. I'm gonna review the difference between the 2 and 3. Sorry, give me one. Yeah, give me 1 second. I'm gonna between 3 and 2. Hold on. Thank you. Thank you so much. Okay, I'll go ahead and do GPS level 3 and with the curfew from 11 to 6. So there is a curfew still imposed.
We'll drop charges.
And the standard bond of 1,000. And then, of course, you remember there's a misdemeanor hold on M265421.
So that's
Okay.
1,000 plus house arrest, correct?
Yeah, I'm gonna do level 3 with the curfew imposed. Thank you. Did you want me to suspend that or? Okay, thank you for sharing that. That was very helpful. That was very helpful. The next case I have is Eduardo Espinosa.
Yeah.
Do you need a Spanish interpreter, sir?
No, I can speak English.
Okay. Perfect. Let me go ahead. You've been charged with one count battery, domestic violence. I'm gonna go ahead and read your a form to determine if there's probable cause. Public defender, do you have any arguments?
Yes, Your Honor. At this time, we're going to argue that there is no probable cause in the four corners of the A form due to the lack of detail or any sort of clarifying explanation as to what or how Mr. Espinoza committed this alleged battery due to the fact that throughout the A form, it does mention an unknown striking method. So for that reason, we're arguing that there's no reasonable person can find that it's more likely than not that Mr. Espinoza committed this alleged battery when the A form itself doesn't even mention the type of strikes or any sort of detail as to the strikes, how it was strike, what kind of strikes, or if they're even, or I mean, how the strikes were conducted, obviously, because it just refers to as an unknown method. And then in addition, Mr. Espinoza himself was struck later on throughout the course of this interaction. So at this time, we're arguing that there is no way that a reasonable person could find that it's more likely than not due to the lack of detail and information in the A form that a reasonable person could find that Mr. Espinoza committed this alleged crime.
Kate?
There is enough to find probable cause in this case. The victim told police that the defendant hit her in the face and multiple times. The method is not needed to have probable cause to believe that the defendant intentionally hit the victim against her will. Additionally, the fact that the defendant was later punched by a person that is not the victim has no relevance to whether or not there's probable cause for what the defendant did earlier. The defendant has no priors. The state's request is $1,000 in a stay-away order.
Your Honor, it's the defense's position that obviously to establish probable cause, it would be a totality of the circumstance situation. In this case, for the A form, the officer wasn't even able to determine what type of strike, which is concerning for the A form, that no strike could be identified, that it was an unknown striking method. I feel like any officer that would ask would be able to determine what type of strike, if the alleged victim would have determined what kind of a strike she was struck with. So for that reason, that's why the defense raises a concern that this A form does not or lacks probable cause and that Mr. Espinosa should be released outright due to the fact that it would be simple to determine how a person was struck if they were struck. The officer in this case wasn't even able to determine what was the striking method, as he was only able to write no or unknown method of strike. And then again, the officer didn't write any form of, proof of or injuries or any visible injuries, scratch, bruises, hits, marks. So for that reason, we are arguing lack of probable cause.
But the A-form specifically says the defendant struck her a final time in the face. So he struck her in the face. It says in an unknown method, whether it's slapping, closed fist, it still says specifically he struck her one final time in the face. So he still struck her in the face. The method, I don't believe the method of how he struck her, the fact that he struck her, I think is sufficient to find probable cause. I find probable cause. I'm going to issue a stay away order, sir. You're not to engage in any criminal activities. You're not to use or possess any illegal drugs. Do not purchase any firearms. If you have any firearms, you must surrender them to the nearest police station immediately. Do you understand, sir?
Yeah.
You are to stay 500 feet at all times away from the victim, VR, including in person, no contact in writing, through social media, 500 feet from the victim's home, school, place of employment. Do you understand?
Yeah, understand.
Okay. I'm going to. Does he have any priors?
No priors.
I'm gonna issue a $750 bond.
How much you say?
$750. With the stay away order.
For a question.
Okay, the next case that I have is Jack Bryan. Are you, good morning, sir. Are you Jack?
Do you have two cases for Mr. Byron Jack, Judge?
Sorry, I couldn't hear that correction.
Do you have two cases for Mr. Byron Jack?
Let me see.
Cause I have
I only have one case on
so
the,
you don't have the warrant cases with, the legal case?
no, I don't have, I guess I'll be held at misdemeanor or felony calendar. I only have the I'm only
So
have the
it'll be
domestic
reset for
violence.
tomorrow, the warrant case. Don't worry about it.
All right. But yeah, we'll adjust that one. Okay, so this is, you've been charged with one count of domestic battery. I'm gonna go ahead and read your A-form to determine if there's probable cause. And corrections did just notify me that you do have another case warrant, which I guess we'll address later on when we get to the misdemeanor and the felony calendar. But let me go ahead with this A-form. Okay, the court finds probable cause.
Yes, Your Honor. At this time, we're just going to be asking if the court would be inclined to grant for Mr. Byron to be released on pretrial services. He has an address and a reference that he can return back to.
I was just informed that he's a Signal 100, so he does not qualify for pretrial services.
I'm in trouble.
Yeah, in the state.
The defendant has priors. He has a felony from 2015, domestic violence, aggravated battery on a pregnant person, no action, not same victim as this case. Felony 2015, domestic violence, felon in possession, carrying concealed firearm, resisting without violence, and probation violation, convicted. Felony from 2011, burglary, unoccupied conveyance, grand theft, criminal mischief, convicted, also probation violation, misdemeanor 2008, giving a false name after arrest, no cross, felony from 2008, fraudulent use of ID, no action, felony 2007, possession of burglary tools, loitering or prowling, no action, felony 2007, possession of coke with intent to sell or deliver, felon in possession, convicted of both of those, felony 2007, cocaine purchase, cannabis purchase, convicted of both, felony 2007, burglary of an occupied conveyance, and grand theft, no action, misdemeanor 2007, resisting without violence, dismissed, felony 2007, oh, strike that, skip that one, felony 2006, cocaine purchase, adjudication was withheld, felony 2006, cannabis, possession, and to sell or deliver, convicted, probation was revoked in that case. And so the state's request is $1,500 because of the prior domestic violence crimes and stay away order.
Okay, based on those priors and that you said he did have a previous domestic violence?
His two, the one was felony 2015 aggravated battery on a pregnant person, was no action, but that was a domestic violence arrest. And then the felony 2015, there's a domestic violence indicator. The crimes were felon in possession, carrying a concealed weapon, resisting officer without violence. He was convicted of those.
Okay,
Yeah. I'm
Yeah.
sorry, if I may briefly, all those are remote in time and also it was no action. And for that reason, we're just asked that he be issued the standard bond of $1,000 in a stay away order. All of those priors that were listed in extent was over 10 years ago. The last crime was in 2015, Your Honor. So for that reason, he should be issued the standard bond of $1,000 in a stay away order.
However, in Florida statute, I'm looking here at the statute 741-290 requires for domestic violence cases that you can look at the background information on each defendant, including prior criminal record, prior arrests for domestic and non-domestic crimes, and the existence of any domestic injunctions filed against you. So it doesn't have to be convictions. The statute specifically says you can consider prior arrests, not convictions. For this case, based on his priors, I'm going to do an elevated bond of $7,500. He has an extensive criminal history and he has a domestic violence.
Your Honor, we would just ask for the standard $1,500 bond that the state was even asking for in this case. All of those priors are remote in time. They're over 10 years ago. The last one and the most recent being 2015.
And haven't been in trouble since.
State?
My request would be $1,500 because it's the domestic violence priors and stay away order, but no objection to the $7,500 bond.
And the previous domestic violence you said was on a pregnant woman, correct?
So the
arrest?
pregnant woman, the aggravated battery on a pregnant woman was no action. The other crimes that were convictions was the felon in possession and carrying a concealed weapon or firearm, and resisting officer without violence. Those were convictions, but they have a domestic violence indicator as well.
Right. And based on the statute again, 741-290, you can consider prior arrests. And so in this case, I'm going to increase the bond to $7,500 with a stay away order. Sir, you're not to engage in any criminal activity. Do not use any illegal drugs. If you have any firearms, you must surrender them to the nearest police department immediately. You're to stay 500 feet away at all times from Crystal Baldwin. You're not to have any contact directly, indirectly through a third person, social media, writing. You're to stay 500 feet away from her place of employment, school, house. Do you understand, sir?
This is a big.
I'm sorry?
Yeah. I ain't even reading the A form.
Your Honor, we're going to need the assistance of the Spanish interpreter for this one.
No problem. And I wanted to go back I wanted to ask you, did you, for Hayes, Ms. Hayes, did you have a chance to see if like some way communicate with her sister? Because I know her sister, this is against her sister and her sister wanted to testify. Do you know?
Yes, I understand that we're trying to get her on the line and work out the whole camera situation. So if we could just have a little bit more time.
That's fine. So we'll just pass that. I'm totally in agreement with that.
Okay, perfect. Thank you so much.
No, the sister is online. She's the victim and wants to like proceed, wants to testify, but she doesn't have video. They're trying to work it out. And I don't have ID here either. Okay, the next case, we're gonna need the Spanish interpreter, please.
The press present, Your Honor.
Okay, are you Yasel Amara?
Señora, ¿es
Sí.
usted Yesel Amora? Yes.
Oh, okay, and then, by the way, public defender, I want to let you know, on video, she just came on video, for Hayes, so I'm gonna do this case, and then I think she is the last case.
Okay, perfect.
Ma'am, I see you're on there, I'm gonna do one case, and then you could speak, okay? Okay,
Un momento,
Okay.
señora, están hablando de otro caso. Un momento.
no, I'm gonna go ahead with your case, sir. So you've been charged with one count of domestic violence battery, I'm gonna go ahead and read your A form to determine if there's probable cause.
Bien, señor, se le acusa de agresión física por violencia doméstica. Voy a leer el formulario de arresto para determinar motivo fundado.
Okay.
Okay.
Okay, eso no estuvo.
Public defender, do you have any PC arguments at this time?
Your Honor, at this time, we're just going to be asking that Mr. Almar Barzaga be released on his own recognizance due to no prior convictions, and the only prior interactions with the criminal justice system that Mr. Barzaga does have, they were all no pros, and in addition, they were over 5 or 6 years old at this point in time, one of them being a litter violation. So for that reason and the lack of interactions with the criminal justice system, Your Honor, we're going to be asking that Mr. Barzaga just be released on his own recognizance.
Su señoría, nuestro argumento es que debido a que él no tiene antecedentes, le den libertad bajo palabra. Además, lo único que tuvo previamente no fue procesado, fue hace más de 5 o 6 años atrás por un quebrantamiento de ordenanzas de basura. Por esa razón, pedimos que se le dé libertad bajo palabra.
The defendant has 2 priors, a misdemeanor from 2020 for battery. It was null crossed as a result of successful completion of pretrial diversion, and a felony from 2022 Florida litter law, also null crossed as a result of successful completion of pretrial intervention. The state's request is $1,000, a stay away order, and GPS level 3. The reason for the GPS request is the victim's statement to police that she has been choked by the defendant multiple times in the past.
Su señoría, para informarle de que él tiene 2 antecedentes. Uno es del 2020 por una agresión física, el cual no se procesó tras haber completado un programa de desviación judicial. Un caso del 2022 de una ordenanza de basuras, el cual no se procesó y estaba en un programa de intervención antes de juicio. De modo que solicitamos que se imponga una fianza de $1,000, una orden de alejamiento, que se le instale un GPS nivel 3, y esto es debido a que la víctima indicó que él en previas ocasiones le había ahorcado.
Yes, reading this arrest form, I see it's a very serious offense when it said, furthermore, the defendant has choked the victim several times in the past. However, the incidents they've always been unreported to police. That's a serious offense, it's domestic violence. I'm going to issue bond in the amount of what were you asking for standard bond?
The request is $1,000, a stay away order, and then the addition of GPS level 3.
Okay, I'll do standard bond for 1,000 with a stay away order. Sir, you're not to engage in any criminal activity. Do not use or possess any illegal drugs. If you have any firearms, you must surrender them immediately to the nearest police station. The defendant is prohibiting from having any direct or indirect contact with the victim.
My apologies to interrupt, Your Honor. I just know that the interpreter.
Oh, sorry. Sorry, Madam
Thank you.
Interpreter.
No, that's okay. Thank you, Your Honor. Bien, entonces, leyendo el formulario de arresto, me doy cuenta que es una ofensa grave, ya que se indica que él en varias ocasiones trató de ahorcarla. Por lo tanto, le voy a imponer una fianza de $1,000, una orden de alejamiento de la víctima, una instalación de un GPS nivel 3, de modo que usted no puede tener ningún tipo de contacto con la víctima, directo o indirecto. No puede tomar parte de ninguna actividad criminal, utilizar drogas o sustancias ilícitas. No puede tener ningún arma de fuego, munición, y debe de entregarla, esas armas, a la estación de policía más cercana.
Okay, you're prohibited from having any contact with the victim, Noel Benitez, including any contact directly, indirectly, in writing, by telephone, social media. You're to stay 500 feet away from the victim's home, place of employment, and school at all times. Do you and the victim reside? I believe you guys reside together. Is that correct?
Your Honor, what is the name of the victim?
I can't pronounce it, so I'm going to spell it for the record. It's Nohelia Benadides.
Okay.
AR.
Noelia Benitez.
Yeah, and the last name says Arostegui.
ARO. Bien, señor, por el momento usted no puede tener contacto con la víctima, sea directa o indirectamente, por teléfono, por escrito, ni en persona, ni a través de terceras personas. No puede tener contacto con la víctima a través de redes sociales o ningún medio electrónico. Debe permanecer a 500 pies de distancia de la víctima, de donde trabaje, de donde vaya a la escuela, en todo sitio que se encuentre la víctima. La víctima se llama Noelia Benitez.
And sir,
Yes.
you're allowed one time to go to the place with a police officer within 48 hours to retrieve any of your personal belongings, health, medication, any of your paperwork. You understand, sir?
Bien, señor, se le permite ir una sola vez a donde vive la víctima, que comparte su residencia, en 48 horas después de liberado, más debe de ir acompañado de la policía para que recoja sus pertenencias personales, cuestiones médicas, medicamentos, herramientas de trabajo. ¿Entiende?
Okay.
Okay.
Okay, so so you have a stay away order, probable cause fine for 1,000. And I'm not going to order the GPS monitoring at this time.
Bien, señor, entonces tiene la orden de alejamiento de la víctima, $1,000 de fianza, y no se le va a imponer el GPS por el momento.
Thank you.
Gracias.
Okay, we're going to go ahead and recall back case number. It's on page 6. It's Elia Hayes.
Yes, Your Honor.
Okay. So I know that the victim is present. You have been charged with 1 count of battery touch strike. I'm going to go ahead and read your arrest affidavit to determine probable cause, and then I'm going to let the victim go ahead and speak. No. Any prior?
No prior.
No pre-trial, Arizona. No pre-trial in Arizona. Okay. Are you, can you hear us? Can you hear us, ma'am?
Yes, ma'am.
Okay, I'm gonna have the clerk swear you in.
Please raise your right hand. Do you swear for the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, what would you like to tell the court at this time?
I would just like to tell the court at this time, me and my sister came on this trip together. She is a loving mother. She works a job, 9 to 5. I am not fearful of her. She is not a threat to me. The issue that I have is simply, I just need to get home. I would love for her to get her necessity done medically, and just for me to be out of her hair. Like I said, I'm not a victim. I know that's how y'all looking at it, but you don't have to have a contact or a no contact order on my behalf. I am of sound mind, and I can tell you for certain she is not a threat to me. My only concern is I came out here to facilitate her medical care, and obviously that isn't happening because of the series of events that took place. I would like for her to have her medical procedure completed, and if we could be cordial, fine. But if not, my only thing would be, if you see that fit, is just permit me some sort of financial support so that I can get back home, because I am out here without an oar. I have $20. I don't, you know what I'm saying? I don't have a dog in this fight. She's not my enemy. She's my little sister, my biological little sister, who I've raised her whole entire life, you know? So at the end of it, I love her. And I don't want anything bad to happen to her. She has 4 children that love and care about her a great deal. And I'm not sure if they're aware or not, but I know that they want their mother home. Again, she provides medical support to everybody and their mama. So at the end of it, it's a misunderstanding, to say, for a long story short, and just let me get my black ass home respectfully. I'm not scared of her. You don't have to have an order. Like, I've known this woman 33 years of her. How old is Leah? 32. I've known her whole life. She's not a threat to me.
Okay,
It was a disagreement. That's what it was. And again, the no contact thing, she's not a threat to me. I'm not in fear of my life and none of that. I just need to make reservations for me to get out of Miami, because I'm not a whore. I don't prostitute. I came out here to provide medical service for my sibling. And if that is not going to get done, respectfully, can y'all help me get home?
State?
The defendant has no priors. The state's request is $1,000 in a stay away order. The state would object to any modification of the stay away order at this time, as there has not been a sufficient cooling off period.
What would qualify as a sufficient cooling off period, if you don't mind me asking?
At least a couple weeks, at which point there could be a motion to modify the stay away order filed.
Your Honor, at this time, the defense is going to object. Mrs. Hayes, obviously, or Mrs. Hayes' sister, is before the court saying that she's in no fear. There's no need for a stay away order to be implemented. She's
correct.
At length has explained to the court that she is not a fear for life. She wants to see her sister. Her sister provides medical attention to everybody, 5 kids. She has a procedure of her own. And for that reason, we're not only asking to be released outright, but we're asking for the stay away order to be removed as well. Please.
I also am not pressing charges, just so we're clear. I've not made any charges against my sister, even through the whole ordeal. I begged and pleaded with the officers during the encounter as well that this is a misunderstanding, and just to allow her and us to collectively be able to kumbaya. They said because they were dispatched that somebody has to go, simply put, and they stood out there for hours, it seemed like, while I still begged and plead. So at the end of it, again, my word is my word. She's not a threat to me. I'm not a threat to her. I love her unconditionally. And I would like for us to end this trip like we started together.
Please. And Your Honor, at this time, we are asking again
Please.
that Ms. Hayes be released outright, as we are hearing from the alleged victim in this case that she is not looking to go forward in this case. So the defense at this time is asking for either dismissal or for Mrs. Hayes to be released outright, as the alleged victim is on the platform explaining that she does not want to move forward in this case.
And under no circumstances, we don't have nothing here. Ego has died with the whole police car ride. So at the end of it, we're still family. I love my sister. I know she loves me. I don't want nothing bad to happen to her. And I don't want her in Florida unnecessarily. Like I said, she has children who love her. She has a family, and she's a single mother on top of that. So her time is valuable. She has a game plan, and I would ideally like to help her execute it. And if not, that's fine. When she get out, she can give me my ticket and I'll get on the plane and go home.
But I have.
Okay, so I want to make sure, and all the testimony you're saying, you've been sworn under oath. Do you understand?
Correct.
Okay, so
Yes.
I want to
She's
make
not a
sure.
threat to me.
Okay, I want to make sure nobody has forced you to come here and testify today. No, has anybody forced you or coerced you into
I'm
testifying?
of sound mind as a pro se representative of myself. I am telling you for free that my sister and I love each other, and discord happens, but at no point am I threatened or in fear of my life from my little sister who I've helped raise. She has a medical procedure that I really want her to make sure that she gets taken care of, because her health is wealth, and also be able to see to it that she gets home to her children who love her, who I love. This is literally just one obstacle I'm more than willing to overcome with your participation in that, the court. My word is my word, and my yes is my yes. She's not a threat. I want my sister home so she can get what she needs to get taken care of, and we can leave like we came together as a family who loves one another. And that is
Okay.
not without
Okay.
its things, but nobody's perfect.
PD, do you have anything else to say?
Yes, Your Honor, at this time, at the
Can you talk a little bit louder? I'm sorry.
Yes, I'm sorry. I think I moved the mic over. Yes, Your Honor, at this time, the defense is either going to be asking for the state to dismiss the case, as the alleged victim is on the platform explaining that she has no interest in
Please,
proceeding in this case, or at the very least, again, being released outright.
please,
Your Honor,
mercy, grace, please.
the state cannot dismiss this case at this time, especially because it is a domestic violence crime. We have a procedure that we must do. We have to do a full investigation before we dismiss any case. The state's request still is a standard bond of $1,000 and a stay away order. If and the state would request in the alternative, if Your Honor does not wish to issue a full stay away order, then to do a modified one that allows for peaceful contact.
It's gonna have to. I ain't got no money. And if y'all not finna help me get home, I
Ms.
cannot
Hayes,
be in Miami. Respectfully, please. It's a peaceful
No,
contact for sure.
when we're talking about peaceful contact, meaning is that you'll be allowed to be in contact with your sister, in contact with her. It just, you have to remain in a peaceful manner. There could be no fighting or arguing, but you could still have contact with your sister. You're allowed to have contact, but you're prohibited from being physical, threatening, or violent towards each other. That's what we mean by.
Yeah, no, absolutely. And I'm wholeheartedly on board with that. 100%. I would have it no other way. But
Okay.
I would ideally, if she don't have to have a bond, please let her out, because I don't have the money to get her out. We don't have the money. We're indigent at this point. We already penny pinching. I'm walking everywhere to feed myself and her. So at this point, a bond would just further complicate things unnecessarily.
All right, thank you. I've heard the victim in this case who swore under testimony, she's not in fear of the victim, that's her sister, and she's requesting, and she's not in fear in this, so I'm going to grant an RR. And she will have no bond. She will be released on her own recognizance. So there's no bond based on your testimony that's sworn that you're not in fear.
Yes, absolutely. Thank you. I appreciate that.
Okay, so I'm gonna do an RR. And then you're gonna have a stay away order, but the stay away order is, you can be in contact with your sister. You don't have to stay, you just have to have peaceful contact. However, Ms. Hayes, the stay away order, you're not allowed to engage in any criminal activity, use any illegal drugs. If you have any firearms, you must surrender them to the nearest police department. Do you understand?
Yes.
Okay. The defendant is allowed to have contact with the victim, but is prohibited from being physically threatening or violent towards the victim in any manner. Do you understand?
Yes, Your Honor.
Okay.
Okay,
So,
Your Honor, my last
And hold on 1
request.
second, hold on. So I just want to let, for the record clear, I did find probable cause on the A form. I did find probable cause, but based on the testimony of the victim, I'm RRing her. Did you go?
Excuse me, Your Honor?
I was letting you know that I did find probable cause, but I'm RRing her based on the testimony of her sister.
She heard it. She got it.
Perfect.
Yeah,
Yeah.
yeah. Can you bring her back? Because I want to make sure she doesn't, she doesn't
And
live
that's the
here,
thing,
so
Your
she's-
Honor. Can I say this? If I like I said, I'm not scared of her, but she does have an attitude problem, and she does stuff like this to where she knows I'm at her mercy. She'll leave me stranded in Miami. So my thing is,
Ms. Hayes.
again, can I go?
Okay, so ma'am, I just want to let you know, I did find probable cause. However, I am RRing you based on the fact of your sister's testimony here today. I just want to make that clear for the record. And I'm doing a modified stay away. I'm doing a modified of the stay away order, meaning you can have contact with your sister, but it has to be, you're prohibited from being physically threatening, violent towards her. And also, I know you're out of state, so you have to make sure you update your address. This is critical because you're going to have a court date. And okay, your court date's gonna be June 16th at 9:30 at the Lawson Thomas Courthouse.
You said June 16th, Your Honor?
Yes, at 9:30 at the Lawson Thomas Courthouse, and then I don't know if you have the courtroom. And the courtroom is 2A. And at that time, of course, maybe the stay will not go forward or not, but at this time, you're released on your own RR and peaceful contact only. And again, the hearing date is June 16th at 9:30 in the Lawson Building, courtroom 2A. And then, public defender, will you please let her know about her address, updating it, and how important that is,
Yes, Your Honor.
and give her all that information?
Will do.
Okay, thank you. Thank you, ma'am, for testifying today. Your sister will
Yes,
get out.
Your Honor. Can
Thank-
I also ask, because I was talking to the previous lady who called in regards to victims. And like I said, my only concern is, like I said, my sister, she does have an attitude problem, and she's not far removed from like punishing me, like keeping me here, the booking and all of that stuff. I'm at everybody's mercy. And at the end of it, I just want to get home.
Ma'am, I'm just here, a judge is in the case.
I know.
But
I'm trying to get home. I need to get home.
Okay, I think, the only thing I could say is that she'll be released. She'll be released, your sister from TGK, just letting you know.
Thank you, Your Honor. Ms.
Okay,
Hayes,
thank you.
You're free to log off. She was released on her own recognizance, okay? She'll be released today.
She's gonna be released. Thank you.
Thank you, Ms. Hayes.
Is that today?
Yes.
Okay,
Sorry?
thank you.
The PD says
Bye-bye.
yes.
Okay.
Yes. So I think we're finished with the domestic violence.
Yes, Your Honor. At this time, that calendar's been completed.
Are you gonna be here for misdemeanors and felonies?
Not for felonies, for the other misdemeanors as well, yes.
Are you guys gonna be here for both?
Yes.
Do you guys wanna?
Recording
take a little
stopped.
break to a bathroom this?
Recording in progress. Recording stopped.
Public defender, I'm gonna let you know, we're gonna take like a 5-minute break for the bathroom in case you need to go to the bathroom or take a break too. I'm just letting you know.
That's fine. Thank you so much, Your Honor. I really
Yeah, of
appreciate it.
course. So we'll be back in 5 minutes. Hi, Miami Beach.
Hi, good morning.
Hi,
This is
we're gonna
Joanne
start in
Hennessy
5 minutes.
again.
We're gonna just take a quick
Thank you.
restroom break.
Thank you.
Recording in progress.
Whenever you guys are ready. I know they were sworn in the morning, but I don't know if it's different groups. Yeah, I would double check. They actually have me in Hialeah. And I don't speak a word of Spanish. Oh, I mean, okay, can you guys hear me? Okay. We're here for Ashley Caldaza Hernandez.
Reset NBC.
So this will be for tomorrow. Okay?
Yeah.
Okay, the next case that I have is Marilyn Lopez. Are you Miss Lopez?
Yes, I am.
Do you need a Spanish interpreter?
No, I don't.
Okay. So, there is a bench warrant in case number AL2LJBE. And it's for a no motor vehicle registration. And it says the notary said you failed to appear for trial on March 31st, 2026.
Yes, Your Honor, the defense is arguing that it was not willful as the,
Hey, sorry, can you talk a little bit louder?
yeah, I'm sorry, I think it just kind of gets away.
No problem.
So yes, at this time, the defense is arguing that the failure to appear to court was not willful. She had a previous address. It was at a hotel, and then she just recently confirmed a solid address where she can receive mail. So we're arguing that it was not willful and asks that she be released on her own recognizance so that she can go get this taken care of. And for the record, she has her license.
State?
And good morning, Your Honor. Secretary on behalf of the state. Now, I do see that you mentioned the previous bench warrants, but this case seems to be related to petty theft. Is that correct?
So this case. I just have the two bench warrants.
Mhm.
Yes, Your Honor, this only has to do with bench warrants. It's actually no motor vehicle registration, so it's a traffic case.
Okay, okay. And then the second case to let you know is AL2LJAE. And it's another bench warrant and it says knowingly in violation. So there's two bench warrants.
Yes, Your Honor, the defense is still arguing that it was not willful as she was in between homes, and then now she has a sturdy home where she can receive a mail. But yes, but as well as far as the bench warrants, they were not willful.
Okay.
You know, Your Honor, just to check on the traffic cases.
But it is,
Yes.
yeah, go ahead.
Yes, Your Honor, I do see here that there are no priors or anything that would, even on the traffic printout. So the state can stipulate to our regarding the bench warrants, regarding the traffic cases.
Okay.
Pending of course, the solution of the felony case that should be coming up.
So she has a.
She does have the felony coming up later on the cases, which is the petty theft, Your Honor, but now, since we are just arguing related the traffic cases, for now, we can stipulate to these ones. And then once we get to the felony ones, then we will address that one.
She's only in custody on the two bench warrant. There's no felony case on her jail card today.
There's no, yeah, I don't see that there's any.
From the defense either, Your Honor, I see no.
I'm,
Let me run the traffic here.
okay, I'm gonna just suggest, so we can go for it. I'm gonna just suggest these two bench warrants right now.
Thank you, Judge.
Ma'am, it is your responsibility to update your address and keep the court aware of your address, do you know, at all times? I can't hear you, I'm sorry.
I told Ms. Betsy, I think what's her name, the last one, Ms. Betsy.
Sorry, I can't hear you. Can you repeat?
Yeah, I told Betsy, I believe that was her name, the judge before, that I was living at a hotel and it did not have an address. She did tell me just to go to the DMV and pay my tickets, which I did pay my tickets. I got my license. So that's why I don't understand what's going on.
Because it says here that the bench warrant that you failed to appear on March 31st.
Yeah, I didn't have an address.
Did you appear for the trial March 31st?
I didn't even know I had a trial date because I just moved to my own house.
Yes, Your Honor, and that's the exact principle.
State,
that
are you
it
willing
was just
to
not willful.
appear for
Yeah.
the trial?
So that was For some reason, the petty theft seems to be attached to this one, but I just double checked and there were no action. So now just focusing on the traffic cases that we have, we can either offer a CTS to close both of these cases right now. If not, we'll just be asking for the standard bond.
Your Honor, they just a second ago stipulated to ROR.
You guys had stipulated to, are you on both of these?
So we can either offer the CTS to close both the traffic cases right now. If not, Your Honor, we'll be asking for the regular standard bond, given the fact that the defendant has previously bench warrant. That will be the state's position.
Your Honor, 30 seconds ago, they literally just stipulated to an ROR based on both bench warrants. This is a no motor vehicle registration with no priors, no threat to the community, no flight risk, has a sturdy address, can receive mail. It wasn't a willful failure to appear. At this time, we're asking that she be ROR.
The reason that they changed it, they're saying, is because there was arrest for petty theft, but they didn't process,
He was no
no action.
Yeah.
No rest.
Yes, Your Honor. And also on the CJIS printout, there's no record of any sort of previous arrest or any case that's related to. This is a no motor vehicle registration case. The state previously stipulated to an ROR, and we're just asking that the state honor that and just allow Ms. Lopez to be released on an ROR. Ms. Lopez has no priors, no interactions with the criminal justice system per the CJIS printout. Your Honor, there'd be no reason to hold Mrs. Lopez in custody. And we have now updated that her address where she can receive mail to appear to her next court date.
The original.
And the confusing aspect is like the petty theft seems to be the underlying, like the missing part here. That's why I previously said about stipulating and then focusing on the petty theft. But given the fact that it was no action, that's the reason why the state's argument.
Your Honor, we don't even see that there was even a no action. We
Okay.
have the
What I'm gonna do is I'm gonna bundle. Yeah, I'm gonna convert the bench warrant into a bond. And I'm gonna convert it into $150.
Your Honor, but there would be no reason to hold Ms. Lopez in custody. It wasn't a willful failure to appear, and it would require a willful. It would have to be that Ms. Lopez absolutely knew that she had court and failed to appear on purpose. She didn't receive notice, and for that reason.
But it's on her to update the court system about their address. No, it wasn't that she failed to appear for a trial. But I'm lowering it from $3,500 to $150.
That's on each case, Judge?
So, yeah, 150 each case, from 3,500 each case.
I understand, Your Honor, but in addition, the state just stipulated to an ROR. Can the state provide grounds as to why it
They want
changed?
to know, okay, they want to know why you just stipulated to an RR and why you changed your ground.
Yes, Your Honor. As I previously stated, the reason why I stipulated to the traffic was because there seemed to be an associated petty theft that I do see here. And when we checked the petty theft, that petty theft was no action. But I was just focusing on the charges, the traffic charges that she previously bench warranted. That is the reason why now I changed from stipulated to an ROR to actually giving a bond.
And Your Honor, nowhere in the A form does it even mention any petty theft or any related case whatsoever. This is a no motor vehicle registration case.
So instead of the 3,500, I'm going on case number ending in JBE and in case number JAE. Instead of 3,500, which is what the state wants to convert it into, I'm doing $150.
Okay, that's your final,
150 on both.
Okay, next defendant is drumming, Judge.
I'm sorry?
Next defendant is drumming.
Sorry, I couldn't hear you. Corrections.
The next defendant is Madeline Drumming.
Okay. Wait, do you still want, you guys?
So the stay away or the petty theft?
But it's,
Yes.
no,
Yes, he was not. Yes.
No, this was an add-on bike.
okay. So now, which Madeline? Oh, it's an add-on. Okay. So are you Madeline?
Go ahead.
What?
She can hear you first time.
Yes, Your Honor.
Oh.
Corrections.
Yes, Judge.
For this, for Madeline, I know it's add-on. What was she picked up on?
A battery and a bench warrant.
So I don't, I see the bench warrant, but I don't have the battery. Hold on.
The clerk should have it. I called him this morning.
Okay. We don't have the paperwork for the battery. Their clerks are telling me.
Marcus, I gave it to Day this morning.
I'm sorry?
I gave it to the clerk this morning, both cases.
They're telling me it has to go through the domestic violence, that they don't have it. Do you guys have it? The battery arrest?
The DV clerk called the misdemeanor clerk and gave these cases to the jail arraignment clerk. And I confirmed it this morning with the jail arraignment clerk.
Okay, so the clerk is telling me that they cannot hear the battery today because they cannot print it.
Okay, reset.
And has to go through a certain procedure, so we can hear there is a bench warrant for $1,500 dollars.
What case is that, Judge?
The bench warrant was on case M2401080.
And that bond is 1,500?
Yes,
So what are we doing with the other case? It's reset for, it's a DV case or what? Because I'm confused. 'Cause we're going back and forth. DV said it was a misdemeanor comp case. So it's reset for DV or for misdemeanor?
okay, so they're telling me for the domestic violence, I'm gonna put a note here. I'm gonna just say for the domestic violence, we're gonna have that reset. Do you know when it's reset to? Okay, I'm gonna put the DD, I'm gonna reset it for tomorrow because we don't have the A form. Do you have the A form, public defender?
Your Honor, we do have the A form.
For the domestic violence?
Yes, I'm seeing two A forms that I have, one including,
Self-defense.
no, hold on one second.
Oh.
One including the actual alleged crime of a battery and then the bench warrant. I have both A forms.
Yeah, and the state doesn't have it. It's only on their computer and I don't have it. So I guess I'll reset the DV for tomorrow because I don't have the paperwork. The clerks say they don't have it.
Okay, is there any way that we can print it out and just pass it until the state attorney's office can get that A form and it can get, provided to them?
Hold on, let me see. I mean,
We're gonna reset it for tomorrow. We have a big calendar. We're trying to move the calendar along.
It's like even if I were to. It was so.
the state is saying even if they're able to print it, that the clerks can't, they need certain paperwork or procedures. I don't know how the procedures work in terms of the paperwork.
Understood, Your Honor, that's fine.
We'll just hear the bench warrant, but I'm gonna reset and make sure that it gets heard at 4:20, and I'm gonna say that due to the paperwork. Really sorry, that's outside of my control, how the clerks and the paperwork work.
Understood.
Yeah, the clerk saying it has to come from domestic violence, because it was just like an add-on.
Okay,
Your Honor, just to clarify, it will be reset for tomorrow?
Tomorrow.
Understood. Yeah, we'll try.
Okay, so we can go ahead and, you guys wanna go ahead and adjust the bench warrant?
Yeah. And you're regarding the bench warrant here, we'll just be asking that be converted to a bond in the same amount of
And
1,500.
what was the original
Judge,
bench warrant was from
1,500,
He
right?
was a petty theft, Your Honor.
state? I mean, PD, sorry.
Your Honor, at this time, we are arguing the same, we stand as previously said. She did not fail to appear willfully, which is what the law requires, that she, knew of a court, didn't show up. At this time, she did not know that she had court. She never received notice. And for that reason, we are asking to be released on her own recognizant in regards to the bench warrant.
So, I mean, she was known of her court date. I mean, yeah, she should have known. So I'm gonna convert the bench warrant of 1,500 into a monetary bond.
What did you say?
Your Honor, could we argue due to the fact that, she was between addresses? I know that you said that it's, their job to update the court, but we're just asking that this bond be modified to $150 instead of the 1,500 that Your Honor has just stated.
And Your Honor, we object not only for what we explained before about the bench warrant, but also because of the potential of another charge to battery. So because of those reasons, we'll keep we still will ask for the 1,500 on a month.
There was no battery.
Okay, so yes, at this time, I'm gonna proceed with converting the bench warrant into a monetary bond of 1,500. I mean, she's known about her court date. I mean, moving two houses, it's up to her to notify the court, update, keep her information. And then the DV will be heard first thing, or I don't know first thing, but tomorrow I'll make sure it gets on for tomorrow because the clerk does not have the paperwork from domestic violence. Right, yeah. I just want to, I know we discussed this earlier for domestic violence, but in all these cases, you're gonna be appointed, appointment. I can't hear, sorry.
Yes, Your Honor, my apologies.
No. Okay, so the next case I have is Salinvento. Okay,
Fonda.
What was that name again, Your Honor?
Fonda.
No,
Anthony Gonzalez.
1 second, Your Honor.
Good morning. Are you Mr. Gonzalez?
No, Your Honor, we're pulling number 19. I was just told by corrections out of order. So it's Brian Stevie Faison.
What page is it on?
It's number 19. That would be page 6.
Okay. And priors. So you're Stevie Brian, correct?
Brian Stevie Faison, yes, ma'am.
Okay. And you've been charged with 2 counts. One was assault with a police officer, firefighter, and the second count is resisting officer without violence. I'm gonna read the PC, I'm gonna read the rest of David to see if I find any PC, and PD, let me know if you have any arguments.
Understood, Your Honor.
Okay. The court finds probable cause on both counts. Edie, do you have any arguments at this time?
Yes, Your Honor, this time we're just going to be asking for the standard bond for the misdemeanors.
Eight?
Yes, Your Honor. The state, for the first count will be asking for 1,000 and on the second one for 500.
Let me see. Yeah. You can see there's looking at this criminal history. Okay, so I will issue, said 1,000 on count one, 500 on count two.
Yes, Your Honor.
Yeah, I'll issue the standard bond, 1,000 count one and 500 count two.
You said count 1,000?
1,000 and count
Okay.
two, 500. Thank you.
Your Honor, we can just reduce the $1,000 to $750 if Your Honor would be inclined.
That one's.
On
I
count
mean,
one.
Yeah, I don't got.
I'm gonna do standard bond. I mean, standard bond on both.
Understood, Your Honor.
So we'll go back to the next case is Anthony Gonzalez.
1 second, Your Honor. I think we are going to call someone at a turn.
I'm calling someone at a turn. Which who are you calling?
Page 8, number 25, Mr. Loving.
Your Honor, this is Joanne Hennessy for the city of Miami Beach. I'm just announcing my appearance in this case. At this time, it's the state's case.
Thank you. And IT, you're monitoring the panelists because a lot of people are requesting to come in. I just want to make sure you're monitoring. Please. Okay, so you put, I guess you could put like a little note if it's from an iPhone, you won't emit them. Is that why? For like security purposes? Okay, I understand. Are you Mr. Loving?
Yes, ma'am, I'm Mr. Loving.
Okay, you've been charged with 3 different counts. The first count is resisting officer without violence. Second count is false name after arrest. The third count is camping prohibited. And this is Miami Beach. So the Miami Beach will handle it. Okay, Miami Beach will handle it.
But now that they gave it to us, now we will use the ordinance to start the legal duty for the our work. So we will
Okay.
use it.
So I'm gonna go ahead and read the A form to determine if there's probable cause for the 3 counts. Okay, the court finds probable cause on all three counts.
Yes, Your Honor, at this time, the defense is just going to be asking that Mr. Loving be released on his own recognizance, as none of the charges in this case that are allegedly being brought against Mr. Loving are violent in any way, shape, or form. It just happened to do with a name discrepancy and him, being in South Beach. So for that reason, we're just asking for Mr. Loving to be released on his own recognizance at this point in time.
Okay,
Yes, Your Honor. Given how recent the priors the defendant has, including all of them in 2025, trespass, disorderly intox, battery, and also violating a sex offender registration, the state will be asking for an elevated bond on the RWOS and then just a standard on the remaining two counts.
so you on elevated on which one?
On the resisting without violence charge, and then just a standard bond amount on the other two.
Which is 500, 150?
Let me double check, Your Honor.
Yes.
Correct.
Okay, count one, I'm gonna, the standard bond 500.
I can't
Count
hear you,
two.
Judge.
Count one, 500, count two, 500. And count three is the standard bond 150. PC found on all three counts. Thank you. You want me to put this out? Are we going back in order now?
No, Your Honor, we're pulling one more person out of turn. That is going to be, give me 1 second while I just turn to the page. Mr. Sinistera Quintero. It's on the page 14 of Your Honor's calendar, and he also needs the assistance of the Spanish interpreter.
Okay. Okay,
Connected, Your Honor.
hold on 1 second. Let me get it. So these, I believe, are, I'm gonna get the priors, but these,
I'm check for the very last one.
okay, are you Jamie Arturo Quintero?
Señor, ¿es usted el señor Arturo Quintero?
Sí, yes.
Yes.
Puede hablar español.
No, Quintero.
Ahí me Arturo.
Okay, so we're here on, it's this one. Yeah.
Yes.
Hold on. So here, there's two, bench warrants. The first one is on AL 50X0 0E, and the second one is AL 50XNE. And the first one is for insurance not enforced. The bench warrant is $1,000, and he also failed to appear for his arraignment on February 25th. And this, the second one was registration expired more than 6 months.
Judge, I only have him in custody on one case,
Which case?
the OE, the bench warrant.
Okay.
Bien, señor, usted se encuentra aquí debido a dos casos, AL50X0E y también por uno que es AL50XNE, por la cual tiene una orden de arresto. La primera es por no tener comprobante del seguro y porque usted no vino febrero 25 para su lectura de cargos. También por no tener la registración por más de 6 meses.
Okay, and we're only gonna address the first warrant, which is the one ending in XOE.
Y solamente vamos a tratar el caso que termina en XOE, que se trata de la orden de arresto.
Okay.
Your Honor, the state will be willing to close this case out with CTS, just to be able to close this case.
Su señoría, la Fiscalía del Estado están dispuestos a cerrar el caso por crédito, con crédito por tiempo cumplido para cerrar su caso.
PD?
Yes, Your Honor. If I could just have one moment to relay that offer and speak with him for a brief second.
Sure.
Your Honor, at this time, the offer is rejected, and we're arguing that Mr. Sinis Quintero should be released on his own recognizance. The only thing that he was stopped for, obviously, was that he wasn't wearing eye protection. And at this time, it's obviously not a violent charge whatsoever. It had nothing to do with violent, and then it was found that he had a bench warrant. And we're also arguing that it was not willful, as again, he just did not update his address. He never received a notice from the court because he was in between homes, and for that reason, we're asking that he be released on his own recognizance.
Su señoría, la oferta está siendo rechazada, ya que él tenía protección en los ojos, no es un delito violento y la orden de arresto fue por no haberse presentado, sin embargo fue porque acababa de cambiar de dirección, estaba en 3 direcciones y no fue una cuestión voluntaria, así que pedimos que en lugar le den libertad bajo palabra.
And Your Honor, let me check the defendant's address. Give me one moment.
But he did
Yeah.
fail to prepare for the arraignment. You know, it is up to, the defendant to update the court. It's their responsibility to update with new addresses when they move, to say it was unlawful. It's their responsibility to let the court know.
Para la defensa es su responsabilidad actualizar la dirección de las personas cuando se mudan.
So Your Honor, having verified the defendant does live here in Miami-Dade County, we will be willing to offer PTS.
A los policías que.
I'm sorry, Your Honor, I wasn't able to hear the state. Can you get closer to the microphone?
So we would be willing to offer pretrial services, given the fact that he was previously bench warranted, and he does live here in Miami-Dade County. PTS onto the next event or court event on the case that he was bench warranted in.
A su señoría, estamos dispuestos a ofrecerle servicios antes de juicio para la ofensa, y ya que es un residente del condado de Miami-Dade.
Your Honor, if I could just have a brief second to speak with him about that. I think that's the different offer than the one I received earlier. I couldn't hear him clearly earlier, but I believe that the offer was different, correct?
Yes, offer.
Okay, so if I could just have a brief moment to speak with him about the new offer that's been put on the table.
Your offer is
Si me da un momento, su señoría, para hablar con mi cliente brevemente, ya que esta es una nueva oferta.
Your Honor, at this time, he is interested in taking the state's offer and he would like to accept pretrial services.
En este momento, su señoría, él está interesado de aceptar la oferta del Estado, que es servicios antes de juicio.
Okay, so he will enter into pretrial services and he's accepting. I will grant that.
Yes, Your Honor, thank you.
Thank you.
Concedido, gracias.
What's the alternate bond? Alternate bond?
Okay, thank you. That's it.
Your Honor,
Excuse me,
Oh,
Judge,
yes.
what is the alternate bond?
Oh,
Standard bond.
which is,
Let me double check here. Standard one is, give me one moment. It says 1,000 here.
That's what the bench.
That's what the benchmark, yeah, let me check.
He's leaving.
You're checking.
It is, we'll be using the one for the non-valid driver license, which is 500.
So,
500.
okay, so I know we left, so in case ending X zero E, the alternative bond will be 500.
You lowered the bond?
Yes.
Bien, ya él se marchó, pero como alternativa de fianza, en el caso que termina en X o E, serán $500 de fianza.
Are we going back in order?
Yes, Your Honor. At this time, we are going to be returning to back in order. It should be Anthony Gonzalez. That's on page,
Okay.
I believe 2 of Your Honor's calendar.
Mr. Gonzalez, do you need an interpreter? No. Okay. You've been charged with 1 count of indecent exposure. I'm going to go ahead and read your A form to see if I determine probable cause. Yeah, this is.
Yes, Your Honor.
PC
Hey,
for me.
brief. I believe this one was set for PC here from yesterday.
Yeah. It was.
Do we have the Zoom open? Let me check.
Hold on.
Yeah, let me see now.
There should, I believe there should be an officer coming because this was reset from yesterday for a PC.
Understood.
Is there a police officer?
So his name is Officer Perez Roberto. I don't know. Whom?
IT, can you help letting in an officer, or can the officer like wave his hand if he's on there?
It should be Perez Roberto or any officer related with the case of Anthony Gonzalez.
If you could put a note or see if they could. But can you put a note in the chat or ask, was the officer going to appear?
So, you know, we try to reach out to the officers. We did send the subpoenas, but we were not able to personally confirm the officer for today.
Okay.
And at this time, Your Honor, the defense stands on its previous arguments that have already been made to the court for the lack of probable cause in the A form. And we actually renew the argument and ask that Mr. Gonzalez Anthony be released on his own recognizance due to the lack of probable cause that an indecent exposure was allegedly conducted on this day.
Okay.
Your Honor, just briefly, I do know that yesterday there were arguments about this case, and the main was the exhibition of the sexual organ. I believe that was the issue from yesterday.
If you would like him to argue his position again, since you weren't here, he can briefly.
Yeah, if I
Can you briefly argue your position? Because
Yes.
this is a new set of state attorneys.
Yes, Your Honor, this is, we're arguing that there's a lack of probable cause due to the fact that there's no exposure of the actual sexual organs, which is required under the statute of indecent exposure. 2 witnesses explicitly state in the A form and told the officer, which the officer did not see this crime, he was only told by other people, that they did not see the organs shown. There's only 1 person and 2 other witnesses did not see it shown. So for that reason, a reasonable person would not believe more than not that an indecent exposure was conducted when 2 witnesses say they didn't see the organ and only 1 did.
And Your Honor, if I may, it will be the state's position that even though the 2 witnesses didn't see the sexual organs, you can see in the A form that while the officer does specify that the witnesses didn't see it, it doesn't say anything regarding the victim. The victim was next to the person, and it, on the A form does not say that the victim didn't see it, whereas the officer does specify that the victim didn't. So based on those records, I do believe that you can infer based on the A form that a victim that was next to a person that was masturbating based on the A form was able to see the sexual organ. So for those reasons, we do think that within the four corners of the A form, we can, there is probable cause to believe that the defendant here did expose his sexual organs.
What's the standard bond on this? If you don't have it, what's the standard bond on this?
The standard bond, moment. Give me one moment. You know, this bond based on what I see here will be 1,000, but the state will be asking for an elevated bond, Your Honor, not only for the, there is an open theft case regarding with this defendant. You can also see a lot of priors, including batteries, aggravated robbery with aggravated battery, disorderly conduct, and more, and also the fact that the cases are concerned. So the state will be asking for an elevated bond in this case.
Want to briefly respond?
Yes, Your Honor. Due to the lack of probable cause within the four corners of the A form, we're asking for we're still asking for Mr. Anthony be released outright. But if Your Honor is not inclined to do so, at the very least, we're asking for just a standard bond due to the lack of probable cause within the A form.
No, they do have an open misdemeanor, and there is an extensive criminal history. I'm gonna raise it to 2,000. And PC is found.
Said 2,000?
2,000. Thank you. And there's also a stay away order. Sir, you're to stay away from Madeline Chica. I don't know how to pronounce the last name, so I'm gonna spell it for the record. It's CHICASOJEDA, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third party. Defendant must stay away at least 500 feet from the victim's home, place of employment, and school at all times. Also, any electronic contacts such as emailing, texting, Facebook, messages over Twitter is prohibited. Do you understand that, sir? I cannot hear you.
Yes, ma'am. Yes, ma'am.
Okay, thank you so much.
Judge, I couldn't hardly hear you.
They're gonna tell you.
1,000 or 2,000?
I elevated to 2,000. Thank you. Oh, did this one. Let me see. Are you Lyric Allen? Yes?
How you doing?
Good, okay. So. You've been charged with 2 counts. 1 count is assault police officer. And this, wait. And the second count is a trespass property after warning. I'm gonna go ahead and read the form to determine whether there's probable cause. After I read it, PD, please let me know if you have any PC arguments. And the court finds probable cause on count 1, and the court finds probable cause on count 2. Any arguments at this time?
Yes, Your Honor, specifically to assault, there has to be an ability to carry out an assault and put someone in actual and real fear. The defense just arguing that there's not probable cause and that someone could not, a reasonable person could not believe that it was more likely than not that while Mr. Allen was allegedly in the back of a cop car, he could have carried out a situation that would have put the officer who was in the front of the cop car behind the other side of the protective cover that happens between the front seat and the back seat in a police car. That would put him in actual and imminent fear for his life as charged under the statute for assault. For that reason, we're asking that there's no probable cause to support that charge and he be released outright on count one.
State?
And Your Honor, while I understand the council's argument about not being imminent, I do see here a combination of words. He would slam the object to the ground with an action of becoming combative. Now we don't know what by being combative what it meant. So, but when you look at the A form, the combination of those two, you can see that that it is reasonable for somebody to think that they're in fear of imminent harm. So that would be the state's position regarding count one.
Your Honor, when someone's in the back of a police car in handcuffs while the officer is in the front seat of the car, protected by the protective metal measure in between the police car, no one can be in actual imminent fear for their life under that circumstance. There's no probable cause to support that the assault could have been carried out in any way or that the officer was in imminent fear.
But the A form did say that he said he was gonna slam. Hold on, it said he was gonna slam. Let me back up. It said here, he says, when I'm out, the defendant told the deputy that when we get to TGK, he would slam me to the ground.
Yes, Your Honor, but there needs to be an ability to actually carry out or put someone in imminent threat. He was in handcuffs in the back of the police car. And if that was so, then this officer would have completely stopped his transport to TGK and called in all of the backup to show up to TGK to assist him if he was truly in imminent fear. And none of that is listed. None of that happened. The same officer he's claiming who was in imminent fear for his life is the same officer that brought him into TGK.
And Your Honor, well, of course, he was in handcuffs. He was kicking the car. That's the reason why. And like I said, well, of course, the threat in words was in the future. It did become combative. So when you add those two, a reasonable person, a reasonable officer would believe that he was at risk of imminent harm.
And the state just contributed to the defense's argument by saying that it was in the future. Your Honor, a future threat does not count as assault, as it needs to be an imminent threat that you can carry out at that point in time. There's no probable cause to support the assault.
And of course, Your Honor, I do agree that it is in the future, but when you combine those words with the imminent action of kicking, then you can infer that a reasonable officer would be placed in reasonable fear.
Oh.
And that's not to
yesterday they
mention that
told
the officer in this case also had an extensive ability to defend himself due to tasers,
Also,
guns,
sorry,
etc.
We'll put it in my comments here. Okay. So count one, I do believe that I do believe with the defense argument here that I don't believe that there's enough for assault. He was handcuffed behind, back of the police car, and it's true, there would have been backup. So on count one, I do not find probable cause. Yeah, so there's no PC on count one.
And Your Honor, we just ask that a standard bond be issued for count two.
State?
And Your Honor, on the second count, we'll be asking for an elevated bond. When you look at the priors to at least four previous trespass, along with other charges, including battery, stalking, and among other felonies in there, but just focusing at least on the trespassing, there being at least four. So for those reasons, we'll be asking for an elevated bond.
Yeah, so on count two, I am gonna give an elevated bond of 2,000. And PC's found.
I couldn't hear count two, Judge.
2,000 elevated based on his previous trespassing. And also, there's gonna be a stay away order. Sir, you're to stay away from the property located at 21657 South Dixie Highway, Miami, Florida, 33170, and that is Panker's Bakery. Do you understand?
They shouldn't have a.
Any officer related titles
Okay, no problem. We went forward with the case anyways, but thank you so much for checking in. You want the priors or no? So the next case I have is, if we're going in order, would be Allen. Oh, Allen, sorry. Mitchell Francis. Are you Mr. Francis?
Me.
It's the same. It's like the same initial.
Yeah.
That's why. Okay, so you've been charged with 2 counts. The first count is battery and the second count is assault. I'm gonna go ahead and read your A form to determine if there's probable cause. Once I read it, PD, let me know if you have any probable cause arguments. Okay, the court determines there's probable cause for count 1 battery, probable cause count 2 assault.
Yes, Your Honor. At this time, we're just asking that Mr. Michael be released on his own recognizance as he has no violent priors. And a majority of them are remote in time as 2006, 98, 2002. And for that reason, we're asking that he is our ward, and also for the basic factors that the court can take into account. He's not a flight risk. He's never failed to appear. And there's no reason as to why Mr. Michael shouldn't be released on his own recognizance, especially with the presumption that someone should be entitled to non-monetary bond.
Date?
And you understand, we requested a standard bond, but I understand that the previous charge is remote. When you look at the A form and the facts of this case, including 2 victims, I do believe that a standard bond would ensure the defendant's return to court and the ability of victim to carry out what happened here.
Okay, so the court finds probable cause count 1, standard bond for that is $1,000. Count 2, standard bond is $250. Court finds probable cause, and also a stay away order from Yami Rodriguez and Scott Mello. Sir, you're to stay away, have no contact with these 2 individuals directly or indirectly, in person, in writing, by telephone, pager, fax, or through a third person. Defendant must stay at least 50 feet away from the victim, victim's home, place of employment, or schools. Also, you're to stay away from the property located at 14700 Northwest 2nd Avenue, Miami, Florida, 33168. Do you understand, sir?
Yes.
Okay. Thank you.
You have 1 out of turn. Page
Sure.
4, number 12, Darling.
Hold on. They said page 4, number
Mr. Darling.
Darling. It's the first one, I think, on the top of page 4.
Your Honor, we're going to also call Mr. Darlin out of turn. He is on page 4 of Your Honor's calendar.
Yes. Okay. Darling Gustavius, correct?
Yes, Your Honor.
Okay. You've been charged with 1 count of petty theft. I'm going to go ahead and read your A form to determine if there's probable cause. Hey, the court finds probable cause for petty theft.
My apologies, Your Honor. I didn't hear you. What happened?
I find probable cause for petty theft.
Understood, Your Honor. At this time, we're just asking that Mr. Darling be released on his own recognizance, as there's no threat of a flight risk or failure to appear, and we're just asking that he do be released on his own recognizance.
And also there is a stay away order, from 20505 South Dixie Highway, Color Bay, Florida, 33189, and that is the Macy's. Do you understand, sir?
Yes.
Hold on, let me look at the state.
And Your Honor, the state requesting an elevated bond here. Not only do we see at least 6 prior theft-related convictions, but also you see that they are recent. So for those 2 reasons, we'll be asking for an elevated bond.
When's the most, oh,
We see a 2026 petty
April?
theft conviction and a 2018 conviction petty theft, 2023, 2023 again. And then what?
so the one that's listed here on April 8th, 2026 is another case, is another petty theft
That is another petty theft.
from this month? Just want to confirm.
Which one are you referring to, Your Honor?
Case ending in 260066783.
1783.
It's on the last one on the first page.
What are the last 4, Your Honor?
6783.
6783.
You want me to show
I
you?
don't see it in here.
Tell me it's the last one on that page. At the bottom.
I didn't think. Yes, Your Honor. Seems to be
A different case. Just want to make sure.
it is a different case, Your Honor.
So there's a petty theft that was from 4/8 just of this month. On 4/8/2026. Do you have that, PD?
I'm looking right now, Your Honor. I do have.
The
I'm
case
speaking-
number is P2026006783. That was just 2 weeks ago.
Can you tell her what happened?
Yes, Your Honor, I do see it.
Okay.
Can you tell her what?
Okay, so because of the prior petty thefts, the court is going to do an elevated bond of $1,000. And PC is found. And I already told you about the stay away order from the Macy's. You understand, sir?
Yes.
Thank you. Are we going back in order?
Yes.
Okay, thank you, corrections. So we should be with Jefferson Alvarez. Are you Mr. Alvarez?
Yes, ma'am. How you doing? Good morning, miss.
Good afternoon. So you've been charged with 1 count of trespass, unoccupied structure or conveyance. After warning, I'm going to go ahead and read your arrest form to determine if there's probable cause. Okay, the court finds probable cause for trespass of an occupied structure you have any PC arguments?
Yes, Your Honor. At this time, the defense is going to be arguing that there's no probable cause for the trespass due to the fact that Mr. Alvarez was given permission at the initial interaction for Mr. Alvarez to enter onto the premises. So he was given permission to enter into the home and be in the home. So at this time, we're just making that argument.
But it says here at the second page of the A form, it says, officers asked the defendant what he was doing. The defendant stated, my friend Carlos let me stay here and I was going to take a shower. The victim was then asked to confirm his roommate, confirm whether authorization had been given. The victim stated his roommate's name is Lewis and confirmed that no authorization had been given for the defendant to be inside.
Defense stands on its argument, Your Honor.
State?
And Your Honor, yes, the state does agree with Your Honor's argument regarding this. So we do believe that here the defendant does say my friend Carlos let me stay here, which it's not what happened based on the A form. So we do believe there's probable cause based on what Your Honor just mentioned.
And are you requesting $500 standard bond?
And Your Honor, in this case, we'll be asking for a felony hold. Here, we see that the defendant has a felony petty that is set for arraignment. And this felony happened before this, that it is predated this charge. So for those reasons, we'll be asking to be held on a felony bond, and to the judge who's gonna handle the felony sees this charge as well and addresses the pre-trial conditions, if any.
PD?
Yes, Your Honor. I kind of lost the state attorney at the tail end of his sentence. Can you just repeat
He
that
said
for me?
that he'll be held on a felony hold.
Can you give me the case number that he's referring to?
I do have it here. It'll be F26 00 67 34
384?
34.
34.
Mhm.
So F26006734.
That one is set for arraignment on May 5th with Judge Emma Alsner.
And that's set for May 5th. At what time?
It is at, let me double check.
Are you placing the hold, Judge?
Yeah, I'm gonna place a felony hold.
Understood, Your Honor.
Okay, and then,
Trying to figure out the time, but I don't.
okay,
think
it's May 5th, 2026, but at this time, I don't think the state has the exact time, but it is May 5th.
Is the arraignment is what you're saying?
Yes.
Okay.
Okay, and then count one, I find probable cause, and I will do the standard bond of 500.
What's the standard bond?
It's 500. And hold for the felony. Oh, okay, so we found out the time. It's May 5th at 9:15.
So, what my
The next. We also had the. Okay. Are we go? So the next case I have is. Ahmed Bemba. Sorry, how do I pronounce your name, sir? You're on mute.
Sorry, Your Honor.
Bumba.
Okay.
Your Honor, Joanne Hennessy for the city of Miami Beach.
So you have been charged with 2 counts. The first count is camping prohibited on Miami Beach, and the second one is parking entering after hours Miami Beach. I'm gonna go ahead and read the E form to determine if I find probable cause.
Okay.
And Miami Beach will be in this. Yeah, perfect.
Thank you, Judge.
Court finds probable cause on count 1 and the court finds probable cause on count 2. PD, let me know if you have any arguments.
Yeah, Your Honor, this is Joanne Hennessy for the City of Miami Beach. I'd recommend the standard bond. Mr. Bamba has a 2023 battery, as well as a recent encounter with the police that didn't result in an arrest or anything, but regarding the same behavior. So I just request your standard bond in this case.
And that's 150 for each count?
It is, Your Honor.
Okay. Thank you.
Yes, Your Honor, at this time, we're just asking for Mr. Bama to be released on his own recognizance as he's not a flight risk. He's never shown an ability not to show up to court. He has ties to the community, and we're just asking that he be released so that he can be outside of custody as per the presumption while he awaits his trial day, so he can, continue on and also show up to trial.
No, I'm gonna give him standard bond 150 on each count. Count 1, 150, count 2, 150. And I find probable cause in both.
Go ahead, Mr. Bama.
Thank you. The next case I have is Mills Gregory. Good afternoon, sir. Are you Mr. Gregory?
Yes, ma'am.
Okay, you've been charged with 1 count of petty theft. I'm gonna go ahead and read your arrest affidavit to see if I find probable cause. Did you have any arguments at this time?
No, Your Honor, at this time, we're just asking that he be released on his own recognizance as Mr. Mills. As Mr. Mills is not a flight risk and shows no threat of not appearing before the court, which is what the purpose of a monetary bond is. So for that reason, we're just asking that he be released on his own recognizance.
And also, Mr. Mills, there's a stay away order from 3929 Northwest 79th Avenue, Doral, Florida 33166. Sir, do you know you're not to appear anywhere near that area? Do you understand?
Yes, sir. Yes, ma'am. Yes, ma'am. Yes, ma'am.
And what state
And
position?
Your Honor, the state will be requesting an elevated bond. Not only does the defendant has these current, but also there is 3 open cases, and out of those 3, 2 of them are batteries. Additionally, looking at the priors, there is a previous without litigation on a petty theft and a conviction on a grand theft, among other charges as well. For those reasons, they will be asking for the elevated bond.
And the 2 open battery cases, they're set for trial?
They are set for report on June 17, and then there's a trespass after warning that is for arraignment.
No,
Your Honor, the seat just reflects that the trespass after warning was dismissed on the 13th of this month.
Hold on. No, petty theft for bond.
And it is appearing on the CJIS printout, Your Honor, that all of the cases are closed. The state attorney's office can provide a case number for the cases that are open.
I have a case.
He has case numbers. Would you like them?
Yes.
So for the one set for arraignment, the trespass is B26 00 6773.
If Your Honor could just give me one moment.
Sure.
State, what was the case number again?
The first one is B 26 006773.
Okay, Your Honor, I was just looking to confirm that case number because the siege printout didn't have that case available.
The court, this case. So the court finds probable cause and is gonna issue, the 150 bond, and I also the stay away order, sir, you understand?
Yes.
All right, thank you.
Placing a hold on his prior misdemeanor case?
Wait, we're gonna keep the hold on the prior, it's open, right?
Yeah, they're all.
Yeah, and there'll be a hold on there'll be a hold on the misdemeanor cases.
Your Honor, you said cases more than.
Yes.
Tell me the case number.
There are 3 cases, Your Honor.
Okay, there's
The
two.
Your Honor,
first one
cases or just-
is
Hold on, corrections is asking, sorry. Sorry, I couldn't hear corrections.
Your Honor, I was asking if there was multiple cases you're holding him on, or is it just this one?
No, I'm gonna hold him on the 3 open misdemeanor cases.
Okay, is state gonna repeat it for us, Your Honor?
Go for it.
Is the state
Repeat.
gonna repeat it for us, Your Honor?
Yes, the first case is B 26 006773. The second
7-2, correct?
73. The second one M 26 006637. And the last one B 25 024 298.
Okay, the next case I have is Travis Movin. You've been charged with 1 count of trespass property after warning. PD, do you have any arguments on this one? Do
My apologies, Your Honor. Can you say it again?
you have any, PC arguments?
Yes, Your Honor. You can just give me 1 second.
Sure.
And Your Honor, if I may, the state will be willing to stipulate to ROR in this case, just to let you know.
Can the state repeat it? So I can't really hear the state very clearly. I don't know if it's just because he's far from the mic.
The state is willing to stipulate to an ROR.
Yes, the defense has no objection, stipulate to an RR.
Okay, but I'm gonna still do a stay, you guys stipulate to an RR?
Yes, we do stipulate to an
Okay,
ROR.
but
with the stay
with,
order.
okay, we're gonna stipulate to an RR with a stay away order, sir. You are not to go anywhere near the address located at 1776 Biscayne Boulevard, Miami, Florida, 33132.
Okay.
The next case is Paul Alexander.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Okay, thank you. So are you Mr. Hall?
Yes.
Okay, you've been charged with 1 count of camping, which is prohibited. I'm gonna read your arrest affidavit to determine probable cause. Okay, court finds probable cause.
Yes, Your Honor. Now the defense is just asking that Mr. Hall be released on his own recognizance as there's no evidence of a flight risk, as he has had prior interactions with the criminal justice system and there's no failures to appear. And the only reason that, the court imposes a bond is to ensure that that Mr. Hall would return to court and appear for his court dates, and he's shown that he can do that in the past.
State,
Your Honor, I don't see any local priors. I don't know if,
there,
do you
there
see
are-
a couple?
there are priors.
I don't know why they didn't pull up here. So anyway, I generally ask for standard bond in this case, but I will defer to you.
Yeah, I'm gonna issue standard bond. It's $150 as PC was determined. $150 was a standard bond. Thank you.
That is.
The next case I have is Raul Ariango. Sorry if I pronounced that incorrectly. Are you Raul?
Yes, yes, ma'am. Arango.
Do you need a Spanish interpreter?
No.
Okay. You're here for a bench warrant. And there's also a stay away order. State?
You mentioned that you was here for a previous bench warrant.
Yeah, it's a
Is
bench
that-
warrant. Sir, there's also a stay away order from 126 Calabar Avenue, Coral Gables, Florida, 33134. You're to stay away from that address at all times. You understand, sir?
Yes, ma'am.
Okay.
I do.
And Your Honor, the state would just be asking that the amount of the bench warrant be placed into the bond amount. He does have a open trespass of structure case along with other priors. So the state would just be asking that the bench warrant amount be set as bond in this case.
PD?
Yes, Your Honor, we're just asking for the standard bond of $150 in this case. If Your Honor would be inclined.
I already paid.
I'll convert the bench warrant into monetary bond of $750.
I have it.
And with the stay away order. Thank you. I can't hear him, but I reduced it from 1,000 to 750. Oh yeah, I did.
Next,
The next case I have is David Gonzalez.
reset NBC.
So it'll be reset for tomorrow, 420?
Yes.
Okay. So the next case I have is Jesus Fernando. Oh,
Your Honor, if I may briefly, the David Gonzalez case, that's reset for tomorrow?
yeah, he was not brought.
Understood. Thank
So
you.
it's reset for tomorrow.
We're going to pass Mr. Galindo and Mr. Perez.
Hold on.
The next defendant should be,
I'm sorry, I couldn't hear you.
we're passing Galindo and Mr. Perez Carlos.
Okay.
Mr. Gonzalez Gill is reset NBC.
Okay. Um, Hold on. Let me write that down. So we're passing Jesus Fernando and Carlos Perez.
Yes, Your Honor, and we're starting with, or we're moving to Hernandez Gomez. It's on page 5 of your calendar.
So, and Jesus Fernando. Jesus Fernando, we're passing. So, they failed to bring him?
Say it again?
Really sad. Okay. Okay, are you Roberto Hernandez?
Yes.
Okay. So in the case, ending in the case 2604-1800-23309 is, that's for bench warrant. Yeah, and it's a bench warrant for, failure to comply. Yeah.
Your Honor,
The
we
fa-
also need, I'm
it's
sorry.
failure to comply with voting regulations, just so you know.
Yes, I'm so sorry. I just realized that we need the Spanish interpreter for this case as well.
Oh, so sorry. Spanish interpreter will need your assistance, please. Is the Spanish interpreter there? Oh, okay. We're gonna need your assistance.
Yes, Your Honor.
Okay, this is for Roberto Gomez Hernandez,
Okay.
and his first case, the one that's ending in 23309 is a bench warrant for failure to comply with a voting regulation.
Okay. Buenos días, señor Gómez Hernández. Estamos tratando su caso que termina en 23309. Es una orden de arresto que se emitió por no obedecer los reglamentos de navegaje.
So the one for the case ending in 0390 is $100.
El caso que termina en 390 son $100.
And for the remaining
Okay,
two,
so this one will be given $100 bond on the case ending in yeah, B2520020390. It will be $100 bond on that case.
Bien, entonces en el caso M25-20390 son $100 de fianza.
For the second case, it's ending in 9059. It's the same thing. It's a bench warrant for the same, for voting regulation. The same-
En el segundo caso, que es una orden de captura por el mismo cargo de desobedecer regulaciones de navegamiento.
And for this one, the bond is $10.
En este caso, son $10 de fianza.
What case is that for $10, Judge?
The one ending in. The
I
one
believe it's
ending in
9059.
That has 2 counts.
I only see one. I know there's another one. I only see one. Oh, I was told by the clerk the other was an infraction and that we don't do anything with that.
Okay, so which count is the bond?
Okay, so
Which
the,
charge?
so the bond on the first one of $100 was the one ending in 55. And the one ending in 860 is $10, and the last one ending in 6618 is $10.
I don't have those.
Yeah.
Your Honor, I don't believe those were the same case
Oh,
numbers.
so sorry. I read the wrong one. I'm so sorry. So sorry. My apologies. So the case ending in 0390 is $100.
Okay.
And that's
and then
count 6 for corrections purposes.
Mhm.
And then the one ending 9059 is $10 and is count 2 for corrections. And the one ending in 11590, and that's count 4, and that's $10.
se ha verificado que en el cargo que termina en 901, $100 de fianza, que en el caso que termina en 059, $10 de fianza, y en el cargo que termina en 590, $10 de fianza.
Yes, Your Honor. At this time, the defense is just going to be asking to ROR Mr. Hernandez Gomez the fact that he has no prior interactions with the criminal justice system, and on top of that, the charges that he's being charged with are simply just voting infractions, and for that reason, we are asking that for Mr. Hernandez Gomez to be released on his own recognizance in exchange to set aside the bond.
Su
And we're getting-
señoría, ya que el señor Gómez Hernández no tiene antecedentes judiciales y además el cargo por el cual tiene la orden de arresto es regulaciones de navegación, solicitamos que le den libertad bajo palabra.
And we're gonna proceed with the standard bond. He has 3 bench warrants and they're not high bonds. They're $150, $10, and $10. So the court stands on its ruling.
Understood.
Thank you.
Debido a que tiene 3 órdenes de captura, uno de 150, uno de 10 y uno de 10, la corte permanece con esas cantidades de fianza. Gracias.
So you said 150?
The first one was 150.
What case is
I mean,
that?
sorry, 100. My apologies, 100.
Perdón, no son 150, sino 100.
So next should be. Are we gonna go back to once we pull it out of order?
So.
Your Honor, what was that next name you said?
Monteagudo. It's on the bottom of page 6.
He refused, Your Honor.
Okay. Will we set this for tomorrow? Unless PD, you want to waive his appearance?
No, Your Honor, we can reset it for tomorrow.
Okay. So the next case I have is Garrett Gaines.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Okay,
I'm gonna pass,
I'm sorry.
pass, Mr. Gaines.
Okay, we're gonna pass it for now. So the next case I have is Jean Marcus.
Your Honor, they're bringing him in right now.
Okay, thank you. Did you guys good? Do you guys need a break? This? Okay.
Thank you, Judge.
Are you, Marcos Jean?
Yes, ma'am.
Okay.
Good morning.
Good afternoon. I'm gonna read your arrest affidavit, but you've been charged with 1 count of resisting officer without violence. And the second count is disorderly conduct. So I'm gonna go ahead and read it. Determine if there's probable cause. Okay, the court finds probable cause on count 1, and the court finds probable cause on count 2.
Your Honor, the defense is going to make a probable cause argument that a reasonable person would not believe that it's more likely than not that the officer had a legal duty to tell Mr. Jean while he was just simply walking on the street with bound bags to step away from the vehicle. It doesn't even explain, the officer doesn't explain how close he was, whether he was even posed a threat to the officer in executing his legal duties. So for that reason, we don't believe that there's probable cause established that the officer had a legal duty in explaining for Mr. Jean allegedly to step away from the vehicle.
State.
Give me one more, Honor. The resistant, you can see the conduct starting on the paragraph is due to the male's resistance and all that. That paragraph summarizes and actually explains the legal duty here. The officers were trying to conduct another traffic stop, and due to safety reasons, they asked the defendant to step away from the scene. So the officers were in their legal duty to ask him to stay away for them to be able to complete the unrelated traffic stop that they were doing. So they do have the legal duty to make sure that they secure the scene.
Your Honor, specifically, but the A form does not establish that he was even impeding on any sort of legal duty. They don't establish how close he was, whether he was walking toward the car, away from the car. On the four corners of this A form, it doesn't even establish in what direction Mr. Jean was walking. And for that reason, this A form does not establish probable cause to establish legal duty, which means that there's no probable cause for resisting an officer without violence.
And it does say here, I gave the male a clear verbal command to step away. He was doing that while he was conducting a traffic stop. He does have the legal duty to maintain the scene. And if,
Yeah, the court finds probable cause. He was trying to need the walkway area clear to conduct a traffic stop, and he refused. So I'm gonna go ahead, the standard bond is 500 on 1, and count 2 is 150. And PC is found on both. The next case I have is Sheen. Hi, good afternoon, sir. Hey. Okay, you've been charged with 1 count of defraud and keeper. I'm gonna go ahead and read your restaurant warrant to see if I determine if there's probable cause. There's no priors on him, right? I don't believe so.
let me double check.
My bad. No, Your Honor, we don't see any priors.
Do you have any arguments, PD?
Yes, Your Honor, at this time, we are asking, well, first, we are establishing that there's no probable cause to establish that he tried to defraud an innkeeper. As part of the statute, they need to show that he intended to defraud by never coming back to pay. That is not established in the safe form whatsoever. He said he left his wallet at the hotel, meaning that he was not looking to defraud this innkeeper, but rather he just needed an ability to go and get this wallet, come back and pay the tab. This officer it's not even provided whether he asked if he was ever going to pay. There's nowhere established in this A form that Mr. Chen was walking out of the restaurant with no intention of paying. He even brought up the fact that his wallet was at the hotel. So for that reason, we're saying that a reasonable person would not find it more likely than not that Mr. Chen was looking to defraud an innkeeper, but rather he just needed the ability to pay, which would just to go back to the hotel and retrieve that wallet. The officer could have been well within his ability to take him and retrieve his wallet. And in the alternative, we are asking for an ROR due to the lack of Mr. Chen's interactions with the criminal justice system.
And he's from Baltimore, is that correct?
Yes, Your Honor.
Your Honor, regarding the intent argument, those are issues that will be figured out at trial, whether he had that intent. But when you look at the A form, he had to pay a tab in the amount of 112. And when they asked him if he had any way to pay for that food, he said no, because he left the wallet at the hotel. You know, intent are issues we will figure out at trial, but in terms of the PC hearing, we do believe there is probable cause regarding this charge.
So how long have you been residing in, or how long have you been, because you said it was at the hotel, so are you living in Miami now?
Yeah.
How long have you been in Miami-Dade County for?
8 months.
I'm sorry, I couldn't hear you.
7 weeks.
And regardless, Your Honor, the probable cause argument still stands. It's not laying out that he had no intention to pay whatsoever. He said he didn't have an ability to pay at that moment, but he was not looking to defraud an innkeeper in the sense of not paying, which is what the statute requires, that he needed to walk out, have no intention to pay whatsoever. That's not what the A form is explaining.
You're here when they asked the defendant, do you have any way to pay the tab? He said no.
And then followed by the next sentence that says my wallet, which would allow him to pay the bill, was at the hotel.
Do you have a permanent address here now, or are you still staying at a hotel?
I'm still staying at the hotel.
And do you plan to go back to Baltimore, or are you planning to stay and reside in Miami?
It depends on different factors.
Your Honor, the state be asking in this case, assuming that probable cause was found, we'll be asking for an elevated bond. The defendant does live in Baltimore. We do want to ensure that this case is taken care of in here. So because of those reasons, even though he doesn't have any trials, we do request an elevated bond to ensure that he does come back to Florida to take care of his case.
Your Honor, there's no reason to. Mr. Chen has not given this court a reason to believe that he would not appear. The state attorney's office is just assuming that for some reason, because he lives out of state, he wouldn't return. There's many people who have open cases in the state of Florida who don't currently reside in the state of Florida, and they're free to come back whenever they please without an elevated bond. An elevated bond is not going to establish that Mr. Chen return, nor is it going to deter Mr. Chen from fleeing, which Mr. Chen has given this court no reason to believe. So for that reason, we're asking that because of the lack of PC in the four corners of the A form, Mr. Chen be released outright. But at the very least, Mr. Chen be released on his own recognizance due to the fact that he has no priors and no interaction with the criminal justice system.
Can you please verify your permanent address in Baltimore for me?
5900 Robindale Road, Baltimore, Maryland, 21228.
Is that a house or an apartment?
That's a house.
I'm not gonna give, since he has no priors here, I'm not gonna give an elevated bond at this time. I'm gonna do I'm gonna do a standard bond just of 150. And the court does fine. There's sufficient probable cause he didn't pay, but I'm not gonna elevate the bond. You guys mail him information for the court date? He doesn't live here. Okay, sir, I just want you to know that everything's gonna be mailed to your permanent address in Baltimore because that's where you live. So I just want to make sure someone's there checking it so you don't miss your.
Okay.
And at that hearing, you explain it. And please stay in contact with the public defender on this case.
Okay.
Thank you so much. The next case I have is Lopez Cruz.
1 second, Your Honor.
No problem.
What was the bond for Mr. Chen? Judge?
150.
Thank you.
Welcome.
Judge, going back to Mr. Galindo, he refused court. He's reset.
Okay.
That we passed.
Okay. What page? Let me go back. Galindo,
Yes, refuse court reset. And we have Mr. Carlos Perez that we passed and Mr. Gaines.
okay, hold on, let me put reset. And on the Jesus Fernando, does a PD want to waive his appearance or you want to reset?
For who?
For the one that refused, Galindo, that refused.
Galindo, is that, that would be on page 4, Your Honor? Yes, Jesus Fernando. Yes, if we could just reset it for tomorrow?
Okay, no problem. It will be reset for 4:20. He refused today. Okay, and who's in front of you now?
Your Honor, this is on page 5 of your calendar. It's Mr. Carlos Alberto Perez.
Okay. Okay, Mr. Perez,
Yes.
do you need a Spanish interpreter or is English fine?
No.
Okay, you've been charged with 1 count of petty theft. I'm gonna read your arrest affidavit to determine if there's probable cause. And of course, PD, let me know if you have an argument.
Will do, Your Honor.
And the court finds a probable cause for petty theft. Do you have any arguments on this?
Regarding the honor, or
No,
regarding.
are you just looking for standard bond?
We would just have kind of one in this case.
Your Honor, you sound low. I'm sorry, I didn't hear what you said.
I said I found probable cause on the petty theft, the court.
Okay, we just asked this court to issue a standard bond of $150.
Yes, standard bond of $150 issued. So 150 standard bond. And also, sorry, and also a stay away order. You're at a stay away from 7480 Southwest 117th Avenue, Miami, Florida 33183. I believe that is Fresco Emas Market. Okay, sir, do you understand?
Yes.
Okay, thank you. I'm gonna write it in here, the name of the
Yeah, thank you.
place. Yeah, of course. So are we going back to Lopez Cruz that we passed?
Yes, Your Honor, I think we're gonna return back to Mr. Gaines. He's on page 7 of Your Honor's calendar.
Hold on.
Your Honor, Joanne Hennessy for the city of Miami Beach in this case.
Thank you. You're Mr. Gaines?
She's asking you, Mr. Gaines?
Yes.
Okay, you've been charged with 1 count of alcohol, open container possession. I'm gonna go ahead and read your arrest affidavit to determine if there's probable cause. Okay, the court finds probable cause to count 1.
Your Honor, I'd ask for standard bond in this case. I don't know if corrections, if there's a misdemeanor hold on M22-24258, the battery from 2022 Miami-Dade County.
You guys want the case number again?
I do have it in here, Your Honor. Let me double check. It doesn't have a set hearing date yet.
What is that? But it's from
2022.
why wouldn't there be a hearing date yet? It's from so long ago.
Would have been Kind of calendar. In the lost
So
in
the
the
case number is M22024-258.
Yes, Your Honor, at this time, the defense would be asking that Mr. Gaines would just be released on his own recognizance.
The state's asking on this one, well, the city of Miami, the beach is asking for the standard bond of $150, correct?
That's correct, Your Honor.
So I'm gonna proceed on this one with the standard of $150, and they're checking the other case to see if it's open. Okay,
Yeah.
okay, so I'm gonna just go ahead. I found probable cause on count one, and I'm gonna do a standard bond like they requested.
Understood, Judge.
Okay, so I'm gonna keep the standard bond just at 150.
Understood, Your Honor.
Thank you so much. And then we passed Lopez Cruz. Are we going back to him or not yet?
You didn't place a hold on Mr. Gaines, did you, Judge?
No,
Okay.
and I didn't place a hold on Mr. Gaines.
Thank you.
You're welcome. Did you get that, PD?
I'm sorry, Your Honor. Say that.
I was letting you know I didn't place a hold on Mr. Gaines,
Perfect. Thank you so much.
of course. So who's in front of you? Okay, yeah, so we're done. Thank you.
Thank you.
So are we gonna go back to Lopez Cruz?
The bond out.
Okay. Can you you're gonna verify Lopez Cruz bonded out?
This is correction, Judge. He's a bond out.
Okay, you bond out. Thank you. Okay, perfect. So the next case I have is Edward Joseph.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Are you Mr. Edward Joseph?
That's correct, Your Honor.
Okay. You've been charged with one count. Wait, you're here on a bench warrant. You feel
That's
to
right, Your
appear-
Honor. This is a bench warrant. I just request that the warrant be converted to a bond.
And the bench warrant is,
Supposed to be thrown out.
and the bench warrant I see here standard is 500, correct? That's what I see in the notes here.
That's what the warrant is, Your Honor. The standard bond for drinking in public is 150, but the warrant is 500.
And you're requesting that it be
The-
converted, the bench warrant into 500 or standard 150?
Your Honor, I'm fine with it being converted to a standard bond. That's fine.
Your Honor, at this time, the defense is just going to be asked that Mr. Allmiller be released on his own recognizance so that he could appear before the court so that the court could set aside the bench warrant. Just implementing a bond would only prevent him from showing up to court to set aside the bench warrant.
Do you have a response, State?
And if this is handled by the Miami.
I mean, yeah,
No,
sorry.
Your Honor, yeah, no, I would defer to you in this case. Actually, I do show that there's some out of county priors. And more recent priors in Miami-Dade County. I would ask for the standard bond.
Your Honor, but the bond being established and being put as a standard bond would only prevent him from going and set aside the bench warrant if he just were to appear to court and stay in contact with the public defender's office. So establishing the bond would be counterintuitive because it would actually prevent him from going and set aside that bench warrant when he can do so out of custody if he was just released on his own recognizance.
Okay, so in this case, the bench warrant is 500, but I'll go ahead and reduce it to the standard bond of 150.
Your Honor, we would still be asking for him to be released on his own recognizance so he can just go set aside that bench warrant without having to pay anyone.
Yeah. Do you have a response?
No, Your Honor. I would defer to you, Your Honor.
Okay, so I'm gonna keep it at the 150 bond. Huh? Yeah, and why did he previously miss court?
Your Honor, he never received notice of the court date. But if we were allowed him to be the opportunity so that we can give him a date certain, I have a piece of paper in front of me with all of the public defender's information where I could write down his next court date. Again, if he was
Does
given.
he have a property address?
No, Your Honor, as stated on the A form, he does not have a certified address. That's why I would be willing to give him a date certain with a piece of paper.
Where does he receive mail or reside?
Your Honor, he said there's a previous address in Ohio, but at this point in time, he didn't receive the notice because he was in Miami at the time. And that's on the impression that I'm under. But as of right now, I can get, if Your Honor were to give him a date certain and release him on his own recognizance, I have a piece of paper here that I can give him his next court date and give him the number to the public defender's office so that he can stay in contact with the public defender's office, show up to court, and set aside the bench warrant for $0.
Let me ask, is he currently homeless at this time?
Yes, Your Honor.
I think I'm gonna put him on the homeless calendar.
Could we just establish that he gets released on his own recognizance so he can set aside this bench warrant?
Yes. Okay, so hold on. So I'm gonna, hold on. So I'm gonna ROR him and I'm gonna put him on the homeless calendar. But I'm gonna give you the exact date and for him to appear. And if he does not appear, another bench warrant will go out and it will not be the same outcome. I hope you explain that to him.
Understood, Your Honor.
So I'm gonna RR on the homeless calendar. And the date time certain is April 23rd at 10:30. At 10:30 in courtroom 6-8, right? So again, it's April 23rd at 10:30, courtroom 6-A.
A or 8?
8.
Okay.
Like the number 8, right? Okay. And again, I'm gonna note it here, but if he does not appear and there's another bench warrant, I'm giving him this time. So please make sure he appears and I ask someone what date it is. But this is next Thursday, just so you know.
Understood, Your Honor. If I can just speak to him briefly and I can explain all of that to him.
Yeah, and if he does get a mailing address at some point, please let him know to contact you and let you know.
Understood.
Okay, thank you. IT, I think there's a few attorneys on specific cases I want to be let in. I just saw one pop up. I don't. Okay, maybe it is.
And Jude, I already
Okay, thank you so much. Are you Edward Joseph?
Good afternoon, Your Honor.
Good afternoon. Are you Edward Joseph?
No.
What's
no,
your?
ma'am.
No, Your Honor, he was reset. This is, I'm sorry, no.
Jonathan Lopez.
Yes.
So what happened to Edward Joseph?
Take it off.
Oh, no, not, I mean the one
Next
before.
offender should be Mr. Blash.
Yeah, Blash.
Reset NBC.
Okay, let me. Okay, so that one was reset, and then you're Mr. Lopez, correct?
Yes, sir. Go ahead, say yes.
Yes, ma'am.
Oh, right here.
This case was added for Mr. Lopez.
Okay. Thank you so much. Okay. Sorry about that. Okay, so now we're on to Mr. Jonathan Lopez, right? Yeah, that's what they said. Is that Mr. Lopez in front of you?
Yes, Your Honor, this is Mr. Jonathan Lopez.
Jonathan Lopez.
Yes. The case right before his, Blash, that one was reset.
So the clerk is telling me that he has a hearing date of April 21st.
Judge, you don't have M25-19953 on calendar for Mr. Lopez, Jonathan?
Let me ask the clerk. Yeah, there is, because I think there's a bench. You have no, you don't
It's
have
a
any.
bench warrant.
It's a bench warrant. I see it.
It's the only case on calendar for him today.
Yeah, it's a bench warrant. Hold on, they're checking the clerk.
Understood, Your Honor.
It's a bench warrant.
Yes, I see bench one.
I just need a pipe. I just need to know.
No, we need a break.
Did you guys do anything to eat tonight? You guys want a break after this? Are you doing felonies, right?
Yes.
After this.
Yeah.
Okay.
Thank you,
Just
Judge.
let me know how long you guys need.
Thank you.
Yeah, but he's here for the, they're agreeing, and it's on calendar here for the bench warrant.
It is,
The clerk is telling me it's not in bench warrant status. What?
What are we doing with the case? Are we resetting the case, Judge?
It's,
We're
it's,
asking for him to be ROR'd under that circumstance.
okay, it's,
Or right.
wait, hold on, he has a case for April 21st, they're telling me in room 6-5 at 9:30.
That's on which case?
On which case is that? On ADQJZ
He's not
70.
here for that case, Judge. He's only here for the M25-19953.
Yeah,
Yeah. I do see a couple of bench warrants.
hold on, they're trying to pull it for me.
Two cases, juveniles.
So, okay, they're saying, the clerk is saying they don't have it. I don't,
Hey, I'll just reset it, Judge, for tomorrow.
okay, we'll just, they don't have it on the calendar. We'll reset it for tomorrow.
Thank you.
Your Honor, can he be released on his own recognizance as he awaits, especially if he has a court date for the 21st?
They want to know if he can be, like, released. Because there's a court date on the 21st.
This is Thursday.
Yeah, he can't be released because there's a misdemeanor case. Do you want to, why they try to figure this out? Do you want to just pass it for a minute just to see so we can move on?
Yes, Your Honor, that'd be amazing. If we could just pass this briefly.
Yeah, because
figure this out.
I personally don't know the whole, or whether on calendar or off. So,
Perfect. Thank you so much.
yeah, of course. So the next case I have is Winston Johnson. Okay.
I don't know if we'll pause and do those or finish this.
What?
Who you calling now, Judge?
Okay, so I was told that we're gonna have to pause for a minute because I have to go upstairs because there's 2 delinquency cases at 1:30.
How many cases for juvenile?
2.
Your Honor, I believe that's the end of the misdemeanor calendar essentially, or certainly the end of.
No, no. Misdemeanors, yes, but not traffic. So yeah, for the
Right.
misdemeanors, it is.
So I'm only
We
here for the
could-
misdemeanor portion of the calendar, Your Honor, if I could be excused.
Yes, of course.
Thank you. Good day.
This is super-
I did bonds once
Recording
before,
stopped.
so
Yes, I did it.
sure what-
Okay, so I'm told that I have to go upstairs to do the juvenile, so I guess it will take like, we'll take a break, maybe it shouldn't be more than 20 minutes. We just have left here some traffic.
Okay, understood. That's fine, Your Honor.
Okay, and then hopefully they'll try to work on the Jonathan Lopez issue. to
Yes,
see.
please.
All right,
Counsel, can you hear me? How you doing? My name's Jude Faccidomo. I'm a private attorney. I was wondering if you had access to the A forms. No, I can't hear you. I think you're muted. It's for Ryan Butler. It's a felony on the afternoon calendar. Yeah, I think they have you muted, counsel.
We're back.
Recording in progress.
That was very, we're not on the record. That was just very short that they didn't bring the juveniles yet. So we're gonna have to, so we came right back down.
Okay.
So we might have to go again. Should we let them?
Recording stopped.
Hold on. I'm gonna try to see. The clerk probably thinks we're gonna be gone for 20 minutes. Hold on 1 second.
And we are, just for the court's notice, we are going to be needing the assistance of a Spanish interpreter as well.
In which case, and who are you on?
That's Mr. William Lazaro Ceballos.
Recording in
Cote.
progress.
The interpreter's present, Your Honor.
Okay, we're not on the record yet. Hold on. I need the clerk here.
Okay.
Check, are we back on the record? Yes, ma'am. Okay, we're back on the record. PD, we got the Jonathan Lopez file. So can we go back to Mr. Lopez?
Yes, Your Honor.
Okay.
Pala pa fuera.
Mr. Lopez, do you need a Spanish interpreter?
No, ma'am.
Okay. So this is for case M2501993. May I just see here, this is for the bench warrant of 1,500, correct?
That is correct.
And what's the bench warrant exactly? Let me see what it's for.
It's the court date for Friday.
What is the bench warrant for?
It seems that it's because
It's a boat registration case, Your Honor.
voting infractions.
The vessel was registered.
All they are. Most of the time.
Yeah, hold on, okay. In this, yeah,
Amy,
okay.
what was that? Right.
I'm actually trying to figure out why the amount, why the bond here says 1,500 for a boat, for the boating. Because the other one was not 1,500 previously that I did, and I'm asking the state. If you recall, I did another one for boating.
Okay, yeah.
And I believe there's no. So state, what do you want? Do you guys want to go back to the original?
Your Honor, let me double check here. Yeah, the.
It says he failed to appear, so he failed to appear.
Yeah.
It says 3 counts, but.
You know, I'm gonna go back to the.
Yeah. The other boating case that we did earlier.
Yeah, but that's not his. I mean, Your Honor, at this time, the defense is just gonna ask that Mr. Jonathan Lopez be ROR so that he can set aside this bench warrant for free. As we can keep in stable contact with the public defender's office and Mr. Lopez, so that he can go before the court and just have the bench warrant set aside. You say you can.
He has no priors.
Yeah, Your Honor, I will go back to what we did previously, and I'm just gonna do 100 in the, I guess in the oldest one of the bench warrants, or are we just
Do
dealing?
110 and 10?
110.
So we're gonna do on the first one, I'm not gonna go by the benchmark and count on the first count, because there's. Okay, so then we're gonna just do it was 100.
I just 100.
We're gonna do 100,
So $100 bond?
$100 bond
What count is that for? Which charge?
for count 1.
Voter registration?
Mm,
Yeah. Fail to comply.
Yeah, hold on, the clerk's double checking. Yes, it's count 1, and I'm gonna issue the same $100 as I did in the previous case for the boating. So it's a $100 bond,
Understood, Your Honor.
and that's what the state stipulated to
Yes,
that.
no.
The state has no objection,
Okay, perfect.
so $100.
Thank you so much.
Thank you. So the next one I have on my list is Winston Johnson. I have Winston Johnson if we're going in order.
He's a bond out
Okay,
and it's 100.
so he's a bond out, okay.
Bond out.
Yeah, that's fine.
Okay, so he's a bond out, and then. Oh. So he was a bond out.
Bond out, yeah.
And then is this Jackson?
Mr. Jackson, Cedric is off calendar.
Okay. So it's not in my packet here?
No, it's not.
Okay,
Rodriguez Lizandro is off calendar.
Rodriguez Lozando off calendar, okay. And what about Anthony
Off calendar.
off calendar, okay.
Perez Hernandez is a bond out.
Perez Hernandez bond out, okay.
Marrero Morales is a bond out.
Hold on. Bond out. Okay, so the next one,
Paris or not bond out?
and Hernandez, Ross bond out. Okay. So then the next one I have is, I would have here, it says Rami Mitchell. What about this one? We did this one?
No. That was a bond out, Your Honor. If it's Romaine.
Yeah, bond out.
Mata Morales, yeah, that was a bond out. And now
Okay.
we're at Williams, Lazaro,
Okay.
Ceballos, Secoto.
Okay,
And just to confirm, Your Honor, if I may briefly, Julio Perez Hernandez, bond that as well.
Yes, on now.
Understood. Thank you, Marcos.
Okay, so this one, we're in case number, does he need an interpreter? or
Yes, Your Honor, this was the individual that I requested the interpreter for.
Okay, interpreter, we need you to confirm that this is William Lazaro.
Buenas tardes, señor Lázaro.
Otra vez.
Buenas tardes.
Good afternoon.
And this is case AMIDSZE.
Para el acta, el caso es el 8AIBSDE.
And you're here on a bench warrant, and you also failed to appear at the hearing at arraignment on March 6, 2026 in front of Judge Nelson.
Y tiene una orden de arresto por no haberse presentado en la corte en marzo 6 del 2026.
And it says the bench warrant here is for $500, no motorcycle driver's license.
Dice que la fianza son $500 por no tener la licencia para conducir motocicletas.
And Your Honor, the state will be willing to close this case out with credit time served.
Su señoría, la Fiscalía del Estado está dispuesta a cerrar el caso con crédito por tiempo cumplido.
Your Honor, if I could just have a brief second to speak to my client.
Of course. William Lazaro was a bond. We did it for you. No, we're on it. Oh, yeah, but he has two?
Yes, he has a new case.
Oh. He has two cases.
Two cases?
Yeah. Huh?
Close both.
And there's two cases, PD. There's another case too for him.
Is that same offer on the table to close out all the cases?
And let me,
Yes, we can close both of them with credit time served.
Son dos casos de hecho y queríamos saber si la oferta es para ambos casos, si se puede hacer la oferta para ambos casos.
and just for the record, the second case is AN, the number 4, CYUE.
Y para el acta, el segundo número de caso es AN4CYUE.
Okay.
It'll close. He's waiting. You guys need more time?
Your Honor, at this time, this offer is rejected, and we're just asking that a bond be set.
En este momento, su señoría, rechazamos la oferta y solicitamos que se imponga una fianza.
And Your Honor, instead, this time we request that the bench warrant amount is set for bond.
Um,
So
uh,
the, sorry, go ahead.
that the bench warrant amount, what, I'm sorry, state.
Bench where amount will be the bond.
Ok, entonces en este momento solicitamos, dice el Estado, que la cantidad de fianza sea por la cantidad por la cual se instituyó la orden de arresto.
So in the first case of AMIBSZE, the bench warrant is 500, so it'll be converted to a monetary bond of 500.
En el primer caso, 8A y BSD, $500 de fianza.
Is that okay?
Yes, Your Honor.
Okay, and in the second case, AN4CYUE, the bench warrant amount is 150, which will then be converted to monetary bond.
Y en el segundo caso, AN4CYUE, son $150 de fianza monetaria.
Okay, sir?
Ok, señor.
Thank you.
Gracias.
The next case I have is Alexander Valero. Does he have any?
Checking right now, Your Honor.
One second, Your Honor, my apologies.
No problem.
Your Honor, we are going to need assistance of the Spanish interpreter for this case as well. And at this time,
Is this
Miss-
Alexander Valerius?
yes, Valer Vales, yes.
Okay,
Buenas
And at this
tardes,
time-
señor Vales.
Buenas tardes.
Good
and
afternoon.
this is for, this is a bench warrant in case AMLNEOE. The bench warrant amount showing here is $1,000 failed to appear for arraignment on January 28th, 2026 in front of Judge Melendez.
Bien, señor, se encuentra aquí en el caso AMLNEOE. Tiene una orden de arresto por $1,000 por no haberse presentado para lectura de cargos en enero 28 de este año frente al juez.
And Your Honor, at this time, Mr. Valero Valez is also going to be representing himself. He receives the assistance of the Public Defender's Office.
En este momento, el señor Vélez se representa a sí mismo, ya que ha rehusado el servicio de los abogados de oficio.
And Your Honor, the state offers also gonna be a credit and to close out the case.
Bien, en este momento la Fiscalía del Estado le ofrece crédito por el tiempo que ya lleva cumplido.
Is the public defender being discharged on this case?
¿Se retira entonces el abogado de oficio en este caso?
Your Honor, if I could have 1 second.
Okay.
Un segundo.
I'm here for felonies too. There's more than that, people.
Your Honor, my apologies. The Public Defender is being appointed on this case.
Okay, so the state offer was credit for time served to dismiss it.
Mi disculpa, el abogado de oficio ha sido nombrado para que lo represente. La oferta del Estado ha sido crédito por tiempo cumplido para desestimar,
To close it out.
To close it out.
para cerrarlo.
And Your Honor, he will, at this time, Your Honor, he's going to be rejecting that offer and he's going to be asking to establish a bond.
En este momento, él rechaza la oferta y solicita una fianza.
So then, Your Honor, the state will be asked that the bench warrant amount of $1,000 be converted into cash bond.
Ok. Entonces, su señoría, solicitamos que la cantidad de la orden de captura de $1,000 sea convertida en la fianza monetaria.
So, do you accept so that means the bench warrant will be converted to $1,000 bond?
That's fine, Your Honor.
Eso significa que la orden de captura se convierte en $1,000 de fianza. Está bien, su señoría.
Okay, thank you, sir.
Gracias, señor.
And the next case I have is Angel Perez Nunez,
What was the bond amount, Judge?
1,000. Angel Perez Nunez. Are you Mr. Nunez?
Yes, I am.
Do you need an interpreter or is English okay?
Yes, Your Honor, we're gonna need an interpreter.
Okay.
Interpret person, Your Honor.
Okay. Can you please confirm he's Angel Perez Nunez?
Buenas tardes, señor Ángel Pérez Núñez.
Ángel Horacio Pérez Núñez.
Ángel Horacio
Horacio Pérez Núñez.
Pérez Núñez.
Okay, we're here in case AMU 1GFE, and this is a bench warrant for no driver's license for $1,000. And he also failed to appear for trial, which was set on March 24th in front of Judge Rohaidi.
Bien, señor, usted se encuentra aquí por un caso en el cual le imputan no tener la licencia de manejar AMUGIE. Tiene una fianza de $1,000 y también ese caso se trataba de venir a juicio al cual usted no vino, marzo 24, frente a la juez Johairi.
Yes, Your Honor, it's the defense's position that it was not willful, and we're just asking that he be released on his own recognizance so that he could just set aside the bench warrant for free instead of having to pay the financial bond.
Su señoría, no fue una razón intencional, por lo tanto solicitamos que le den libertad bajo palabra para que él pueda ir de por sí a retirar esa orden de arresto sin pagar una fianza monetaria.
And if I can have a moment, I do see that there seems to be an open felony. Just want to make sure whether this predates.
He's
this
on the
case.
bond hearing calendar next.
He's on the felony hearing.
So, you know, because of the reason we'll be asking for a felony hold because of the felony. That is all.
Bien, acaban de anunciar que usted también tiene un delito grave a continuación y la Fiscalía del Estado solicita que le retengan ya para el caso de delito mayor.
So he's gonna have a felony hold.
There's no hold, Judge. That case will be addressed on the bond hearing calendar next.
Okay, there's no hold. It's gonna be addressed next.
No existe retención por delito mayor, sino que va a estar en la agenda de casos de delitos mayores a continuación.
So then you're, because of the felony that it is coming up, now the state will just be asking that the $1,000 bench warrant be converted into a bond amount.
Debido a que tiene el delito mayor a continuación, la Fiscalía del Estado solicita que la cantidad de la orden de captura sea convertida en la cantidad de pagar de fianza.
It's a possession of cocaine.
State, sorry, PD, anything you have to say?
No, Your Honor, we stand on our previous argument.
Okay, I will lower I'll convert the bench warrant to monetary bond and I'll lower it to 500.
Convierto la cantidad de orden de captura en la cantidad de fianza y la reduzco a $500.
Okay, the next case I have is Israel Brown.
Refuse, reset.
Okay. Refuse, reset, or 420. Unless, are you going, PD, are you gonna waive his presence or you wanna reset it?
Reset it for tomorrow, Judge.
Okay. will be reset. Right. The next one I have is Samuel Romero.
Ma'am, can you hear me?
Are you Samuel Romero?
Yes, ma'am. Can you hear me?
Yes.
Okay, I'm sorry.
So do you need a Spanish interpreter?
Interpreter? No, I speak English.
Okay, perfect. So we're here in case AN1MADE, and this is for reckless driving, damaged property person, and there's also a related felony case, right? It appears
Yes, ma'am.
on the next calendar. And the standard bond for this, I believe, is 500 for the reckless driving.
Let me double check, Your Honor.
Bond 500, Judge?
That's what it's showing.
If it's that's the way.
Yeah, standard bond of 500. And we'll address the felony at the next hearing.
Understood, Your Honor. Yes, ma'am.
Thank you.
Is that it? Yeah.
So the next one is Julian Marcus.
That's you.
Hello, ma'am.
No, this is case. They're ready. Okay, we have 2 more cases here. So should we just finish this? Okay. Okay, this is case number AMGRIEE, and this is a bench warrant for $1,000 for failure to appear at arraignment on 4/8/2026, and this is for a no motorcycle driver's license.
Yes, Your Honor. The defense is just asking for an ROR to allow him to appear before the court to set aside his bench warrant instead of having to pay.
Moment, Judge.
Does he have any?
No priors.
I'd also like to make a note for the record that he has no priors or no previous interaction with the criminal justice system. So he would be able to appear and just set aside this bench warrant for free.
But we're only addressing 1 bench warrant. No, there's 2. There's actually 2 bench warrants. And the second bench warrant is for case AM8CJ7E, and that's no driver's license. And that bench warrant's for 1,000. It's failed to appear for arraignment on April 1st, 2026. So there's 2 bench warrants, both are for $1,000. Okay?
You know, the state will be, can offer credit time served to close both of these cases.
The state's offering credit time served to close both of the cases.
1 second, Your Honor.
Okay.
Yes, Your Honor. He'll be accepting the adjudication credit time served to the no valid driver's license.
Okay.
Your Honor, I believe you're muted. I don't hear you.
No, okay, so he's accepting credit time served on both the cases?
That'd be the no valid driver's license ending in 7E.
And what about the case ending in E?
What, 5E, Your Honor?
The no motorcycle deal. That's case AMGRIEE. And
Yes, Your Honor.
and the state's willing to do the same thing, credit time served on both.
That is, yes.
Yes, Your Honor.
And there is infraction tickets with this as well.
And we're asking the court be inclined to dismiss the civil infractions?
Your discretion.
Well, there's several. 1, 2, 3, 4, 5, 6, 7, 8. There's 8 civil infractions.
Yes, we're asking that the court would just be inclined to dismiss the civil infractions in exchange for taking the adjudication CTS in both cases.
State? Yeah.
Usually with infractions, because we don't have jurisdiction, we don't make any recommendations, but Your Honor, if you want to dismiss, that will be up to your discretion. The state has no
Okay.
comments.
And he has no priors?
No, Your Honor.
No.
Okay, so 1, 2, 3. Okay. Yeah, I'll go ahead and, do you want to go through each of the infractions, the numbers?
No, Your Honor.
For the record?
Yeah, you can just make it clear in the record that all civil infractions attached to this case are dismissed.
No, I'm gonna have to read each number for the record.
Okay, that's fine.
Okay, so the first one is AM8C2GE infraction, civil infraction is dismissed. Okay. The case in AM8AJVE will be dismissed. The civil infraction. The case AM88JSE, the civil infraction will be dismissed. The case AM8CJ3E, civil infraction will be dismissed. The case AM8CZ3E, the civil infraction is going to be dismissed. The case AM8CYZE, the civil infraction is going to be dismissed. So that was 3, 6. There's 2 more, I believe. Case ALRNZUE, the civil infraction will be dismissed. Case AM8AJAE, the civil infraction will be dismissed. Because on the other 2 charges, the defendant took the state's offer for credit time served.
Thank you, Your Honor.
You're welcome. And I was just informed to sign that we're closing this out. So that he gets it? Oh. The PD gets $50 for closing it out. I was just informed. I did not know. Okay.
I think that's just a normal fee for the public defender. John.
Yeah, I didn't know that.
Okay.
Okay, thank you. So we're done. So I closed out all the civil infractions, read them for the record, and then does he did credit time served on the other 2 cases?
Perfect.
Thank you.
Thank you. I'm good to
And
go.
next,
Thank you, brother.
Fernandez.
Morris is the next one?
Morris bonded out, Your Honor.
Bonded out.
We're on Fernandez.
Morris. So Morris found it out. Okay. Fernandez. My order would say next is Luis Alberto Fernandez.
Yes, Your Honor.
And what about let's try next. And then there's 2 more. Okay. So you have several. So the first infraction is DWSL knowingly, that's $150. And that's case number ANG4WUE. And the next one is ANI0ZNE, which is another $150. The tag was not assigned. And then The next one in this stack is AN, the number 1P20E, and that's $1,000 DUI damaged property person. And state, what are your positions?
The state will be requesting, in this case, an elevated bond. The defendant has a previous DUI in 2015.
So what are you requesting the elevated bond be for the DUI?
One moment. Is bond that you have there $1,000
Yeah.
for the DUI? We'll just have 100.
Okay.
I didn't hear that last statement by the state.
Since he had a previous DUI, the state is asking for an elevated bond from 1,000 to 1,500.
At this time, the defense is just asking for the standard bond of 1,000 as the judge had stated previously.
So on the case ending in ANGFWE, it'll be 150 bond.
Which case was that, Judge?
The one ending in WUE. ANG4WUE. The next one, the case ending in AN, the number 10SNE, would be the standard bond is 150. The next one of the DUI, the case AN1P20E, the DUI, the standard bond is 1,000.
He has 5 more cases.
Yep, I see that. So we took care of those 3. Now next is another case ending in A9KUMCE. That's the DUI for 1,000. The next case is ANG4WOE, and it's the DUI test second 150. And the next one is case AN1P2CE, $1,000 DUI damage to property and person. State?
The state will be just requesting the standard bond on those other charges that you have in there.
Including the DUI?
Yes, Your Honor. DUI.
And do you have any
That's
position?
Your Honor.
Okay.
Standard bond.
Okay, so standard bond for the one ending for A9KUMCE will be $1,000. The case ANG4W0E will be 150, the standard bond. The case AN, the number 1P2CE will be $1,000, the standard bond. Okay.
Yeah. You set the bond for the case ending in 1SE? It's 1SE and HZE that I don't have the bonds for.
Well, I think those are doing right. I haven't done those. I believe, right? No, I haven't done those yet.
Okay.
Okay, so now the next one is AN1P1SE. That's a DUI. It's 1,000. And the next one is ANG3HZE, which is LS financial suspicion, and that's 500. Do you have any position on this date?
None of the state doesn't have any objection to those amounts.
Standard bond is perfect, Your Honor.
Okay, so we'll issue $1,000 bond on the 1A and 1P1 SE, $1,000. The one ending in ANG3HZE of $500, the standard bond will be issued. And then, is there one more? Oh, so sorry. Sorry. Sorry about my mistake. Okay, so I think he's all done. So are you Stephen Gerald?
Yes.
Okay. Stephen Gerald. This is, I see here that it's a bench warrant.
Yes, Your Honor. At this time, the defense is just asking to be released on November cognizance so that he can appear and set aside the bench warrant in court.
And this is AMW17FE. Okay.
Judge.
And also for the record, he has no priors, Your Honor. And so for that reason, we are asking again for an ROR so that he can just go get this bench warrant set aside in person.
And the bench, wait, I apologize. For Stephen, I had the wrong, no, this is the case when the bench warrant here is saying $3,000 that he failed to report on February 26, 2026. Yeah.
And the state will be offering an offer to close out the case if ready time served.
Yes, Your Honor. He'll be accepting that.
Are we accepting it?
Yes.
Okay, so in case AMW17GE, the state is offered to close out the case for credit time served and the defendant accepted it, correct?
Yes.
Okay. And there's also a related infraction. And there's a related infraction, AMW17FE.
And we're asking that Your Honor just dismiss the civil infraction.
Do you have any objections, Dave?
No objection.
Okay, so I'll dismiss the civil infraction. And then I'll dismiss the civil infraction.
Perfect, Your Honor. Thank you.
And then the, I believe Oscar Cortez bonded out.
Yes, Your Honor.
Okay. And then there's one other case. Okay, so he's finished.
You're good to go.
So there's one other case from earlier, the Juan Marcos Platt, he was no motor cycle bench warrant for 1,000, but there's also another criminal infraction.
What page of the calendar was that on, Your Honor?
It's a criminal ticket. It's not on calendar. The clerk is asking, do you want to reset it or to close it out? Let me.
What page is Mr. Platt on?
Let me look.
What charge is that we're talking about?
Page 12.
What's the charge?
Oh, it's for a criminal infraction.
Oh,
Oh, where he took Julian Marcus Platt, he took an adjudication and all civil infractions were dismissed.
He said it, wait, they said that he took a credit time served.
Yes, and all civil infractions were dismissed as well.
Right, but this is a criminal infraction, that's why. It's a criminal ticket.
What's the, do you have a case number?
The case is AMGRIDE.
And the second one, M as in mom,
Yeah,
motor vehicle. Yeah, we can close it out, the same credit time served, well.
okay, so the state says close it out with the credit time served. Is that what you had it already?
Your Honor, we just had the adjudication of credit time served for what we spoke about earlier when we addressed this case first. I don't know if this case was involved in that.
It was not.
Okay, so then for purposes, just to be safe, then we're just asking if the state would be inclined to ROR him on this so that he can appear before the court and just address this case while his other cases took the adjudication credit time served.
Yes, we can stipulate to our.
Okay, so the state has stipulated to RR on this one.
And what was that?
Custody on it anyway, Judge.
I'm sorry?
He's not in custody on that case.
Oh, okay. So he's not in custody on the case.
No, okay.
Yes, okay.
Mhm.
So. Jason, right? Okay, so I think we're done with the misdemeanors.
Yes, Your Honor.
And are they ready upstairs? Okay, thank you.
Thank you, Your Honor. Have a great day.
You too.
Recording stopped.
Yeah, I'm gonna check the rest. Do they have any holds or anything like that? Yes, he says, right?
I mean,
No, but I.
listen.
Because he wanted to close it, but he was like saying, I thought we closed it. Oh. That's why I have her see the case.
We're about to start fun.
Special ed. You're special. That's it? Yeah, she does. I'm taking with her.
Oh, okay.
Because of the.
Okay.
Yeah. This guy? No, he was supposed to get that. Overturn it to life.
Yeah, but what I'm asking is, he's been here all of this time.
He came back.
Oh, he came back on up, you know, okay.
That's when you look at the jurors like, don't fuck. And it's all because she broke up with him. The mama didn't want to be with him and took the girl and slid her throat with people.
Yeah, he's an asshole.
Yeah, and he's an asshole. So it's even.
I was trying to. How you calling?
I heard about that story. So he said, so he just pretend nothing happened. Oh, okay, so it's like a Casey Anthony story, but you know that's what. Which one? That? No, it wasn't. It's not a good Casey Anthony. Casey Anthony got out. He made it out, and then her family covered it up. Yep, I bet you the dad, maybe not the mom, but the dad.
Well, they don't, you know.
Put alligator alley, child for
Did you ever find wrong?
Yes. Oh, okay. Go ahead, ready.
And we have a couple of people before they turn purple and blue. Black and blue.
Yeah. Right now, you wouldn't go earlier, you weren't ready. Now that you. That's why it's simple. Yeah. All right. Is that here? Here in Florida? So 11-1, so that means 11 jurors out of 12 say fuck yeah. And then can you overturn that with a? Oh, this one that held that whole thing with the like no, the life sentencing stuff was put on hold for a little bit, right? He was 18. No. Also, everybody has. That's still in the thing. Bro, y'all haven't done nothing since I left. Did you get that information?
So that's the reason why he was able to bring it back.
You still there too? Yeah, I'm doing a double bump. Yeah, bro. Going out.
That's how they gonna do it. Then that you need to say, you know.
No, her car is here. I gotta pick the box. What the fuck? They taking a break? They on break? What the hell going on? That road is acting like Alonso. Alonso just get shot for no reason. Yeah, he was there with Alonso.
Well, they said the case. So how is her?
Y'all know they twins right now.
Well, she was get out of the quiet and put out.
You just walk these wrong time. Just in the car with a buddy, bro. Matter of fact, we have to jump first.
Sorry, they are really.
Damn, bro.
You need to know how to design. Anybody could be an extra person. After the fact, after you learn how to.
Sure. What's the? I'm sorry. Okay. I was like, I'm sorry. Like.
So now. You should do it. I know you want the reset, then that would be easy. I mean, you got to, there's gonna be 100 reset, so you gonna dock your 5 things? It's a work in the damn phone. This is a whole nother world. And
Yeah, he said.
oh, what's she doing? Hey, friend, I was there. She started at she's actually right. Probably nobody. She's and most people.
AT, are you there? The case that's for Ryan Butler, is that an attorney that wants to be, or is that like a victim?
Your Honor, this is Jude Faccidomo. I'm an attorney. I
perfect.
represent. How are you?
I just want to make sure you were let into the Zoom.
Yes, ma'am. I actually don't know if he is printing on the afternoon
Recording
calendar.
in progress.
Oh,
I was told by TGK he might be on the morning calendar, but he was booked at 3 a.m., so I would expect him to be on this afternoon.
this is the app. No, this is the app. We're starting from, his name is it's F267666 Ryan Butler. F26-7666. They're gonna check right now.
Okay. Hey, Kim.
Who's the defendant?
Oh, wait, they're saying that corrections in
Your Honor,
he's gonna be on the defense or tomorrow. He got arrested at 3 a.m.
He was actually booked at 3 a.m., Your Honor. He was arrested much earlier, so.
Your Honor, who is the defendant? Who's correct?
Okay, so they just told me, the clerk just told me that he's not on the calendar. He'll be on for tomorrow.
So, Your Honor, as I'm sure you're aware, under the rules of criminal procedure, he needs to be brought before a judge within 24 hours. So unless we're having a 3 a.m. calendar, I think we need to get him in front of you today.
That's not how that works. He didn't print on today's calendar. It's for tomorrow.
Yeah, but he was booked at 3 a.m. So again, under the rules of procedure, he has a 24-hour window to be brought before a magistrate to address the bond.
There's a cutoff period at 1 a.m. He came in after the cutoff period. That's why he gonna appear tomorrow morning calendar.
Yeah, unfortunately, corrections internal processes don't affect the rules of criminal procedure.
Hold on, the states, are we on the record? Okay, the state is gonna look into that right now.
I appreciate it. Thank you, State. Thank you, Your Honor.
You're welcome. It's classy. Yeah. So don't even look. So would you guys? Thank you.
Special privileges, yeah.
And they're gonna check now, and then we're gonna start. They're gonna.
Can we start a calendar, Judge?
I was informed by the clerk, it's gonna be tomorrow morning, because it's on the domestic calendar. Oh, it did, they said it did not make the cutoff. Okay, you're on mute. You're trying to talk.
Sorry, Your Honor. I heard you, and I understand corrections has their process, but 3.130A requires him to be brought before a judge within 24 hours. So again, that would be, he was arrested, my understanding is he was arrested late evening, booked at 3 a.m. Either way, unless he's brought before Your Honor today, then we're gonna have to file a writ at the 3rd, which by that time, it'll resolve itself with the morning calendar. So he's in a no man's land. I understand he's sitting in TGK in the booking area right now. So I would suggest.
I have a quick question. Maybe I'm like totally wrong, but if he got booked at 3 a.m., that's today, like, so that's this morning. So technically tomorrow he could go in front of a judge.
He was arrested at around 11, Your Honor. When he was booked was 3 a.m.
hold on, the state's gonna talk to you because this is, can you talk to Justice Attorney? This, we're on the record, the state's gonna talk to you guys.
I mean, my understanding is that happens all the time, splitting hairs over a matter of like hours. I don't think, if he wants to change the rule, that's strictly and file whatever he wants. It's not, I don't think it'll make any difference, but go ahead. Like, we cannot do anything about addressing this. Not gonna happen.
So, Your Honor, with respect to the state, I'm not splitting hairs. The rules of procedure are the rules of procedure. And a defendant's liberty is at stake here. So the rules are designed exactly for that reason, to protect this issue. So again, even if he was booked at 3 a.m., 3 a.m. Monday morning would be 24 hours. I think the simpler fix is for him to be transported from the holding area to have a bond hearing in front of Your Honor.
Corrections, when is your cutoff?
1 a.m.
The cutoff is 1 a.m. and it was 3, and you said it was 3 a.m. that he was booked.
So, Your Honor, corrections cutoff is irrelevant. Under 3.130A, it requires that any defendant be brought before the court within 24 hours of arrest. So again, unless I'm misunderstanding.
I do understand the rule, but I don't know I haven't had the specific happened to me. I mean, what is the state?
Judge, we don't have no file, paperwork, jail card, none of that.
They don't have, corrections is saying they don't have the paperwork, and the state's saying he'll be heard first thing in the morning.
No, I understand, Your Honor, and I get that this is
out of my control.
Respectfully, Judge, you're the judge. You can order whatever you want. If Your Honor's telling me that there's no way for him to be brought before the court, then
do you even have the arrest form yourself?
I do not, Judge, but again, that's not really my concern right now. My concern are in terms of release.
But in terms of like, if I don't have the arrest form and you don't have the arrest form, like how can we even argue probable cause for the state or the defense?
And again, Judge, I don't mean to be a broken record on this point, but all of those are ancillary issues to what's the governing rule. So the fact that the process has been delayed somehow is really irrelevant to the fact that under the rules of procedure, he's required to be brought before you. So I can't speak to corrections process. I can't speak to the state's belief that, you know, a matter of hours is irrelevant, because I very much think Mr. Butler would argue differently. And I can't speak to where an A form is or how a probable cause determination is to be made. What I can say is that the rules are the governing predicate here, Judge. So I think that's the issue. So if the court is telling me it won't be till tomorrow morning, my remedy is a writ of habeas corpus to the 3rd, which seems like an awful lot of work to do when he can be brought down the hallway.
No, but I mean, give me a second. We're gonna.
And state, I don't know if you can hear me. I know we're off the record, but it's a 3rd-degree felony. I will stipulate to a standard bond and a stay away order. And that might be the best way to address it.
Sorry, give me a minute, sir, and I'm gonna go back and forth.
Yes, ma'am.
Okay, thank you.
Recording stopped. Recording in progress.
Sir, which is the attorney? Which case?
Are you asking me, Your Honor? Jude
yes,
Faccidomo. How are
And
you?
which is, and which case you're on for Ryan Butler?
Yes,
F26?
ma'am.
Okay, we're back on the record. So this is, I'm speaking to, can you make your appearance?
Jude Faccidomo on behalf of Ryan Butler.
And this is case F26-7666. I spoke to our administrative judge in this case, and her name is Lodi Jean. She's administrative judge.
Yes, ma'am.
And there are certain circumstances that you could have 48 hours and that this issue is not even right because to even be discussed now, it hasn't even been 24 hours yet.
I understand that, Your Honor, but
So the
again, it
issue's
will
not
be
even-
it's one of those issues, if we think back to law school, capable of repetition yet evading review, because come 3 a.m., it will be ripe, and hopefully none of us are still working by then. I am not familiar, and I know Judge Jean practiced before many times.
Right, and she
and
wanted
I
me to make
trust
sure I
her.
put, she wanted me to make sure I put her name on the record, so I was like, okay, I'm gonna go, because she's the administrative judge for criminal, so I called her and I told her that your situation, and I do know the 24-hour rules, and I know it's close in time, and she said specifically, you can put my name on the record, and that there's, and that you could, if you want, file your motion, but there are circumstances that they could be brought within 48 hours, and the exact statute, she did not have at the moment.
Yeah,
but
I
she
was
wanted her name
okay.
to go on the record. So
Yes,
that's
ma'am. May I ask, and I think you just answered this question, but may I ask the court a question?
you can, but I don't know if I'll be able to
Okay.
address it or know it, but
I'm just curious if Judge Jean advised of what those instances of a 48-hour window are. Did she give any citations or any guidance on that?
no, I just really, because this calendar, I just.
Yes,
wanted to
ma'am.
be
I'm sorry to hold everybody up,
No,
but
and I
I
wanted
do have to
be
do my
fair.
job.
But yes, and if you want, you're more than welcome. And she wanted me to tell you her name and this, and I know you're doing your job, but that's what she told me, and she knows I defer to her judgment. So
Yes,
I'm
ma'am.
sorry about this, and it will be heard tomorrow. And I'm glad I put this on the record. So, and if you want to speak, or you can always reach out, but it's on the record that she told me that. And
I will do so. Thank you, Your Honor.
Okay,
And I
thank you.
appreciate you letting me be heard, and just note my objection for the record, please.
okay, thank you.
Thank you.
Okay.
All rise, raise your right hand.
Todos de pie y levanten su mano derecha.
Do you swear affirm the testimony about to give me the truth and the whole truth and nothing but the truth? Say I do.
Juran o afirman que el testimonio que van a dar es la verdad, nada más que la verdad y únicamente la verdad. Si es así, respondan en voz alta.
Okay, so this is Samuel Romero.
Judge, we're starting, it seems, with Miss Morales. She's number 3. Andrew Black for the public defender. by the
Hold
way.
on. Sorry. Oh, we're gonna just go in order? We're going in order?
Judge, they brought out Miss Morales, number 3 first. I'm not sure why.
They said this is Miss Morales.
Judge, I think number 1 is a bond out, Mac.
Number 1, Mac is a
Okay, so the first one I have is Lativia Mack.
It's a bond out.
You're on the bond.
Okay. Okay, so the next case I have is Jasmine Tai.
Your Honor, she refused.
Are you,
Judge, I'll just waive her presence, and she already has, she's in on a misdemeanor, and she's got a fugitive warrant. I don't have any PC arguments, so I think we can quickly handle this one. Presence waived.
for Jasmine Tai?
Yes, Judge.
State?
We would just request the.
And by the way, Judge, impossible for us to hear the prosecutor over here.
They
I don't
can't
know
hear you.
if they can speak more directly into the mic.
So you're waiving her appearance?
Yeah, waived her presence. I don't have PC arguments. She already has holds. I think standard bond's appropriate here.
Yes, standard bond is
Okay, so the standard bond is, 150.
Your Honor.
Wait, hold on, sorry, I'm looking at. Sorry, no, I'm so sorry, had the wrong paper in front of me. Oh, it doesn't have, 25? Okay, the standard bond is 2,500.
And Judge, I forgot to ask, that the PD's appointed provisionally for all of these cases this morning,
Yes,
or this afternoon. Thank you.
thank you. Oh, God, sorry. Okay, so 2,500. Total cost found, okay. Okay, so the next one we're on is Samantha Morales.
And this is Ms. Morales. You can come over.
Does she need an interpreter?
No, Judge.
I'm gonna go ahead and read her a form to see if there's probable cause.
Okay, Judge, and defense will not have probable cause argument here. Viewed on PC for a defense.
Okay. Yeah, so court finds probable cause. There's 2 counts of battery with the bodily harm with a firearm. There's 3 counts of assault aggravated with a firearm. There's 1 count of firearm displayed while committing a felony, and there's 1 count of weapon firearm. And the court finds probable cause on, there's 7 counts.
8 counts.
Oh, 8, I didn't. Oh, yeah, and, use alcohol beverage. So there's probable cause on all 8 counts.
And Judge, we're just asking for standard bond here. It's going to be significant for her. She doesn't have any priors.
Your Honor, the state filed a motion for pretrial detention. This is a first-degree felony, and it is one of the enumerated crimes, aggravated battery. One of the victims in this case was shot, and she also has priors from Iowa.
Yes, I'm going to go ahead and grant the motion for the pretrial detention under statute 907.041. These crimes, especially the firearm, and like the state said, a victim was shot, she will be held with no bond.
Your Honor, on what counts?
I think it should only be, I think they mentioned the battery, Judge, so it should only be for 1 and 2, counts 1 and 2.
That's correct.
And then you'll just have to set standard bond for the 6th count.
So count 1 is no bond. Count 2 is no bond. Count 3 is 5,000. Does the state have any objection?
No, Judge.
Okay. Count 5 is 5,000.
Your Honor, you said count 3 is 5,000, count 5 is 5,000?
Count 3, 4, and 5 are all 5,000. Count 6, 7,500. Count 7 is 500. And count 8 is 150. And shall be held with no bond. Yeah, and shall be trial detention tomorrow.
And Your Honor, we'll also be requesting stay away orders for the victims.
Did you send me them?
You didn't? You didn't?
I don't see them. Yes. Do I need to? Well, then we're gonna have stay away orders.
Yeah,
You guys doing that?
yeah. Or he can do it and then sign it if you want to keep going, or we can do it right now.
Yeah, but she has to. Okay, so can I just get one of them and I'll do them now? Okay, ma'am, you're to have no contact with the victim. AA, directly or indirectly, in person, in writing, by pager. You must stay 500 feet all times away from the victim, their place of employment, house, no contact, email and texting. Do you understand?
Yes, Your Honor.
And then, and LR, same thing, you have no contact, indirectly, directly, text, phone, email. You understand? 500 feet? Okay? And IR, again, directly, indirectly, in writing, pager, by third person means, electronic. You understand?
Yes, Your Honor.
Okay, so there'll be 3 also stay away orders. Thank you. I'll sign up. Okay, so the next case I have is Priscilla Brown. I'll sign them at the end. There. Are you Priscilla Brown?
This is Miss Brown, Judge.
Okay, Ms. Brown, you have one count of battery aggravated with a deadly weapon. I'm gonna read your arrest affidavit to determine probable cause.
And Judge, I am gonna have PC arguments here, just heads up.
And what is your PC argument?
Judge, I'm sort of disturbed by this arrest affidavit. I'm not sure why there's PC as to the alleged victim story, but there's not PC as to Miss Brown's story. Miss Brown claimed self-defense. That there's 2 statements without any independent evidence here, without any tiebreaker. I'm not sure why there's probable cause here for any sort of crime. Additionally, a folding chair wielded by a 16-year-old woman against a young man approaching her. I'm not sure how that constitutes aggravated battery. For it to be aggravated, there has to be a deadly weapon. There has to be permanent disfigurement, permanent disability, or great bodily harm here. So I'm asking you to find that there's no probable cause and release her outright.
Okay.
Both the defendant and the victim agree that the defendant did in fact hit the victim with the folding chair. And there is probable cause to believe this was an intentional battery due to the victim's statements to the police that he was just showing the food to the defendant when she grabbed the folding chair and struck on the right side of his body. The defense's arguments are more suitable for a standard ground hearing or trial, but as far as probable cause goes, it's very low standard. There is enough for probable cause. The folding chair could also be a deadly weapon. It is a big, heavy object that could do significant damage to a person.
And are there any priors? I don't see.
She's got
No
priors,
priors.
Judge, I'm asking for ROR. She also has an elderly father at home. She's the only caregiver. He's in his 90s. He's 85, Judge. Given the facts of this case, I think ROR is appropriate.
What's it? I find probable cause for battery. I'm not gonna. What's the standard round for battery?
For just normal battery, $1,000 stay away order.
Okay, I'm gonna do $1,000.
To bond out?
PC found
for just straight battery.
For battery. PC found for battery.
If it was just normal battery, then
Yeah.
misdemeanor battery.
And then, but there's also gonna be a stay away order from Ian Rowley. You know what that individual is?
Yes.
Okay, you're not to have any contact directly, indirectly, in person, in writing, pager, phone, fax. You must stay 500 feet of all time from the victim's home, place of employment, school. No electronic means. You understand, ma'am?
Yes.
Okay, thank you. Good, I'm here. So the next case I have is Zuli Gonzalez.
Yes, this is Ms. Gonzalez.
Does she need an interpreter?
No, Judge.
Okay, she's been charged with 1 count of burglary of unoccupied conveyance and 1 count of criminal mischief. I'm gonna read that affidavit to see if there's probable cause.
Judge, no PC arguments.
And there's no priors?
No priors, Your Honor.
Okay, court finds probable cause on count 1, burglary, unoccupied conveyance, and count 2, criminal mischief.
Just requesting standard bond, Judge.
Okay, first, 2,500 for count 1 is the standard bond, and count 2 is 150, right? Count 2 is 150. Thank you. PC file, thank you. Okay, the next case I have is Anna Strokes.
Bond out.
Bond out. I did stay away.
Judge, I don't know if you heard number 6 is a bond out.
Yeah. Okay, so I have next is
Are you Kathy?
Kathy Joseph. Are you Kathy, ma'am?
This is Ms. Joseph.
Okay. Okay, so you've been charged with aggravated battery. I'm gonna go ahead and read your arrest affidavit to determine probable cause.
And Judge, I do have a PC argument.
I thought I wrote his name. You do have, okay.
Yes, ma'am, I do.
Okay, what's your PC argument?
So Judge, I would argue that this is not aggravated battery. Aggravated battery requires great bodily harm, permanent disability, permanent disfigurement, or the use of a deadly weapon. It's a serious allegation, Judge, but I would argue that it's a first-degree misdemeanor.
I agree, Your Honor.
Okay, so the state is submitting to a first-degree misdemeanor?
Yes, Your Honor.
Okay. And what is that, PC is found first-degree misdemeanor, what is that on amount?
$1,000 in the stay away order.
Okay, so it'll be $1,000 and a stay away order. The stay away order is with Vicky Joseph, okay, ma'am?
Yes, ma'am.
And you are stay at least 500 feet away from the victim, victim's house, place of employment, school at all times. No contact directly, indirectly by telephone, pager, sending emails, Facebook, Twitter. Do you understand, ma'am?
Yes, ma'am.
Okay, thank you.
Hello.
Hello? Yes, this is, I wanted to speak on this case. I needed to verify that I'm in fear for my life with Katie Joseph, so I wanted to assure that everything goes properly.
Who is this speaking?
This is Vicky Joseph, the victim,
On which case?
the one you just read.
Okay, yeah, and there's a stay away order, to protect her from going anywhere near you.
Is that all you can do? Because she makes threats daily.
I don't see your, if you want to speak, I need to see your face and for you to get sworn in. You have to accept the panel request.
Okay, let me unmute. Okay, I'm here.
Do you want to, can I swear her in? Can you swear her in, please?
Raise your right. Do you swear you about to give the truth, the whole truth, and nothing but the truth? I do.
Can you repeat that one more time?
She's asking, she's swearing you in under oath.
Do you swear offering the testimony about to give me the truth, the whole truth, and nothing but the truth? Say I do.
Yes.
Okay, you're here as the victim in which, against which case?
Katie Josephs.
Okay, and we.
I heard you guys say that it wasn't a weapon. She released mace on me in a hospital, in a public place, in the lobby of a hospital. Put everyone in danger, including my elderly sick mother.
Did you, the last part says pepper spray. Did you guys read it?
Yeah, 1 second.
Okay.
Well, definitely assaulted.
So Judge, it may be helpful to inform the victim that there is bond and there's a stay away order.
Yeah, she heard that, you know that there's a stay away order. She cannot come 500 feet from your house, anywhere, or your residence, home where you work or school, or she'll be in violation of the stay away order. And there's also a bond.
So is that all that's gonna be able to be done? Because I know you issued a stay away order. I'm gonna be going downtown tomorrow to apply for a civil injunction, as they was told. I wanna make sure charges are fully pressed. I was assaulted when I wasn't here for any type of issue. They have cameras in the hospital. Everyone tried to stop her. I don't know what's going on. If she's on something, I just don't know.
It's a weapon.
Judge, I'm just not sure what more can be done at this setting, but the case is going to be prosecuted. She has
Does she
bond.
have to get bond because she
No,
makes
this case
threats
is-
all the time?
I can't give any legal advice or anything about the case, but the case is not over with. The case is not over with. This is just bond. And hold on, the state's gonna talk.
Yeah, this is just us setting her bond. This isn't formal charges at all. The state will do further investigation and reach out to you and then decide what the formal charges would be. These are not formal charges. This is just a bond hearing.
Okay, and a bond is necessary? Because I don't feel safe for me or my mother. Is a bond necessary for her?
Yes, she is entitled to a bond.
But you have a stay away order. She cannot come in 500 feet of you. If she does, you can call the police immediately.
Okay.
All right, thank you.
Thank you.
Okay, the next case I have is Christian Rivera.
So Judge, Mr. Rivera is in Ward D, which is the hospital. Can we reset this for tomorrow, Judge?
Okay, so it will be Ward D and there's 8 cases, so it'll be reset for tomorrow. Where do you prefer that I write this up? And he has, and they'll be here tomorrow. He has several accounts and so he's
Yes,
in.
Judge.
Thank you. Okay, so the next case I have is Israel Brown.
I don't know that we have Mr. Brown. Your Honor, he refused.
Are you waiving his presence?
I'm sorry, I didn't hear your question, Judge.
I said, are you gonna waive Mr. Brown's presence?
Yes, Judge.
Okay. Mr. Brown has been charged with resisting officer with violence and driving while his license was suspended knowingly. I'm gonna read the A-form, probable cause.
Mute on PC and just asking for standard bond. Your Honor, the case we're here for, Mr. Brown, is F-26-7643 and is resisting with violence.
Sorry, I couldn't hear you. I can't hear.
Brown is the case number for Mr. Brown is F-26-7643 and is resisting officer with violence. Yes.
Yes.
And the driving while license suspended was reset for tomorrow.
Okay,
Okay, then just reset the felony with the misdemeanor then, Judge.
okay, then it will be reset.
Thank you, Your Honor.
You're welcome.
I meant not misdemeanor traffic, reset with traffic.
So the next case that I have is Arthur. Is that Arthur?
This is Mr. Romero, Judge.
Oh, yeah,
He's number 10.
yeah, sorry, skip that. Samuel Romero. Okay. Hey. Good afternoon, sir. Okay, you've been charged with 1 count of battery aggravated law enforcement officer. You've been 2 counts of battery aggravated with a deadly weapon and 1 count of reckless driving, damage to the property or person. I'm gonna read your arrest to determine if there's probable cause. I didn't write that? Oh, did I write it in there? Please, fine. Yeah. Okay. The court finds probable cause on the battery, count 2, the battery aggravated with a deadly weapon, and count 1, reckless driving. State.
Your Honor, we have a motion for pretrial detention in this case because of the first-degree felony aggravated battery on a law enforcement officer.
Do you have any arguments?
Judge, I don't really have any when they file the motion to hold pending pretrial detention. This is an eligible offense, so no.
Did you guys file them? You have the motion? Oh, this is the top of page 10. Okay, so there's PC for count 1, probable cause 2 counts for aggravated with deadly weapon and reckless driving. There's count 1, and we're gonna hold him. This aggravated battery with the law enforcement qualifies for pretrial detention, which will be no bond.
I apologize, Your Honor, but we already, we'll fill it out quick right now.
Okay.
And so, Judge, it's held no bond, count 1. What are you doing with counts 2, 3? I guess it's just 2 and 3.
For those, the state would just request the standard bond.
Okay, and there's 2 counts, so what is this? But there's 2 counts of, count 2, so 75 each. So on count 2, it's 7,500 times 2. So basically 15,000, because there's 2 counts. And then count 3 is, what's the standard bond there? And
So held no bond 1, 2, and 3 is 7,500 each?
yes,
Okay.
counts 2 and 3 are both 7,500, right? And also there's a stay away order from Xavier Villarano and Jonathan Villarano. They're to have no contact directly, indirectly, by phone, email.
Acknowledge now? He said he understands, Judge.
Okay. By Twitter, no third party. Okay. And also I'm signing the, because this is, you, there's, stay away order, you wrote it. Oh, okay. Oh, okay. And I'm also signing, this is a, I'm also signing the motion for pretrial detention under statute 907-041, because it's aggravated on a police officer. Thank you. The next case I have is Arthur Morali. Oh. I guess he got out, wait, Arthur. Wait. Okay. So we're gonna go back to 11?
Go ahead and call them.
Oh, okay. Okay, so we're gonna go out of turn, I get to page 12.
Okay, we're gonna have to get the right defendant here then. We've got Mr. Morelli. Oh, excuse me, Mr. Moore, we have Mr. Moore here. Is there somebody else you need, Judge?
It's Angela Perez Nunez, Angel,
No, we don't have that person. Let me ask.
but it says here, oh. Okay, we'll put it to the side and keep on going.
Okay,
So who's next to you now?
this is number 11, Arthur Moore.
Okay. You've been charged with robbery by sudden snatching, and the second count is battery.
Judge. It's
Oh,
just.
sorry. Sorry, was that? Okay, hold on, okay, sorry about that. Corrections, can you bring Mickerson,
What's the defendant's name, Your Honor?
Mickerson Escarment? It's page 8. Okay, and then while you're doing that, I'll do the one in front of you now.
Okay,
Okay. Sir, you've been charged with assault aggravated with a firearm. I'm gonna read your arrest affidavit to determine if there's probable cause.
and defense is mute on PC, no PC argument. And Judge, just pointing out that the allegations pertaining to Mr. Moore start on the second page because there's a co-defendant in this case.
Okay, the court finds probable cause aggravated assault with firearm.
And Judge, we're just asking for standard bond. He's only has, one prior arrest.
The state would request the same, 5,000.
Okay,
And a stay away.
so it'll be 5,000 and a stay away order. And the stay away orders between Devante Bohan and you're to have no contact directly, indirectly, in person, in writing. You're to stay 500 feet away from the victim at all times, victim's home, place of employment, school, no electronic contacts such as email, texting, Facebook, or Twitter. Do you understand?
Yes,
Okay, thank you.
you are.
Judge, who was it that you wanted to call out of turn?
McPherson Eskerment.
Yeah,
You said it was on page 8,
yes.
25,
The
correct?
defendant is not here yet.
It's number 25.
Your Honor, the defendant is not here yet.
They're saying,
Judge, I don't know if you heard that. A corrections officer said that he's not here. Defendant's not here.
is he gonna come?
I
Yes.
don't know. Do you know if he's on the way? Yeah, he's on the way.
Okay, we'll just pass him so we can continue.
What number is that? Judge, corrections is requesting that we call number 16 out of turn, Alberto Amador, on page 5.
Number 16, right?
Yes, Judge. And we're gonna have to help this
Alberto.
person. Hold on.
Amador.
You will need the services of the Spanish interpreter.
The interpreter is present, Your Honor.
He needs an interpreter, correct?
Yes, Your Honor.
Okay.
Yeah.
Is this the one whose family was on earlier? Is this the one whose family was on earlier? Okay.
What's
They're
his
not
name,
there.
counsel?
Amador. Last name is Amador. First name is Alberto.
Okay. Buenas tardes, señor Alberto Amador. ¿Me escucha?
Sí.
Okay. He can hear me, Your Honor.
Okay, you've been charged with one kind of assault aggravated with a deadly weapon and criminal mischief. I'm gonna read your arrest affidavit to determine if there's probable cause.
Okay, one second. Bien, señor, usted ha sido de una agresión con agravantes con un arma letal y destrucción de propiedad. Ahora voy a leer el documento acusatorio para determinar motivo fundado. Un momento.
Do you have any arguments?
I don't have PC arguments, Judge. I just wanted to mention that the corrections officers mentioned to me that Mr. Amador had family on the platform earlier who was informing corrections and intended to inform you that Mr. Amador has Alzheimer's, which would explain the allegations in this case. And I'm
Okay.
sorry. Yeah, I'm sorry, Interpreter. Go ahead.
No, that's okay. Thank you. Thank you, counsel. Bien, entonces, abogado, ¿usted tiene algún argumento con respecto a motivo fundado para el arresto? No tengo ningún argumento con respecto a motivo fundado. Sin embargo, quería avisarle a su señoría que previamente estaba conectada la familia de él y ellos querían informarle a su señoría que él está sufriendo, padeciendo de Alzheimer's, lo cual explica este tipo de acusación.
Given the lack of priors here, Judge, I would ask for a non-monetary form of bond. Even if it's house arrest, I understand that he's listed as homeless, but if he's able to give contact information to family and family can reach corrections, that's a way to get him out on non-monetary bond, which still accounts for the seriousness of the allegations.
Okay. Su señoría, por lo tanto, dado que él no tiene antecedentes, solicitamos que le den algún tipo de liberación que no sea de tipo monetario, por ejemplo, arresto domiciliario, aunque sí le han listado como que en este momento él se encuentra desamparado o sin techo, pero si entre la familia de él y la correccional pueden intercambiar información para que de esa forma pueda ser liberado.
And I would just mention one more thing. I'm sorry to interrupt. That defendants are entitled to a presumption in favor of non-monetary release.
También quisiera decir una cosa más y disculpe por interrumpir, que es que a los acusados se les da el derecho de liberación no monetaria.
Your
A
Honor,
la consideración.
Your Honor, the state would be requesting standard bond in this case. As defense just stated, if the defendant is homeless as listed on the arrest form, he cannot go on house arrest without a home address. We need something to ensure that he will deal with this case and come back to the court. If his family is going to help him with that, then that's fine, but he still needs some type of bond, just the standard bond to ensure that he will come back, or that someone else will help him come back.
If you set an alt bond, I'm sorry, go ahead, Interpreter.
Sí, su señoría, la Fiscalía del Estado solicita que se imponga una fianza estándar. Sí, se ha mencionado en el formulario de arresto que él está sin techo, que está desamparado, pero para poder que él vaya en una detención domiciliaria se necesita una dirección donde él se quede y para nosotros cerciorarnos de que él regrese a la corte para lidiar con el caso. Ahora, si su familia quiere ayudarle para venir a la corte, eso está muy bien, pero mientras tanto solicitamos una fianza estándar.
If family doesn't reach out, he's not going to be released. So it's not like he's going to be released on a monitor without having an address. And also, if you set an alternate bond and he doesn't have an address and family's not able to sponsor him, family could maybe still pay bond.
Su señoría, si la familia no se contacta, pues entonces no será liberado, especialmente ya que él no tiene dirección y la familia sería la que le asistiría en cuestión de pago de fianza.
Then state won't object to house arrest with an alternative bond in the amount of $5,500 as long as he can provide an address that he will be staying to house arrest.
Okay.
Corrections won't let him out unless he does.
Okay, so there's probable cause found on both counts. Count one would be 5,000, count two is 500, correct? And
entonces, la fiscalía no se opone a que le den arresto domiciliario y o fianza de $5,500. Entonces, motivo fundado en el cargo 1, $5,000 de fianza y $500 en el segundo cargo.
And house arrest will be total lockdown. Yeah. And the house arrest will be total lockdown.
Y cuando esté en arresto domiciliario va a ser encierro completo, total.
And also, there's 2 stay away orders. Jairo Salmon and Lucas Rodriguez. Defendant is to stay directly, no contact with these individuals by phone.
Your Honor, respectfully, what is the name of the first victim?
Lucas, the first one is, I'm not sure how to pronounce it, so I'm gonna spell for the
It's
record.
okay.
Thiago,
INEO.
and then it's Salmon.
Simón. Ok. Bien, señor. Mientras tanto, usted va a tener 2 órdenes de alejamiento. Una es para el señor Tineo Zamor y la otra orden de alejamiento a favor de Lucas Rodríguez. No puede tener contacto, sea directo o indirecto, con estos individuos por teléfono, en persona o a través de terceras personas.
And you must stay 500 feet away from the house, employment, school at all times. Do you understand, sir?
Y debe de permanecer a 500 pies de las víctimas, de donde vivan, donde trabajen, donde quiera que se encuentren. Usted debe de estar a 500 pies de distancia. ¿Entiende, señor? Responda. ¿Entiende?
Sí.
Yes.
Okay, thank you.
Gracias.
Your Honor, so the bonds are 5,000 plus house arrest?
No,
5,000, the bond is total is 5,500 or the,
Yes, count 1 is 5,000, count 2 is 500, but is there an alternate or is it plus house?
No, the bond is house arrest level 1 with an alternate bond of those amounts.
Yes.
if you can provide an address.
Entonces va a ser arresto domiciliario nivel 1 o si no la fianza monetaria de $5,500.
Okay, the next one I have is Felix.
Hasta
Number
luego,
12.
señor. Eso es todo.
Yes. Thank you. Are you Felix, sir?
No, Judge, this is number 17. I'm not sure where we're out of order, but
We're out of order.
this is Mr. Venner, number 17, bottom of page 5.
Venner, number 17. Does he need a Spanish interpreter? Sir, does he need a Spanish interpreter?
He does not, Judge.
Okay, so you've been charged with cocaine possession and disorderly intoxication. Let me read the A form to determine if there's probable cause.
And defense is mute on PC, Judge.
Yeah. Okay, the court finds probable cause on count 1, cocaine possession, and count 2, disorderly intoxication.
And Judge, I inquired with Mr. Venner about his financial circumstances. He's informed me that he wouldn't be able to afford even 10% of the standard bond. So, Your Honor, because he's entitled to a presumption in favor of non-monetary release, and because I see that he doesn't have any prior convictions, I'm asking for release on pretrial services. It requires that he check in and abide by other conditions of release.
How long has he lived in Miami-Dade County for? Or
17 years, Judge. I was born here. At that address, he's lived there for 17 years, but he was born in Miami-Dade County, Judge.
State.
Your Honor, the state would request the standard bond. Although he has no local priors, he does have a misdemeanor from 2007 battery, which he received a withhold from adjudication from the Seminole Tribe Police, and a misdemeanor from 2007 indecent exposure, which he was convicted from Broward County.
Given the fact that he doesn't have any priors for 20 years and he's not going to be able to bond out and he's entitled to a form of non-monetary release, I'm asking for pretrial services.
Okay, I'm gonna go ahead, the standard bond for count one is 2,500. I'm gonna go ahead and reduce it to 1,000. And on count two is 150, correct?
Yes, Your Honor.
Okay, so I reduced the standard bond to 1,000 and then 150 for count two. I find PC on both.
No,
Thank you.
Thank you, Judge.
You're welcome.
is there something I could think of?
So are we gonna go back in order?
Yeah, because he was the next one after Mr. Amador, but Amador was out of turn, so we need to go
Okay,
back
right.
to
Felix.
Michael Felix.
Judge, I apologize.
Yeah,
Could I please recall Mr. Benner, number 17?
the one I just,
Yes, ma'am.
I already ruled, but sure, go ahead.
I'm sorry, Judge. He's informing me that he can't even afford $100. So if Your Honor could.
I mean, I reduced it. It was 2,500 standard bond and I went down to 1,000.
I do appreciate it. Would you be willing to issue house arrest with an alternate bond? Alternate bond, excuse me.
Not at this time.
Okay, thank you, Judge.
You're welcome. Okay, so we're gonna go back to Michael Felix. No, we just. Who's in front of you now?
This is Mr. Higuchi.
Number 12?
Yes, Your Honor, this is Michael Felix.
Okay. So number 12. No?
Higuchi.
No. Okay. Okay. And there's a note here that he's out on bond for case number F2525935 in front of Division 4.
Judge, that's Mr. Higuchi has an open case?
No, see what, who's giving me?
This is number 12, Michael Felix Higuchi.
Sorry, I grabbed the wrong paper. I apologize.
So Judge, we have no PC arguments for Mr. Higuchi.
Is there any? There. Let me pull them up. Sorry. Okay, so on this one, you're charged with grand theft third degree and possession of cannabis. Okay, the court finds probable cause in count one and probable cause in count two.
That means I would have to do time.
And there's also a stay away order for Jaylene McGray. Did you hear me, sir?
Yes, sir. Yes, ma'am.
Okay, you're directly, indirectly, in person, in writing, by telephone, pager, fax, or through third person. Defendant must stay at least 500 feet away from the victim's house, home, place of employment, school at all times. No electronic means of communication. Do you understand?
Yes, ma'am.
Okay.
And Judge, I'm respectfully requesting that the bond for the second count be set at 500, and I'm asking for that amount because Mr. Higuchi has informed me that he's not going to be able to come up with more than $300 in order to bond out.
Date? The standard bond here says 2,500 for grand theft, and
The state would just be requesting the standard bond, although he has no local priors, he does have convictions for Palm Beach County. He was convicted of, he has 3 convictions from Palm Beach County.
And what years are those?
It's 2020 felony, fleeing and eluding, 2020 criminal mischief, and sorry, 1 second. 2020 burglary of an occupied dwelling.
Thank you, Judge. I would just argue that excessive bond for an indigent person is tantamount to no bond. I would just ask for a reduction on that count.
what is the standard bond for? It doesn't have for count two for the cannabis.
25.
Okay, I'll go.
And I would also just point out that it is charged as a felony because the officer said that it's 20 grams. I could have made a probable cause argument stating that that's a conclusory statement. He didn't tell us how he knows it's 20 grams. I held back on making that argument, but I think it does militate against setting standard bond. I think we can reduce it.
He didn't even wish.
Because the difference between the misdemeanor and the felony is that 20 grams. And so since we don't know, and it very likely could have been charged as a misdemeanor, I think a misdemeanor level amount may be appropriate.
What's the misdemeanor amount?
$500.
It says he suspected it to be 20 grams.
Large bag, but.
Okay, I'm gonna go for count one. I'm gonna go with the count one. There's probable cause on both counts. Count one, I'm gonna go with this standard bond of 2,500. And count two, I will, since it does say suspected marijuana over 20 grams. I know you had a PC argument. I will reduce it to
I think even the misdemeanor standard would be lower than 500. So I think
and I'll reduce
500
it
would
to,
be.
I'm gonna reduce it to 500.
Thank you, Judge. Okay.
And also there's a stay away order, which I already addressed with him.
Yes, Judge. And Judge, Corrections wants to take number 45 out of turn, and that's Mr. Perez Nunez, and he's on page. He's on page 12, Judge.
Number, so it should be. What you said, number 45, correct?
Yes, Judge.
Perez, you got it?
Sorry, they're trying to pull it out of order.
No problem, Judge. Thank you.
Oh, sorry. Okay. Does he need a Spanish interpreter?
No, ma'am.
Okay, he's been charged with 1 count of cocaine possession. I'm gonna read that rest affidavit to determine if there's probable cause. Okay, court finds probable cause. State?
Your Honor, the state requests a standard bond as well as a felony hold. He has an open felony case F2525935.
Yes, and that's in Division 4. Okay, I do find probable cause count 1 and issue the standard bond of 2,500. And and there's also a felony hold that was said in F2525935. So there's a felony hold. Thank you.
Your Honor, that was standard bond of 2,500?
Yes. And also there's also a felony hold.
Yes, Your Honor.
Thank you. Do you guys, does corrections have, Mickerson escarment? If I'm pronouncing it correctly?
They have them, Judge. And what number is that? Or what page?
25, I think.
That's page 8. Ma'am, is that the case you're here on? And are you the victim in this case? Okay, let me first. This is page, okay. And these are the parts, okay. Okay, sir. Sir, you've been charged with robbery by sudden snatching and battery. There's also a victim present that's going to be sworn in. Okay.
They have my idea. They took it. I could show you a picture.
Can you just share the date of birth? That's good.
Sorry about that.
Your Honor, I also speak on the case too, also.
Wait, yeah, I'm gonna just read the rest of your, even and then I swear you in, and you'll say your name for the record and you can speak. Okay, the court finds probable cause for robbery by sudden snatching and battery, and there is a victim present. Can you please come closer, speak in the mic, and please state your name for the record?
Sorry.
Okay. And what would you like to inform the court or say about this case?
I never once said that the victim pointed a gun. That was a lie. So what the detective said, it's like they flipped my words. If you could watch the dash cam, you would see everything. Most of the stuff that there's a lie, and then I was supposed to drop the charges. They called me to come and drop the charges, and then somebody else. It's like I was speaking to 2 different detectives, and they was giving me different details on it. And if you watch the audio with the detective, you can see they were pausing and playing the video. If you watch the police, I told them that he's a good person, and like you could watch the videos, see that the detective was sitting there and no words.
Are you in? Is that your boyfriend?
Yes. And also last night, I had got pulled over because the officer, he said that he seen my expired tag. He said he seen 0226, but my tag says 0228. If you watch his dash cam, as soon as he got close to the car, it was like probably 10 police cars that put me over and blocked me. I was very scared. If you watch the video, he apologized and he said he thought my tag was expired. He couldn't see. And I also mentioned too that there was other cars speeding past, and I was driving normal. I did not do anything at all. And he stopped me, and then I was with him, and my firearm was in my possession, and they took it with him. And I'm trying to figure out why did my firearm get taken when it was in my possession. He's not a convicted felon at all or anything, so he could be around firearm. So I asked them why. And I don't understand.
So
I didn't get any ticket or.
Are you in fear of? You're not in
No,
fear of the
not the fear of the defendant at all.
state?
Your Honor, the state would be requesting secured bond in this case.
Oh, gang hostage.
The state would still request a stay away order in place. despite the victim's wishes to have contact with the defendant. However, I do recognize that this is a delayed arrest. This happened back on February 6th, 2026.
May I ask for a peace?
Hold, let me talk. Defense,
Judge, there's clearly a lot that went down at the scene that.
can you
is
talk a
not-
little bit more in the mic? Sorry.
There's no problem. Judge, there's clearly a lot that happened on the scene that is not memorialized in the arrest affidavit. Given the alleged victim's representations, I would ask that we honor the presumption in favor of non-monetary release for Mr. Escarpment. If we set it at PTS, he still has an obligation to check in, and if he doesn't abide by those conditions, he can get taken in and held no bond. So I think, hold on a second. I think pretrial services is appropriate given the representations by the alleged victim. And as to the stay away order, given the alleged victim's representations, I'd ask for at least a modification of the stay away order to a no harmful contact order.
He does? He does not qualify for pretrial services.
Oh, and why is that?
Because of the alleged charge.
Huh. Okay.
And because this is a domestic abuse crime, his priors are felony 2023 improper exhibition of a weapon, which he was convicted of. Felony 2025, grand theft and burglary, no action. Felony 2024, grand theft with a firearm and weapon open carry, no action. Felony 2025, grand theft of a motor vehicle, no cross. Broward. Because of this history with weapons, especially firearms, the state is concerned for the victim's safety and would still request a stay away order and would object to any modification.
Judge, I just wanted to quickly point out that improper exhibition charge is a misdemeanor. I thought I heard the state describe it as a felony. So Judge, he is still entitled to a presumption in favor of non-monetary bond. And I think that presumption becomes even more important when the alleged victim, the firsthand witness of the allegations, is on the platform refuting those allegations. And so, Your Honor, the legislature has set a presumption in favor of non-monetary release. He has a good address for house arrest. He can be monitored. And so we're asking for Your Honor to honor that presumption, especially in light of the allegations by the alleged victim on the platform today.
You don't have. And state, do you still stand on your position?
Yes, Your Honor.
No, this is. What is the standard bond for the robbery, sudden snatching? Okay, I'm gonna go ahead and since he does not qualify for child services and the alleged victim is testifying that that is her boyfriend, she's not scared and she plans to, wait, you said you plan to go ahead and drop charges?
Yes.
Well, I'm gonna go ahead and reduce the bond on count one to, I'm gonna reduce it in half by 2,500.
Also,
Hold on, 2,500, probable cause is fine. Found, and count two, the battery, 1,000, PC fine. I'm gonna note. Is you're gonna, you guys have a stay, and there will be a, you have a stay away order?
Yes.
Okay.
2 seconds, I'm almost done.
Did anyone force you to come in here or force you to come in here to speak today?
no.
You did this on your own free will?
Yes.
Sorry.
Okay, so count one is 2,500. Count two is 1,000, and there's gonna be there's a stay away order. Sir,
Excuse me.
you're not, hold on. You're not,
Stay away.
let me finish. You're not to engage in any criminal activities, not to use or possess any illegal drugs. Do not use, purchase, possess, or carry any firearms. You must immediately surrender any firearms you have to the nearest police station. Do you understand, sir?
Yes, ma'am.
Okay. The victim is prohibited from having, do you guys still object to the having, she's here, that's why they're for them to have contact, but physically, if it's cordial contact?
We're requesting a no harmful contact order in the
State
stay
would
order.
object, but of course it's up to you.
Okay. Yeah. Okay. So I am gonna modify because she is here. I'm going to offer that the defendant is allowed to have contact with the victim, but is prohibited from being physically threatening or violent towards the victim in any manner whatsoever. Do you understand, sir? Okay, so I went ahead and modified it per the victim testifying that she's not scared of the defendant. She came on her own. It was not forced into coming here. And do you guys reside together?
Occasionally, like, I'm not saying, but
Sounds like a no.
Okay. All right, sir. Thank you.
Miss, how do I go about the lying on him? Like how they lied? What do I go?
I can't give you any advice or
Because they lied on the paper.
I
And you
can't.
could watch the video camera. You don't hear me say that at all.
You can go down to, you can talk to the public defender's office, state attorney. I can't give you any advice. Sorry. Who's in front of me now?
Judge, this is Mr. Valdez, and I just also wanted to inform the alleged victim in that case, she can go to the state attorney's office and give a statement there. She can also give a statement at the public defender's office as
Yeah,
well.
not what it says. You can go to the state attorney or public defender and speak there, but I cannot advise you. Okay. Thank you. So what number are you on?
I have Mr. Valdez, correct?
Sorry?
Mr. Valdez, number 13, bottom of page 4.
Okay, so we're back. Daniel Valdez, does he need a Spanish interpreter?
No, Judge.
Okay. You've been charged with 4 counts. The first count is worthless check deposit with intent. Count 2 is uttering forged bills. Count 3 is grand theft in 3rd degree. Count 4 is unlawful possession of a stolen credit card. There's also 1, 2, 3. There's probation on 4 felony charges: F22-13258, F23-15301B, F24-7830A, and that's all in Division 21 in front of Judge Rodriguez. I'm going to go ahead and read the A form to determine if there's probable cause.
Judge, we have no PC arguments, and he's held on the violation of probation, so just standard bond is our request.
Okay, the court finds probable cause on all 4 counts.
The state's request would also be standard bond with the felony probation hold.
Okay. So I will do standard bond, which is count 1, 2,500. Count 2, 2,500. Count 3, 2,500. Count 4, 2,500. Which is the standard bond. And there's also, there's also the felony hold. And we're gonna hold them on the felony hold, okay? Thank you. The next case I have is Jose Gonzalez.
We'll need an interpreter, Judge.
We're gonna need the interpreter, please.
The interpreter is present, Your Honor.
Okay. Are you Jose Gonzalez Hughes?
Buenas tardes, ¿es usted el señor José González?
Sorry if I pronounce it incorrectly. It's Fouz.
¿Es el señor González Fouk?
Yes.
Yes.
Okay. You have been charged with controlled substance possession of a methamphetamine and 2 counts of drug paraphernalia, possession with the intent to use. I'm going to read the rest affidavit to determine if there's probable cause.
And defense is mute on PC, Judge.
Bien, señor, se le acusa de tenencia de una sustancia controlada que es metanfetamina y 2 cargos de tenencia de parafernalia de drogas. Voy a leer el affidavit de arresto para establecer motivo fundado y nosotros, la defensa, permanecemos en silencio con respecto a motivo fundado. Un momento.
Okay.
The state would just request the standard bond. He has no priors.
So 2,500, 5 and 5, right?
Judge, unfortunately, I'm not able to ask him about his financial circumstances because I don't speak Spanish, but given the fact that he doesn't have priors and this is a personal possession case, I'm asking for either a reduced bond or non-monetary bond like PTS.
Bien, la Fiscalía del Estado solicita una fianza estándar y su señoría, dado que no puedo comunicarme con él en este momento y que él no tiene antecedentes, estamos solicitando que le liberen de una forma que no sea con una fianza monetaria y como alternativa un programa de servicios antes de juicio PTS.
And there's no priors, correct?
No priors.
Okay, I will reduce the bond by half in count 1 to 1,500, count 2, 500, and count 3, 500.
So I'm sorry, just to clarify, count 1, 1,500?
Yes.
And then, or count 2 and 3 reduced at all?
No, I'm going to leave those at the 500.
Bien, entonces se va a reducir la fianza en el cargo 1 a 1,500, cargos 2 y 3, $500 cada uno.
Okay, the next case I have is.
Eso es todo.
Are you Mr. Acosta?
Judge, you'll need an interpreter.
Okay.
Interpreter present.
Can you ask him if he's Mr. Acosta?
Señor, diga su nombre, por favor.
Ya, de la Costa.
¿Cómo?
Es de la Fea Costa.
Chris de la Fea Costa.
Okay, you've been charged with battery with a deadly weapon. I'm going to read your arrest affidavit. In addition, you're on probation for F249474 and F24-17242 in front of in Division 19.
Bien, señor, usted ha sido arrestado por una agresión física con agravantes, con un arma letal. Además de eso, usted se encuentra bajo libertad vigilada o probatoria en el caso F24, 974 y 17242 y está frente a la división 19.
Your Honor, those case numbers are not reflected on the jail card.
Su señoría, esos no son los números de caso que se reflejan en la tarjeta de la cárcel.
On the jail card, it shows that the case number was F257337.
What's here?
En la tarjeta de la cárcel indica que el caso es F25-7337.
Hold on, the clerk is going to look it up. I do find probable cause for the aggravated battery with a deadly weapon.
Encuentro motivo fundado para la agresión física con agravantes con un arma letal.
Requesting standard bond, Judge.
State.
Solicitamos la fianza estándar, juez.
The state also.
What is the standard bond on this?
7,100. State also requests the standard bond as well as the stay away order from the victim and then the felony probation hold for 3 cases.
Okay.
I'm sorry, felony hold you said?
On the 3 cases, which
Okay.
we're double checking right now.
Okay, thank you. Su señoría, la fiscalía solicita la fianza estándar de $7,500 más una orden de alejamiento de las víctimas y una retención en los casos de delito grave, que son 3.
And then there's a stay away order with Junior Garcia. You're to stay 500 feet at all times away from the victim, victim's home, employment, school. No contact directly, indirectly, in writing by third party. Do you understand, sir?
También usted tiene una orden de alejamiento, la cual le prohíbe acercarse a Junior García. Debe de permanecer a 500 pies de él, de donde él trabaje, donde él viva, en todo sitio donde él se encuentra. No puede tener contacto ni directo ni indirecto, ni por teléfono, ni por texto, ni a través de terceras personas. ¿Entiende? Yes.
And we will grant the stay away order there, and then the standard bond 7,500, and we're double checking and we're gonna keep them on the felony holds, which we're double checking.
Entonces, $7,500 de fianza y esta orden de alejamiento a favor de la víctima. Estamos revisando la retención de delitos graves en los otros 3 casos.
So the clerk confirmed those are the correct numbers for the 3 felonies, so we're gonna hold them on the felonies. Do you need the numbers again?
Yes, Your Honor.
Okay. Thank you. Hold on one second. The first one is F249474. The second one is F241742. And the last one is F257337 in Division 19.
Thank you, Your Honor.
You're welcome. And he'll have a hold on all those.
Señor, va a tener una retención por los delitos mayores, que son 3, F24-9474, F24-17242 y F25-7337 en la división 19. Eso es todo, señor.
Okay, the next one I have is Doobie Allen, number 18.
I don't think we have him, do we?
I believe he refused, and there's actually a hold. There's 4 felony holds.
Corrections is checking whether he refused. Judge, we can waive his presence.
Your Honor, it's NBC.
He wasn't brought, Judge, but we can waive his presence, given the felony holds.
Okay, so you're gonna go ahead and waive his presence, okay?
Yeah.
Okay, the 4 felony holds are F26-6466, F26-6467, F26-6468, F26-6479, and he is charged with controlled substance, meth, and second charge is drug paraphernalia with intent to use.
No PC arguments, Judge. Requesting standard.
State?
The state would also request the standard bond if he also has a misdemeanor case.
Okay, so the standard bond is 2,500 on count 1, correct, and 500 on count 2? Okay, so I'll do standard bond 2,500 count 1, PC found, 500 count 2, PC found, and and he has the 4 felony holds, and then he has 1 misdemeanor hold too? Oh. Okay, is it domestic?
Never.
Okay, so we're gonna keep him on the 4 felony holds. Thank you. Oh, sorry, here's your. The next one that I have is Daniel Higgins.
This may also be not brought.
It says here, the note said he refused, but there is a felony hold.
Given the hold, we can waive his presence.
Okay, he was charged with controlled substance possession and camping prohibited in public property.
State would request the standard bond.
I find probable cause on count 1 and count 2, so standard bond on count 1 would be 2,500. And count 2 would be 150, correct?
Your Honor, what's the defendant's name again?
Hey,
A. And waive his presence because he has a hold in Division 6. For case, felony case number F256109, in Division 6. This next one that I have is this Daniel Lloyd?
This is Lloyd Daniels, Judge.
Okay. Okay, and he's charged with one count of cocaine possession, suspect to be crack cocaine and drug paraphernalia with the intent to use. I'm gonna determine if there's probable cause. Okay, the court finds probable cause on count 1 and probable cause on count 2.
Judge, can you grant TAP?
State,
The state would just request the standard bond, 2,500, count 2.
he has a long criminal history in this. I don't even think he would. What do you think? Like there's several convictions. Yeah. So I'm gonna do a standard bond count 1, 2,500, count 2, 500. The next one is Philip Farmer. Are you Mr. Farmer?
Yes, Judge.
Okay. You've been charged with one count of false imprisonment, and the second count is battery. I'm going to read your affirm to determine if there's probable cause. I mean, based on these allegations, I think this is aggravated, and this is a very serious, and she's holding the baby. Defendant grabbed her by her hair, shoved her. Then the defendant grabbed her by the neck and choked her. Victim was still holding onto the child while being assaulted, and the child's 2 years old. Those are severe allegations with a child. State?
Your Honor, state would request the standard bond of $5,000 for count 1 and $1,000 for count 2, but because of the allegations of the A form of choking and the fact that the child was present, the state would also request GPS level 1. This is a domestic violence crime. The defendant has no local priors, but he has a 2008 DUI conviction.
Yes, this is serious allegations with a child choking, having a child in his hand as you do this, like child could have got severely injured. I'm going to, you said the false imprisonment, you said 5,000?
Well, it's
Yeah,
with violence, so 5,000.
Yeah, it's with violence. I'm gonna go up.
So just so I understand, we're increasing the bond?
Well, it's a 3rd-degree felony, but with force or threat of force.
Oh, I see, on the schedule.
5,000.
Okay. Judge, just one moment.
Your Honor, count one was 5,000?
Yes.
Thank you.
Yeah, I'm gonna set count one at 5,000. He choked her neck with a 2-year-old baby while she was holding on to a child. So count one is 5,000 and count two, I'll do a standard bond of 500. Oh, sorry. Oh, sorry, count two is 1,000. So count one, 5,000, count two is 1,000 with GPS monitoring.
Judge, on the GPS, it's effectively no bond for Mr. Farmer. He doesn't have anywhere to go. If he doesn't have an address to list, he's not going to be released. So this charge, I'm not sure. I don't think it qualifies as a charge for which he can be held no bond. And so he is entitled to a bond in this case, and the GPS is effectively no bond.
You and the victim resided together, is that correct, sir?
Judge, I would ask him not to make any statements about the facts of the case at this time, but he has informed me that he has nowhere else to go.
Okay.
If a stay away order is imposed.
I'm going to issue the stay away order. Do not engage in any criminal activity. Do not use or possess any illegal drugs. If you have any firearms, you must surrender them immediately. The defendant is prohibited from having any contact, direct or indirect, with Caroline. I'm going to spell the last name because I cannot pronounce it for the record. Luszczyzyk. Indirectly, directly with the third party. The defendant may return to the victim's residence one time with a police officer within 48 hours to retrieve personal belongings. You're to have absolutely no contact with the victim, and these are serious charges. When there's a baby being held while you are choking, those to me are serious allegations, and that is why I'm also including, what level did you want, Jess?
I'm requesting level 1 lockdown.
Yeah, whenever he provides an answer to this, I'm granting the GPS. Plus on.
Your Honor, is that gonna be an alternate house arrest or is it plus house arrest?
No, plus. These are serious allegations.
So Judge, just over defense objection because it's tantamount to no bond and it is not one of the enumerated offenses that qualifies
But
as a no bond offense.
no, I did get bond. I gave 5,000 and 1,000, and he could go out on GPS. So I didn't give him no bond.
No, I understand, but because he's not going to have anywhere to go, the GPS will, even if he pays bond, will preclude his release. So while it is technically a bond, it is effectively tantamount to no bond, and that's unconstitutional.
State?
Because this is a domestic violence crime, and especially because there's allegations of choking, which when there's allegations of choking, the risk of the victim being murdered by the defendant increases significantly. GPS is necessary to protect the victim in this case. It is not tantamount to no bond just because he can't go home. He could go to another address as long as he provides one. So it is not tantamount to no bond. He's given a bond. This is essential to protect the victim in this case.
In addition, for the record, the victim was still holding onto the child while being assaulted, which is to me very, very serious. And it's a 2-year-old baby, right? He's choking her neck with the baby. So I am granting GPS monitoring. If he has a place to go with an address. Thank you. The next case I have is Jackson Barron. Hey, is Mr. Jackson there? Mr. Jackson. You guys. Can they discuss this later? Okay. Yeah. Sorry, yeah, please talk to him later. We have to move the calendar. Are you Mr. Jackson? Oh, I can't hear you.
It's the same, Judge.
Okay,
Yes.
you've been charged with a petty theft, 2 counts, and you have several prior convictions. I'm gonna read the rest after David to determine if there's probable cause. Okay, the court finds probable cause. In addition, there will be a stay away order from 1085 Northwest 36th Street, Miami, Florida. And that is the Family Dollar. Do you understand, sir? You cannot go to the Family Dollar? I can't hear you.
He said yes.
Yes, ma'am, I understand.
Okay, state?
The state would just request standard bond 2,500.
I don't have no money to pay your bond. I don't have no money to pay your
Judge, given his representation that he's not going to be able to afford bond, would you be willing to offer PTS or house arrest? He's got an address.
PTS.
Based on his prior several convictions,
I've been arrested over a year.
yeah. Oh, by the way, he doesn't qualify for pretrial services. He's a habitual offender and he's signal 100.
Okay. Would you entertain house arrest, Judge? He does have an address.
No, not at this time. Okay, the next case that I have is Eric Matthew. Eric Matthew Pawnee. Okay. Are you Eric?
Yes.
Okay, you've been charged with 3 counts. One count is tampering with physical evidence. The second count is controlled substance sale with possession with intent. And the third count is resisting officer without violence. I'm gonna read your A form to determine if there's probable cause. Okay,
The state requests standard bond 2,500 for count 1, 7,500 count 2, and 500 count 3.
One moment, Judge.
so count 2 for controlled substance sale, 7,500.
Yes, Your Honor.
The court finds probable cause on all 3 counts. What are? Only has 1 fire, right?
Yeah, the 2020 co-possession cell education held.
Judge, given the limited priors, I don't see any prior, I do see 1 prior conviction. Given the limited priors, I would just ask for a reduction of the bond.
Your Honor, the state would object when officers saw him handling packages with what appeared to be white powdered cocaine. They told him to exit. Upon that, he dumped it into a sink and proceeded to ignite the materials. Fire rescue had to come, smelled butane gas, had to utilize oxygen mask. This was, a very dangerous scene that could have put many people in serious danger of being harmed. This is also a location that has been involved in trafficking of crack cocaine and fentanyl. So the danger here in this case was extremely high, which is why the state would object to anything lower than standard bond in this case.
Okay, I agree. That is very severe. So I'm gonna do standard bond 2,500, 7,500, and 500. PC found on all counts. The next case I have is Harper Hollis Madison. There's no priors?
Your Honor, he has no local priors, but he has felony convictions from Arkansas, as Las Vegas and Georgia, as well as multiple failure to appears for his felony cases in Arkansas, which show that he is a substantial flight risk.
Okay. Are you Harper, sir?
Ma'am.
Okay, you've been charged with 1 count of cannabis sale with intent and another count of, second count is cannabis possession more than 20 grams. So I'm gonna read your A form to see if there's probable cause. Okay, finds probable cause on both counts.
The state would request an elevated bond of 5,000 on each count. Standard bond would be 2,500 on each count, but considering the defendant's extensive out-of-state priors from 3 different states and his failure to appear in those other states, it's imperative that we ensure that he appears for court to handle this case, and that's the reason for the elevated bond request.
Judge, I don't think that there's good cause to elevate bond in a case involving cannabis where over 50% of the state has voted to legalize it. Okay, he's not trafficking in cocaine or fentanyl here. What's more, if you set it at 10 grand total, he's not going to be able to bond out, which means that it's tantamount to no bond, which means that he's being held unconstitutionally. If bond is set at 5,000 total, that is a significant motivator for him to have to return to court, given what he'll owe if he doesn't. On top of potentially being held no bond.
Okay, I'm gonna issue count 1. I find probable cause. I'm gonna issue the standard run 2,500, and count 2. I find probable cause. I'm gonna issue the 2,500.
Thank you, Judge.
Thank you. Okay, the case I have is Logan Timothy.
Your Honor, he refused.
He refused. Are you waiving his?
That was Logan?
Logan Timothy.
Hold on, let me see if I can waive it. Hold on.
If not, we'll reset it, unless you want to wait. He's number 26, page 8.
Judge, we can waive.
Okay. He's charged with petty theft with prior convictions, trespassing property after warning. I'm gonna read the A form to determine probable cause. Okay, there's probable cause found in both counts.
Just asking for standard bond, Judge.
The state is also requesting standard bond.
So count 1 would be 2,500. And count 2 would be 500, correct?
Yes, Your Honor.
And what about with the stay away order, correct?
Yes, the stay away order from the marshals.
Okay. Huh?
That's okay.
Okay. Okay, so since you waived his present, he has to acknowledge a stay away order. So state recognize there won't be a stay away order.
That's fine. For the
Okay, so you want me to rip it up or? Okay, thank you. Sir, are you Thomas Darrell? Sir, oh, these are all the ones. Sir, are you Thomas Darrell?
Yes, ma'am.
Okay. There's 2 arrest forms here.
Do you have 2, Judge? I only have 1. I have case number ending 7600.
Your Honor, he also has a bench warrant. F24445.
I guess that was addressed at jail arraignments.
So this was the arrest warrant. It's for F 24445.
Oh, the case that was open?
And the bond set.
It was on yesterday, but they reset it because he refused.
That's the case number ending in 445?
445, yeah.
Okay, understood.
Okay. So he was charged with grand theft, third-degree vehicle, and driving while license was suspended knowingly. I'm gonna read the form for PC. Okay, the court finds probable cause for count 1 and probable cause for count 2. And he also has the felony arrest, grand theft, first degree, and that one's showing a $50,000 bond. State.
The state would request that the $50,000 warrant be converted into a bond. And the state would also request just the standard bond amount for the case ending in 7600, which would be 2,500 for the grand theft and I believe 500 for the driving with a suspended license.
Your Honor, the bond for the suspended license was addressed yesterday.
Oh,
And it was set at 150.
okay. Okay, so we're just dealing with the grand theft, which is 2,500. PC was found. So count 1 would be 2,500. And then in terms of the bench warrant, it's set here. And there's also a stay away order from Kanita Dones. Sorry if I cannot pronounce that incorrectly. You're to have no contact directly or indirectly in person in writing by telephone, audio. You're supposed to stay 500 feet from the victim at all times, from her house, from her employment or school. Do you understand that, sir?
Do you understand the stay away order?
Yes.
Okay, and now let's go ahead and address the warrant. This is F 24445.
Yes, Your Honor.
And this is for grand theft in the first degree, and it's showing a bond amount of 50,000. State, or you already said you wanted to?
Actually, Your Honor, the state would just be requesting a felony hold on that case since this warrant was issued in January. So he violated his pretrial release by picking up this new crime that he picked up on the 17th. So they would just need to address bond again in that felony.
Yeah. Okay.
You can speak.
Okay.
Okay. Then in that case, I would just request that the warrant amount be converted to a bond.
Which is 50, correct? Oh, it says here 50,000. What it? Yeah, and it says, yep. I don't know. There was what? I'm sorry.
The rest, first degree.
Okay. No, yeah, I believe it. So this isn't. Yeah, this isn't.
So you either
Yeah.
put up or you put.
Okay. Do you have anything to say?
I wasn't quite sure what the outcome of the 24 case was.
The
What are we
F-24
doing?
case?
Yeah, with the arrest warrant, what are we doing? Bond amount?
So the state wants to convert I'm gonna go ahead with the standard bond amount for first degree, for grand theft first degree.
On the new case.
On the case of F 24445.
Okay.
And clerk, you said it was 10,000? 15,000? And the standard bond on that is 15,000.
Okay.
So like,
Your Honor, you're saying that the new bond is gonna be $15,000?
yes.
You're lowering the bond, Your Honor?
Well, based on the bond, can I look at the paper a second? Let's see. Based on this, first degree felony, it says, and state, correct me if I'm wrong, is first degree felony standard bond 15,000?
Yes, I believe so.
Yeah, so first degree felony, which is grand theft, standard bond is 15,000. So I'm gonna go ahead and do it for 15,000. Like, let's cross out there. Okay, thank you. The next case I have is Diaz. Renee.
Wait, Your Honor, so that was only for one of the cases, the one with the warrant? Or the other ones that you addressed yesterday?
The standard.
Oh,
bond.
sorry.
Are you Mr. Diaz?
Yes, Judge.
Do you need a Spanish interpreter? Or
Speak English.
okay, you're charged with one count of false imprisonment and one count of battery. I'm going to read your arrest form to determine if there's probable cause. Okay, the court finds probable cause on the false imprisonment and on battery. And there's a domestic violence stay away, sir, against Angela Diaz. See, are you requesting the standard bond 25 and 1,000?
Yes, Your Honor. And 1,000 battery.
So 20 on count one, 2,500. PC found, count two, 1,000. PC found. And with a domestic violence stay away order. Sir, you are not to engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry any firearm. If you have any firearms, you must surrender them immediately or conceal weapons to the police department. You are prohibited to have any direct or indirect contact with Angela Diaz. Not in writing, no text. You must stay at least 500 feet from the victim, place of employment, house, school at all times. Did you and the victim reside together?
Then
Wait, they're husband and wife, correct?
Judge, I really don't want him to comment on the facts of the case, and
Okay.
it could be a fact relevant to the case.
Okay, no, that's fine. Okay, you are able to return to the victim's residence only one time within 48 hours with a police officer to get to retrieve your personal clothing, personal health items, medication, any documents, but you're not to go back to the property located at 4263 Southwest 161 Street, Miami, Florida 33185.
To what?
You understand? Yeah, I understand that.
Okay, thank you, sir. And then standard bond, 2,500, count one, 1,000, count two. The next case I have is Edwards Calvin. Are you Mr. Edwards?
Morning, good afternoon.
Good afternoon. Are you Mr. Edwards?
Yes, ma'am.
Okay, you're charged with 4 counts. The first count is controlled substance possession. The second count is controlled substance possession, GHP. Third count is drug paraphernalia, possession with intent to use. And the fourth count is loitering or prowler. Okay, I'm going to read the rest affidavit to determine if there's probable cause. Loitering or prowler. Okay.
The state would just request standard bond for each count.
And Judge, we are just requesting a reduction in the standard, reduction by 1,000 on counts, each of counts 1 and 2. He's not going to be able to afford more than that. He doesn't have significant priors. I think the last prior was over 10 years ago. And also the allegations in their arrest affidavit, if true, sound as if somebody is maybe impaired, intoxicated. It's not a serious crime. He's endangering himself more than anyone. And so given the allegations, given that it didn't involve anybody hurting anybody except himself, and the fact that he would not be able to afford anything more than $300 to bond out, I'm asking for a $2,000 total reduction.
I'm going to give count 1, 1,500. Count 2, 1,500. Count 3, 500. And count 4, 150.
Thank you, Judge.
And PC found on all 4. Okay, the next case that I have is, thank you. Is Mr. Smith.
This is Mr. Smith.
Okay, Mr. Smith, you're charged with 1 count of cannabis to sell, and you're charged with grand theft with the 3rd degree with a firearm. I'm going to read your arrest affidavit for probable cause. State, I find probable cause on count 1 and probable cause on count 2.
Judge, I apologize. I did just want to mention, count 1, it seems is charged as an F2. I'm not sure why. There's a note there that it's enhanced for, I guess, the allegation that he was armed.
Yes.
There's no enhancement in the statute for like an armed possession with intent to sell. So I think at most that should be charged as a 3rd degree felony, which involves a bond reduction. As to count 2, he is alleged to be in possession of a stolen firearm, but there's no allegation that he stole it. So like in the jury instructions for grand theft, if the state alleges that somebody was in possession of a stolen item like the day after it was stolen, we can presume that the person who was in possession was the person who stole it. There's no such allegation in the 4 corners of this arrest affidavit, just that he was in possession of stolen property. And so I'd ask you to find no probable cause on count 2 and release him outright on that charge.
Okay.
Your Honor, for count grand theft of the firearm was reported stolen out of the Pembroke Park Police Department. The fact that he was in possession of a firearm stolen, not just a stolen firearm, but a firearm stolen from the police, is a serious allegation, and there's probable cause to believe that he stole it since he had it. Whether or not, he did steal it is more of a trial issue. And then as to what? Sorry, one thing.
Yeah, the other thing state was that count 1 seems to be charged as an F2, but I don't know why. I think it's just an F3.
Because it was armed. Like
Yeah, there's just nothing in the statute that says that's how it's charged. If you look at 1A2. And Judge, if I could just well, State is looking into that. If I could just address count 2 in response to State's arguments. The
I'm gonna
elements.
pull up the statute for the. You could go proceed and talk, but I'm gonna pull up the statute for that.
Sure. So for the grand theft, Judge, is what you're pulling it up?
Yeah, to see, you're saying that it should not be an F2 just because there's a firearm.
Oh, as to the possession with intent. Yeah, I don't see anything in the statute related to enhancements for it being armed. Now, as to count 2, the state said that, the specific allegation about whether he stole it is an issue for trial. No, all of the elements of the charge are at play in PC hearings. And so in order for there to be probable cause, all of the elements have to be alleged within the 4 corners of the A form. And there's no allegation that he had anything to do with stealing the firearm. And so what we could be charging is being in possession of a stolen firearm, which is not what he's charged with. Sorry, we're having trouble hearing her on this side.
Okay, we can't hear, can you speak for me?
I agree with defense on count 1. I'm not seeing anything about firearms or being armed, at least not in this statute charge. But I do think there is probable cause for possession with intent to sell because of the black scale that he was concealing along the bags. For count 2, I would still argue that being in possession of a firearm stolen from the police, there is probable cause to believe that he was the one that stole it.
So Judge, I'd like to correct my argument. I do see that a simple possession with intent to sell, I think is correctly charged as an F2. So I'm sorry for wasting everybody's time. I'm saying that now in the statutory language. I would just maintain my argument as to count 2. There has to be an allegation that he had something to do with stealing it.
Okay, so what is the standard bond for count 1?
For count 1?
Yeah.
It's since it's a secondary felony, it's 7,500.
And count 2 is 2,500, correct?
Judge, one moment.
This he's found on both. I'm gonna do count 1, 7,500, count 2,
Judge, I'm
2,500.
sorry. So Judge, no, I'm sorry. If you go to section 1 alpha 2, which is the section he's charged with, what that says is that possession with intent of a controlled substance under 893.031C is charged as a 3rd degree. So cannabis is under that section. And so possession of cannabis with intent to sell is properly charged as an F3. So he cited the correct section, just upcharged it for a reason that's not apparent to me.
Sorry, one more.
And I can't hear the prosecutor.
I agree with the PD on this. It would be an F3.
So F3 as to count 1, and what is your decision on count 2, Judge, the grand theft?
So what is the standard bond for an F3? Okay, so it's 2,000, not 75, so count 1 would be 2,500, and I agree with the PD on this one. It's an F3, so 2,500. And then count 2 will be the 2,500. The next case that I have is Stephen Lediahome. I'm sorry if I pronounced it incorrectly. Are you Stephen, sir?
Yes.
You've been charged with 1 count of false imprisonment. I'm going to read your arrest affidavit to determine if there's probable cause. Okay, the court finds probable cause for false imprisonment.
The state would request the standard bond for third-degree felony with force or threat of force, since the defendant threatened to strike the victim if she attempted to leave, which would be $5,000. Additionally, although the domestic violence indicator was not checked off on the arrest form, the state is requesting a domestic violence stay-away order, since the defendant and victim aren't new to each other and have been in an on and off again relationship for 4 years, and even on the date of incident were intimate.
Hence,
Judge, we're asking for you to maintain the standard bond at 2,500. He's informed me that 2,500 is going to be very difficult. 5,000 is going to be impossible. It's going to be tantamount to no bond.
I'm going to issue the stay away order because they were in a relationship. So even though domestic violence box wasn't checked off, I'm going to issue it. Sir, you're not to engage in any criminal activity. Do not use or possess any illegal drugs. If you have any firearms, you must surrender them to the nearest police department immediately. You're to have no contact with Kira Williams. Indirectly, directly, no, not through emails, texts. Do you understand that, sir?
Yes.
You're to stay 500 feet away from her at all times. Do you have any belongings at her residence? Did you guys,
I don't know that.
okay, well, it doesn't matter. I'm gonna put here, I'm gonna allow you within 48 hours to go back to the victim's residence with the police officers if you have any personal belongings to get with the police officer one time in 48 hours, in case you do have any personal belongings.
Okay.
And you have no communications via text. You understand?
Yes.
With the victim? Okay.
Judge, are you maintaining the bond at 2,500 or are you elevating it? If you need additional argument in support of keeping it at 2,500, I'd only say what we have in the 4 corners of the arrest affidavit are 2 conflicting statements without any independent evidence breaking the tie here. And so you're permitted to use the facts and circumstances of the allegations.
Bond at 2,500.
Thank you, Judge.
Okay, the next case that I have is Mike Karama, sorry. Hence, not speaking Spanish. And there's two cases here.
Yes, Judge.
Okay, the first case I'm gonna address is F26007642, and that's petty theft, and there's prior convictions. I'm gonna read the rest affidavit, determine probable cause. And there are convictions regarding the same, just this past, just to let you know, there was a conviction on this just last year for petty theft. Let me see. Okay. The court finds probable cause for count one. I mean, not for count one, for the case ending in 7642. I'm gonna grant standard bond of 2,500. And now let me read the next one, which is F26007625. Again, this petty theft conviction. Let me read the form to determine if there's probable cause. Again, I find probable cause. State standard, you're requesting standard bond?
Yes.
Okay, and then the case ending in 7625, standard bond 2,500. I'm not gonna go down on bond based on the prior convictions, and I didn't go up, so I'm keeping it the standard bond instead of. Thank you. Oh, and there is a stay away order from. You're to stay away from the public, sir, located at 15750 Southwest 72nd Street, Miami, Florida 33193. You understand?
Yes, ma'am.
Okay, thank you.
All right, thank you.
Good. No, I'm just wondering if any. Like, I get through. Okay, the next case that I have is Hensley.
Hello, good afternoon.
Hello. You have been charged with 1 count of burglary of an occupied dwelling and criminal mischief. I'm gonna read your arrest affidavit to determine if there's probable cause. And there's no priors in this?
Your Honor, does he need the Spanish language interpreter?
He does not need an
Okay,
interpreter.
all right, thank you.
The court finds probable cause for burglary of an occupied dwelling and criminal mischief. State,
This just requests the standard bond for both counts.
what is the standard bond on burglary?
Judge, I
For
apologize.
the burglary, it's a second degree felony, so it would be 7,500.
Judge, I apologize. Can I make a PC argument? I'm sorry for the late PC argument. My only question for Your Honor is, burglary requires an allegation of an intent to commit a crime therein. So what is the intent that is alleged within the four corners of the A form? And that's something that even has to be specified within the charging document. So it has to say burglary with intent to commit petty theft or burglary with intent to batter or something. There's no allegation. The other crime that took place was not the intent, was not the crime he intended once he trespassed. It was in furtherance of the trespass. But however,
Your Honor, the state agrees with this.
And so, Judge, I would argue that the bond on count one should just be the standard bond for trespass of a dwelling or structure, which is a first degree misdemeanor.
And so your PC argument is that it's not alleged? That he was gonna commit a crime within?
Yes, there has to be an allegation of an intention to commit a crime after he got into wherever the trespass was going to happen. It's trespass plus intention to commit the crime, which can be evidenced through actually committing the crime or some other allegation of intent.
Yeah, okay, I agree with the PD on this one. So that would be, there's gonna be a stay away order. So what's the standard bond then on that one? The misdemeanor?
500.
500, and then the second one is 500, correct?
Yes, Your Honor.
Okay, so count one is 500. Count two is 500. PC found on both. And sir, there's gonna be a stay away order from MB. Date of birth is February 8th, 1967. You were to stay away directly, indirectly, in person, writing, text messages. You're to stay 500 feet from the victim's home, place of employment, or school. Do you understand?
No problem, that's perfectly fine.
And in addition, you are to stay away from this address, 2325 Northeast 42nd Circle, Homestead, Florida, 33033. You understand?
Yes.
Okay, thank you. Hey, are you Tinoco Gustavo?
No, Judge, bond's out.
Huh?
Tinoco is a bond out, 34.
Thank you. So is this
35 Hatcher is also a bond out.
Hatcher's a bond out?
Yeah. And then the next one in 36 for Hanno is also a bond out.
So then there's no stay. What times? 30. Jonathan, no, Hatcher 35 is a bond out?
Yes. No, Hatcher 36 bond out. No, excuse me, Hatcher 35 bond out, Verhano 36 bond out.
So right now, who is in front of you now?
This is Mr. Alvarez, first name Angel, number 37.
Does he need a Spanish interpreter?
Yes, ma'am.
Okay, Madam Interpreter.
Interpreter is present, Your Honor.
You're Angel Alvarez, correct?
Usted es Ángela Álvarez, ¿correcto?
Sí.
Yes.
Okay, this is case number F26007646. You have been charged with aggravated battery. I'm going to read your arrest form, determine if there's probable cause.
Bien, señor, estamos en su caso F26007646, agresión física con agravantes. Voy a leer el formulario de arresto para determinar motivo fundado.
Okay, the court finds PC for aggravated battery.
La Corte encuentra motivo fundado para agresión física con agravantes.
State,
The state requests 7,000. The state requests the standard bond 7,500.
and that's a standard bond for aggravated, right?
Yes, Your Honor. And
The reason it's aggravated because it says here
pregnant.
and the victim is also pregnant with the defendant's child, which makes it aggravated. Yeah.
Yeah, and then the state would also request the domestic violence stay away order.
Yes, and so the aggravated is 7,500.
Yes, Your Honor.
Okay, I'm granting a find probable cause and granting bond of 7,500. PC's found and it's aggravated. She was pregnant, so that's a very serious offense. And I'm issuing a domestic stay away order. You are not to engage in any criminal activity, use any illegal drugs. Do not purchase any possessed firearms. If you have any, you must return them to the police immediately. So, sorry, interpreter. I'm so sorry.
That's okay, Your Honor. Thank you.
You want me to go back? You want me to go back for you?
No, thank you. I took notes. Bien, señor, encuentra motivo fundado para una agresión física con agravantes, debido a que la víctima es una mujer que está embarazada. Es un delito muy grave y se está emitiendo una orden de alejamiento por violencia doméstica. Usted no puede participar en ninguna actividad criminal, no puede usar ni tener drogas o sustancias ilícitas, no puede tener, usar, ni comprar ni portar armas de fuego ni munición. Si usted tiene alguna arma de fuego, munición, tiene que entregarlas inmediatamente a la estación de policía más cercana.
You are to have no contact with the victim, Maria Rodriguez, directly, indirectly, through a third party, no social media. You are to stay 500 feet from the victim's home, victim's place of employment, schools at all times. You can go with a police officer one time within 48 hours to get anything from the victim's home, like your personal belongings, health, but you are not to go back to the residence. Do you understand, sir?
Bien, usted tiene una orden de alejamiento que le prohíbe acercarse a María Rodríguez. Debe de permanecer a 500 pies de distancia de ella, de donde ella viva, donde trabaje, donde vaya a la escuela, donde quiera que ella se encuentre, usted debe de estar alejado. Podrá ir a la residencia a recoger sus pertenencias personales en 48 horas después de ser liberado, mas tiene que ir acompañado de la policía. Si usted se llega a presentar ahí sin la policía, será arrestado. ¿Entiende la orden de alejamiento?
Sí, entiendo.
I understand, yes.
All right, thank you.
Gracias.
The next case I have is Jackson Mount.
Jackson.
This is Mr. Jackson.
Okay, you're being charged with one count of robbery, strong arm. I'm gonna read your arrest affidavit to determine if there's probable cause.
Judge, I am going to have a PC argument on this one.
Okay, and is there priors on this one?
Yes, they're from Huron County, 2010 withholding adjudication for trespassing, 2010 withhold of adjudication for battery, burglary 2014, and grand theft of firearm 2014.
What's your PC argument?
Judge, so F2 strong arm robbery requires a specific allegation of force or violence in addition to what is used in order to grab the item. So I think strong arm robbery is a little much for the allegations here. If it's properly charged as anything, it's charged as a sudden snatch robbery, which is an F3.
Your Honor, I agree.
Yeah, I
robbery
agree.
by sudden snatch, third-degree felony.
Yeah, I was gonna, she didn't need to argue.
I would also additionally ask Judge, so Mr. Jackson has informed me that he doesn't live in Miami. He lives in Tallahassee. He's employed. He wants to resolve this case. His concern is that he's not sure how he's going to pay bond, given that he doesn't have anybody who can call a bondsman. All of his items are on property. Given the allegations of this case, the allegations aren't serious. It started with a fight in which the alleged victim dumped water on him. He's not alleged to have done anything to her other than just grab the phone. I'm asking for an ROR in this case, Judge. He says he has to be at work back in Tallahassee this week. I think this is somebody who's tomorrow, excuse me. I think this is somebody who's gonna keep up with his court dates and resolve this case.
How long have you been in Miami for?
Thursday.
State?
Your Honor, since he does not live locally, some form of bond is required to ensure he will return to Miami if needed. So the state would just request standard bond for third degree felony, which would be $2,500.
Judge, I would just mention that ROR is a bond. It's called a recognizance bond, meaning that he has to comply with conditions of pretrial release, which includes showing back up at court. And if he does not, he risks being held no bond. That's risking a lot to not come back to court. And so I would argue that a recognizance bond is sufficient in order to motivate his return to court.
And Your Honor, it's not like he has,
I mean, it says here on Tuesday, the victim and the defendant were involved after the victim poured a cup of unknown liquid on the defendant as he was sleeping. That seems, based on that, that seems like the victim is the one who initially was the aggressor in this instance. Then he became destroyed property, and then he tried to get the cell phone.
Yes, Your Honor, but he still grabbed the victim's phone from her, deprived her of it, and was still in possession of it when the police arrived at the scene.
I was in. Hold on. Judge, I would just reiterate that a recognizance bond is a bond, and the motivator to return to court is that if he does not, the division judge could issue an alias capias, which means he would be held in Tallahassee, no bond until he came back to Miami-Dade. He'd be held there as many as 30 days. I mean, that's a huge motivator, and this is somebody who needs to get back to work tomorrow.
And he has no priors?
He has no local priors, but he has priors from Leon County, trespassing, battery, burglary, and firearm. So he has criminal history, just not locally.
But are they convictions?
Withhold of adjudication, for the trespassing, withhold of adjudication for the battery, and conviction for burglary, conviction for theft of firearm.
What year were those?
The theft of firearm, 2014, burglary, 2014, the battery withhold was 2010, trespassing withhold 2010.
Okay, so over 10 years ago now. I think a recognizance bond and the threat of being held in Tallahassee, no bond, if there's an alias capias issued, is a motivator here. I'm asking for ROR. He may not get out if we don't issue it. In a case which very well may end up being a no action.
Yeah, I'm gonna actually RO her. Like he grabbed the phone from her, but he got water poured on him. He could have, like he was asleep, which. Yeah, I will RR him.
Okay, so it's PC as
There is
to a third degree.
There is probable cause. He snatched it from her.
Okay, so PC as to F3 and then ROR. Thank you, Judge.
But there is PC found, but okay. Okay.
Your Honor, is there going to be a stay away order?
Says they're currently living together. Based on the facts, I could do a stay away order. I'm gonna modify it. You can have contact with the victim, but it must be, you're prohibited from physically threatening or violating the victim in any manner whatsoever. Do you understand, sir? Okay, you're not to engage in any criminal activity, any illegal drugs. If you possess any firearms, you must surrender them. You understand? I know you guys don't live here, so you can have contact, just no physical based on these allegations. Do you understand? Okay, thank you. You guys know. I'm gonna take a break for like 1 or 2 minutes, okay? Thank you. Okay. I'm back. So the next case I have is Morris.
Morris is a bond out, 39 is a bond out.
I'm sorry?
39, Morris is a bond out.
Okay. Okay, the next one that I have is, sorry if I pronounce this incorrect, Carlos Manuel. I don't know how to,
Reset NBC.
are you waiving his presence?
Judge, I'd like, reset is fine.
Okay. Will be reset for tomorrow?
Yes, please.
Okay, reset for 420. The next one that I have is Hollywood.
NBC, Your Honor.
Are you waiving his presence?
Corrections, do you have any other holds for 41?
He's a fugitive from Broward.
So Judge, I can waive and we can address.
And he's fugitive from Broward. Okay, he's charged with burglary of an occupied dwelling. I'm gonna read his affidavit to determine if there's probable cause.
And Judge, just to give you a heads up, I would make the same argument as it relates to intention to commit crime therein.
Your Honor, I agree.
Yeah, so it will be 2,500, correct? Is that the standard?
No, it would be 500 if it's for the first degree misdemeanor.
Yeah, for trespassing, it'd be 500.
Okay, sorry. Okay, 500. And there's also the fugitive,
Yeah, he's held, so yeah.
And I think that did a stay away order for the residents.
but if he's not here,
Oh, right.
I can't do a stay away. The next one I have is Davis, Jeffrey.
NBC, Your Honor.
Are you gonna waive his presence or?
No,
reset?
ma'am, asking for a reset.
Okay. It'll be reset for tomorrow. We do want to keep this for that. Okay. The next one that I have is Angel Cabrera. It's number
NBC, Your Honor.
Requesting a reset, Judge.
reset. You're not going to waive his presence?
No, Judge.
Okay. It'll be reset. NBC and it's set. It will be set for tomorrow, 420. Okay. The next one I have is John Collins.
NBC, Your Honor.
Requesting a reset.
You're gonna reset or waive his presence?
I'm gonna request a reset.
Okay, I'll grant the reset. Will be reset for tomorrow for 20. I'm gonna keep all the stayaways that you issued with it, with these solo helping. Do you want the priors too for these? So they can, so the next one that I have here is, I believe, is 46. Greg's Curtis also has a hold in Division 19.
NBC, Your Honor.
And Judge will waive his presence.
Okay. So there's a hold in F261961. And there's a hold in F261970. I'm gonna take care of the first case first. There's two A forms. The first one is F26007598. He's been charged with retail theft and he has prior convictions.
And I do have a PC argument, Judge, when you're ready.
You have a PC argument?
Yes, ma'am.
What's your basic argument?
Judge, an F2 retail theft requires a repeat offense at the same store within 120 days. So what we have here is just an F3. An F3 for both the value and prior theft. But the retail theft would require another incident being alleged at the same store.
You're saying it's not an F2 because of that. It's not a prior incident at the store.
Right. It's just a grand theft or otherwise a petty theft prior conviction.
But he does have priors for petty theft.
Yeah, and that would be an F3 if it were charged appropriately. So if it said that, what is this store called? If it's
Lowe's.
if he went to the Lowe's twice within 120 days, that's the F2 retail theft. If it's just the amount, the 3,200 stolen from Lowe's once, that's grand theft, which is an F3.
That's under 9 subsection A, right? That. Hold on, let me see. Hold on, let me make sure there's other. I just not to. No, I believe you're right. Actually,
Okay. So PC for F3, not F2.
PC. I state. Do you have any objection?
No, Your Honor. I'm just for PC for F3. Petty theft with prior convictions.
That's correct, Judge. Or grand theft. They're both F3.
Yeah. And what's the bond on that?
I think it's 2,500.
Yeah, 25.
Okay. So I'm not gonna go lower on that because of his prior convictions, but I agree with your argument. There's a public cost for that. Now, the next one is, and plus he also has, we discussed the felony holds. The next one is F260075590, robbery, strong arm, and battery.
No PC argument.
The state would just request the standard bond and the domestic violence stay away order.
But with his waiving his presence.
Oh, right.
I can't.
Presence waive. Oh, understood.
I don't think I'm not allowed to do the stay away order, if he's not present.
For the domestic violence case, would it be possible then to reset it? Because if it wasn't domestic violence, I wouldn't make a big deal, but it's really important that he's colloquied on the stay away order with the victim.
Okay, reset.
I agree, because it's domestic violence, and
Okay.
these are serious allegations. So we'll reset the. We'll just, okay, we'll reset,
Reset everything, Judge. It's fine
okay.
if it's easier.
So we'll reset everything. So reset for, tomorrow or? Okay. Yeah, I agree, because on a DV, otherwise it's petty theft, but a DV, yeah. Okay, the next case I have is Davis Allen.
Your Honor, the state has a motion for child detention for this.
And hold on. Yeah, okay. Reset, please.
Oh. Are you gonna waive his presence?
No, ma'am.
He's not gonna. Yeah. I'm sorry? Reset it. Yeah. Okay, so this will. We're gonna reset this for. And along with that, I'm just making the note for the case F26007-607, the state does have a pretrial detention motion, which will be addressed tomorrow. The next one that I have is George, Jimenez.
Refuse, Your Honor.
You gonna waive his presence?
Yes, Judge.
Yeah. I'm sorry?
Yes. Waiving his presence.
Okay. So
And I have no PC arguments.
there's 5 cases. So the first case is F26007529, and he's charged with cocaine sale from 1,000 feet from a school, cocaine possession from 1,000 feet of a school, communication device unlawful use. There's actually 3 counts. And so that's the first charge, there's 3. And I find probable cause on all 3.
Your Honor, just to notify the court, he does have a hold for immigration, and these charges have a hold for magistrate and for.
Oh, yeah. For magistrate, yeah, he has a hold, also nice hold.
And a Nebbia, Your Honor.
I'm sorry?
And a hold for Nebbia.
Oh, and a hold for Nebi. So you're gonna do the standard? You want the standard? What's the standard on the cocaine cell within the school?
That's a first degree felony, 15,000.
Yeah. That's, it says to do it around the school. So 15,000 in count 1, easy found, count 2, 2,500, and count 3, 2,500. Okay, that's the first case. The second case that I have, for George Jimenez is F26007527. He's charged here again, cocaine, there's cocaine cell with intent, 1,000 feet of the school, cocaine, cell with intent, and then communication device and lawful use, and it's also a hold for the magistrate. Yeah. So again, these are the when did so yeah, all of these are the same alleged crime, they're all occurring the same. Like there's 5 arrests, but they're all for
They are all the same allegations on different dates, Judge.
but it's the same day, 5 different.
If the one we just did was December 3rd, the one we're on now is a different date, January 14th.
Oh, yeah, I see that, okay. So, it's 15 for, it'd be the same, right? 15 for count 1. Count 2, 2,500. Count 3, 2,500. And there's also the ISO PC. Okay, the next one is the same thing, cocaine cell. Sorry, this is case number F26007526. And this is cocaine cell, again, 1,000 feet from a school, cocaine possession, 1,000 feet of the school, communication device unlawful. I find probable cause. And there's an ICE hold. So I'll do the same standard on 15,000, count 1, count 2, 2,500, count 3.
What case number is this on?
Oh, sorry, this is case F26007526. Okay, this is, now we're in case number F26007525. This is again the same.
Can you repeat the bond for 7526?
Yes, it's the same on all 15,000, 2,500, 2,500.
Your the case has 5 counts.
I'm sorry?
So Judge, on case number ending in 26, the first 2 counts were first degree felonies. Are you setting both of those at 15,000?
Yeah, they should both be at 15. So it should be count 1, 15, count 2, 15.
And then count 3 through 5, 2,500 each.
Yep. So 15 for count 2, and then count 3, 4, and 5, 2,500. The next one is F26007525. Count 1 is cocaine sell 1,000 feet from the school. Count 2, possession within 1,000 feet of a school. Communication. Count 3 is communication unlawful device. I find probable cause, and I am going to do the same as I did in the previous cases. And there's ice holds on all these. Count 1 will be the 15,000. Count 2 on this one is 2,500. And count 3 is 2,500. That's what they had told me. Right, corrections? You said he had an ice hold?
Yes, Your Honor.
Yes, there's an ice hold. Okay. Okay, and the last one is F26007524. And this is, again, cocaine sell within 1,000 feet of a school, cocaine possession with intent, communication device unlawful. And so I find probable cause on all 3 counts. I'm going to do the same as I did in all previous cases. Standard bond is count 1 is 15,000. PC found. Count 2 is 2,500. And count 3 is 2,500.
Your Honor, are all these bonds plus Nebula?
Yes. And there's the ice hold. Thank you. So the next list that I have is Enrique Brown.
Your Honor, he refused.
Waive his presence.
He's charged with burglary of an occupied dwelling. And this says it was an added charge. I'm gonna go ahead and read the rest of it to determine if there's probable cause.
And Judge just would direct your attention to the requirement for an allegation of intent to commit a crime therein.
Okay. You have a PC argument?
Just the same argument as I made in the other cases that I don't see any allegation of an intent to commit a crime therein. The facts are a little different than those previous cases. But just directing your attention to that, he's got the felony hold anyway, so it doesn't make a lot of practical difference for him.
I agree with the, do you guys have any objection?
Your Honor, I would argue that this case is different because the defendant was not alone. He was with 2 other males attempting to pick the lock on the door. And when they saw the resident, the victim inside, Mr. Mutia, they ran back to their car and fled the scene. I feel like this showed more of evidence that they were trying to commit a crime therein. If not, they would have acted this way before and after the victim saw them.
You want to respond?
No, Judge.
It was also at 3:29 a.m.
Yeah. At 3:29. Yeah, I'm gonna have to agree. What's the standard bond amount?
So it would be a third-degree felony, which would be 2,500.
Okay. Easy fine, I'm gonna do the standard 2,500. And, well, obviously, he's not here, he waived his presence, so I can't do the stay away orders. Is that correct? You have to be present.
Yes, Your Honor.
Your Honor, what the bond?
2,500.
Thank you, Your Honor.
Welcome. The next case I have is Kenner Torres. Reese.
Refuse, Your Honor.
Judge, I'm not waiving on this one. Request a reset.
Okay. So you're not gonna waive?
No, ma'am.
Be reset. 420.
And Your Honor, this defendant also has a hold for immigration.
Oh, and there's a hold for immigration. The next one that I have is Jose Antonio, 51,
Refuse, Your Honor.
and you wanna waive his presence?
Yes.
Okay, he's on house arrest for F-26-3081 and F-26-6830 in Division 3 in front of Judge Gonzalez. Okay, he's alleged with grand theft vehicle and second, he's alleged with hired vehicle failed to redeliver. I'm gonna look at the arrest to determine if there's probable cause.
No PC argument from defense.
Okay, so there's probable cause found in count 1 and probable in count 2, and there's also the felony holds. What's the standard bond for the grand theft?
That would be 7,500.
And then 2,500, correct?
Yes.
Okay, so count 1, 7,500, PC found, and count 2 is 2,500. The next one I have is Jonathan Allen Reyes.
He's not here. Waive presence.
Your Honor, he refused.
And
No
this is-
PC arguments from
No.
defense.
This is F-26007495. He charged with battery by detainee or visitor of the detainee. I find probable cause for count 1, and that is
The state would request the standard bond $1,000
for that one. That's 1,000 is the standard.
for battery.
Okay. So I will do the standard bond of 1,000. Probable cause. The next one that I have is Andres Miguel Gabriel, 53.
He's not here.
Refused, Your Honor.
And I request a reset.
Okay, I will grant the reset. It will be tomorrow. Have any objection, state?
No objection.
And you're not waiving the appearance, right?
I'm not.
We'll reset till tomorrow, 4:20. That goes to Patty Casey. The next one I have is Ines Florentino. Sorry if I pronounced it incorrectly.
Florentino?
Yeah, Florentino. It's on 54 on page 17.
He refused, Your Honor.
Waive presence.
Okay. He is,
No PC arguments.
okay, and he's charged with, this is case F26007635. He's charged with battery by detainee, a visitor. There's no PC arguments.
Just asking for the standard bond. Your Honor.
Okay. If I'm PC, we'll do the standard bond of $1,000. The next case I have is Metavas Dukes.
Refused, Your Honor.
Waive presence.
Okay.
No PC argument.
And this is case F26007535. He's charged with battery by detainee. I'm gonna review to make sure there's probable cause. Yep, I find probable cause.
They just press the standard have.
Yes, I'm gonna grant the standard $1,000 on probable cause found. Okay. The next one that I have is Tristan Colby.
Refused, Your Honor.
Waive presence.
Okay. He refused, they're gonna waive his presence. He's charged with battery by detainee or visitor. I'm gonna read it before we determine if there's PC.
No PC argument from defense.
Okay. State.
They request $1,000.
And find probable cause, and we'll do the standard bond of $1,000. The next one I have is Robert Watkins.
Refused, Your Honor.
Waive presence.
He's charged with grand theft in the 3rd degree. I'm gonna review the form to determine that there's probable cause.
No PC argument from defense.
What is it? I'm sorry. He has a lot of priors. You guys going with the standard on $1,000?
Yes, Your Honor.
What? That's 2,500.
Yes.
Okay. PC's found 2,500. The next one I have is Jonathan, it's 58, Jonathan Perlos, yes. I'm sorry, I cannot pronounce.
Refused, Your Honor.
Pierre Lewis. Gonna waive his presence?
Yes, ma'am.
Okay.
No
He is-
PC argument from defense.
He's charged with battery by detainee or visitor. Defense has no PC argument. You requesting standard?
Yes, Your Honor.
Okay, $1,000 standard bond. Okay. The next one I have is Carmelo McGraw.
Refused, Your Honor. Waive presence.
Okay. He charged with battery by detainee, a visitor.
No PC argument from defense.
Okay, and there's two different cases, so I'm gonna go with the first case is F 2600763. State, $1,000 standard bond.
Yes, Your Honor.
Okay, probable cause found. Defense has no objection. PC, $1,000 standard bond. And for case ending in F.
Well, I phrase it as I stand mute on PC, not that I don't have an objection to it. Not that it matters for, practically speaking, for this case, just letting you know.
I understand. Thank you. The second case number for this is F 2600767, and he's charged with the same crime and battery by detainee. The court finds PC.
State order plus the standard.
We're gonna do, I'll grant the standard $1,000 bond, PC found.
Your Honor, that's for both.
I can't hear you, I'm sorry.
Is that for both cases, Your Honor?
Yes. The standard 1,000 on both. And I believe that's it. Yeah, we're done. Thank you so much.
Recording stopped.
You too, take care. Yeah. This was one of